Good morning to our distinguished speakers and guests who are joining us both virtually and in person. Welcome to day 2 of the 3rd Incheon Law and Business Forum. I am Han-gyul Kim, legal expert at UNCITRAL RCAP, on secondment from the Minister of Justice, Republic of Korea. It is my great pleasure to return as one of your moderators for the forum today. We hope that those who attended yesterday's panels and events found them enriching. Today, we'll continue to explore the theme of this forum, from documents to data, legal and commercial solutions for digital trade. Participants will once more hear from representatives from the legal, business, and public sectors as we discuss the promotion of law reform and business development in support of digital trade across Asia and the Pacific. Today's program comprises 2 panels, Law Track 1, Trade in Data, and Law Track 2, Digital Trade Agreements, as well as a roundtable on digital trade law reform in Asia and the Pacific, and a lunch highlight on the environmental impact of paperless trade. Once more, we remind today's participants that this event is being recorded and will be posted on the UNCITRAL event webpage along with the presentation slides with the consent of the speakers in due course. The program and speaker bio notes can also be found on the webpage, and our event facilitators will be posting links to the relevant material, including UNCITRAL text, in the chat box throughout the event. We kindly request our panelists to remain muted with your cameras turned off unless you're speaking. At the end of each session, group photos will be taken for each panel. Virtual speakers, please turn on your cameras for the group photo. In-person participants viewing on their laptop should remain muted to avoid echoes. We once more welcome questions to our panelists via the Q&A box, which will be addressed during the Q&A session at the end of each panel. Speakers can also request the floor using raising your hand function on Zoom. Due to time limitations, panels may not be able to address all questions. If you have technical issues, please write in the Q&A box or email uncitral.rcap@gmail.com. Thank you. Without further ado, I am pleased to introduce Professor Kyoungjin Choi as the moderator for today's first panel discussion, which will be on the topic of trade in data. Professor Choi is the president of the Personal Information Protection Law Association and the Personal Information Experts Association. He also serves as a member of APEC's E-Commerce Business Alliance Expert Committee and is the head of the Gachon University International Exchange Office in the Artificial Intelligence Big Data Policy Research Center. Professor Choi, it is a pleasure to have you with us here today. I will now hand over to you to introduce our panelists.
Thank you. Good morning, everyone. I am so honored to moderate the first session of day 2 in this wonderful forum today. This forum consists of a 2-day program, and the day 2 program will begin with our Law Track 1. Law Track 1 has the theme Trade in Data and consists of total 5 speakers. In the original program, only Mr. Yong was listed from Shanghai Data Exchange, but one more speaker, Mr. Zihan, was added. I will introduce each of the speakers participating in Law Track 1 before each presentation. This session will be conducted first by listening to presentations from 5 speakers, followed by Q&A session as time allows. The speakers in this session have different professional background and are expected to demonstrate different legal approaches to trade in data. As the 2023 ILBF theme was from documents to data, data has now become a core necessity in international trade. With the advancement of artificial intelligence and IT technology, we can see that the higher the utilization of data, the higher the competitiveness in trading data. So now we will listen to 5 presentations on the legal approach to the international trade being changed based on data. For a Q&A session, I will announce the remaining time 2 minutes before the end of each presentation. The first speaker is Dr. Jacob Lee. He is a group leader, a logistics contract group of Samsung SDS Republic of Korea. The presentation time is 50 minutes. So please welcome Mr. Jacob Lee. Now you have the floor.
Good morning, everybody. Nice meeting you. I'm Jacob Lee, who is responsible for all the logistic service-related agreement in Samsung SDS. This morning, it is my honor to attend this wonderful forum first. And this morning, I will be presenting about the e-beatable rating. I believe you have a similar session yesterday, which is being discussed again, especially in ocean transportation market. And I'd like to briefly explain the current market situation by focusing on the platforms of e-beatable rating and the status of legislation on e-beatable rating in South Korea. First of all, I don't think you are familiar with the company of Samsung SDS. So let me give you a brief instruction on SDS. SDS means Samsung Data System. It is one of the subsidiary company of Samsung Group, which is engaged in IT business and the logistics business as well. Last year, SDS produced total revenue of $13.8 billion in 2022, with 23,000 employees working in 69 branch offices in 41 countries around the world. Of these, the logistics business, which I am a part of, had a revenue of $9 billion last year, with about 6,700 employees. And SDS assigns about 10,000 logistics service agreements a year. Next, I would like to talk about the market situation for the activation of e-beatable rating. I think you have a similar session yesterday as well. The global endeavor to apply e-beatable rating go back to 1971. It can be roughly divided into 3 stages. The first stage was from 1970 to 1990. And there was about 4 systems, including TFR in 1971. The second stage was from 1999 to 2010. And the system that appeared in the market during this period and are called the registry system, such as Bolero, which started in 1999 and still existed today, and ES stocks in 2003, but they are not very much successful in activating e-beatable rating. The third stage is from 2011 to the present. The platforms using cutting-edge NFT and blockchain technology are emerging. With the emergence of platforms such as Wave, TransLens, and CargoX, which utilize this cutting-edge technology, market participants seem to want to promote meaningful e-beatable rating activation during the third stage. The recent effort to promote e-beatable rating in international ocean shipping can be found by the Digital Container Shipping Association, I mean the DCSA, in which the CEOs of 9 global carriers have signed a pledge to realize and promote 100% e-beatable rating by 2030. In addition, the CEOs of DCSA estimate that the e-beatable rating will save approximately $6.5 billion in cost each year. Ocean shipping carriers have pointed out the lacks of technology, insufficient adoption, and legal invalidity as the main reason for the sluggish e-beatable rating realization rate of only 1.2% from the advent of Bolero in 1999 to the present. But this time, TCSA has established a Fit Alliance and is promoting the practical activation of e-variable lading in alliance with BIMCO, Piara, ICC, and SWIFT. So it is strongly expected that the market will change in the future. I'd like to see the recent major platform for e-variable lading. If we look at the platform currently appearing in the market, Bolero and ESS stocks, which are the product of a registry system in the past, and the Translens you are all know is about a blockchain-based platform that has been ambitiously developed by Maersk Line and IBM since 2018. In particular, Maersk Korea successfully completed a pilot test of e-variable lading for the automotive parts transported from Korea to the United States using blockchain technology last year. However, early this year, Maersk Line abruptly announced that they would discontinue the development of Translens. They say that the reasons for the discontinuance was that although there is still no technical problems in issuing the e-variable lading by applying the blockchain technology, the complexity of technology used and the risk caused by it became a burden in the end. The next platform is that the attracting attention is WaveBL. It is also a platform that uses blockchain technology and appeared on the market in 2015. And it is reported that the Gymline is investing in this platform. Currently, Wave is used by MSC, Gym, ONE, and Hapag-Lloyd among the major 10 members carrier in TCSA, while Maersk CMA and the HMM seems to be exploring their use. Lastly, IQAX eBay platform, also known as GSBN, which appears in 2022, is also based on blockchain, centered on Costco and invested by Cargo Smart and Bank of China. Next, I will simply review the process of issuing variable lading and delivering it to the consignee between the e-variable lading and the paper-based variable lading. The process on the screen is based on the process of SDS. In the process of screen, the blue-colored part from issuance of variable lading to container release is the main differences between the e-variable lading and paper-based variable ladings. First of all, at this shipping instruction stage, if a shipper selects the option of e-variable lading instead of paper original variable lading as bill type in the platform of e-variable lading, and at the BL issuance stage, if a shipper verifies the draft variable lading and the request to issue the e-variable lading, the carrier is also asked to issue the e-variable lading in the platform. One of the main differences is that in the case of a paper variable lading, shipper sends the paper variable lading to consignee through a courier. But in the case of e-variable lading, shipper sends the paper variable lading to consignee on the e-variable lading platform instead of courier. So on the e-variable lading is less likely to be lost or forged compared to paper variable lading. And for the cargo pickup by the consignee would have to go to the carrier's office to return the paper variable lading and pick up the cargo. But by issuing an e-variable lading, the consignee no longer has to go to the carrier's office. They simply return the e-variable lading to carriers and are able to pick up the cargo on the beautiful lading platform. The following is a comparison of the advantage and disadvantage of using e-beautiful lading compared to using paper beautiful lading. First, as described above, there are procedural and time advantage on e-beautiful lading, and it can be also solve the problem that the vessel arrives at the destination before the beautiful lading, especially when the transit time of vessel is short in ocean transportation. Second, paper beautiful lading has difficulty to be kept for a long time, for several years, based on the local law of each country. But when e-beautiful lading can be kept in an archive format on the platform, and therefore it has advantage in beautiful lading storage and management. Third, as mentioned earlier, e-beautiful lading can reduce the possibility of a forgery and the possibility of being lost in delivery of beautiful lading compared to paper-based. Fourth, e-beautiful lading can reduce the use of paper, which has positive effect on environmental conservation, which is an important issue worldwide this day. Lastly, e-beautiful lading can also reduce the cost, which according to the aforementioned DCSA opinion could be saved as much as 6.5 billion per year. In contrast, e-beautiful lading also has a disadvantage. First, the current e-beautiful lading has been very sluggish in the market, about 1.2%, and it is still not clear how to promote active participation of market participation in the very short future. DCSA plans that it will place paper beautiful lading by using 50% in 5 years and 100% by 2030. But for such a plan to be realistic, there must be benefits for all market participants, including not only carrier, but also shipper, consignee, bankers, and MVUCC, while there seems to be no visible effect yet. Secondly, as mentioned before, now more than 10 platforms are rushing to beautiful lading market. And in the future, not only carrier, but also MVUCC are considering developing their own platforms for themselves. So I'm afraid that there will be lots of platforms of e-beautiful lading in the future market. In this case, the shippers and consignees are concerned about the complexity of accessing various platforms for each carrier. Finally, there are lack of legal stability. One of the reasons for the low utilization rate of e-beautiful lading in the current market, for example, 1.2%, is the lack of legal stability. In order to promote the e-beautiful lading, the countries of destination as well as the countries of origin must be equipped with the legislation to ensure the legal stability of e-beautiful lading. And eventually, all countries where international trade occurs must be equipped with legislation. For Samsung SDS example, we are transporting the large ocean cargo to Brazil from Korea. And currently, Brazil basically accepts e-beautiful lading, but Manaus customs in Brazil does not accept e-beautiful lading for cargo clearance, while they only accept the paper beautiful lading. In the case of South Korea, I cannot say Korea has very much promoted the legislation for revitalizing e-beautiful lading. And Korea just revised and added one provision of Article 862 to the Commercial Code in 2007. in relation to e-beautiful rating, which states that e-beautiful rating has the same legal validity as the paper original beautiful rating. I do not believe that this is sufficient to ensure and promote e-beautiful rating in terms of legal stability. Therefore, it is necessary for Korea to further revise the law, promote e-beautiful rating, and the future revision should include the following items. First, the law should be revised to include the main items of UNCITRAL model law on electronic transferable record adopted in 2017. For example, it should include all international norms such as integrity, governance, user consent, and international effect of electronic transferable records stipulated in the UNCITRAL model law. Second, the current commercial code of Korea does not specifically regulate the liability issue related to the use of e-beautiful rating. As a result, refusal by bank to issue letter of credit and the refusal to provide the P&I insurance coverage has become practical obstacles. So it is necessary to regulate liability for the use of e-beautiful rating to resolve the practical obstacle. Finally, in recent years, countries such as the US, UK, EU, and China, Japan are discussing practical legislation for the revitalization of e-beautiful rating, including the Singapore Electronic Transaction Act in Singapore, 2010. Since UNCITRAL's model law is not an internationally binding regulation in nature, it can be effective only when each relevant countries enact legislation based on the model law with the same content. In this regard, a practical discussion and a substantial approach on the use of e-beautiful rating in Korea are necessary. Thank you.
Thank you. Thank you so much for the introduction to the e-beautiful rating development. I understand that Samsung SDS collects and generates a huge amount of data based on the logistics. So I'm wondering whether you can introduce the data-based trade business experiences or strategy of the Samsung SDS as time allows after all the presentations. And the next speaker is Mr. Lu Yong and Lin Zihan. Mr. Lu Yong is Vice President of Shanghai Data Exchange of China. You have also 15 minutes. Please welcome Mr. Lu Yong for the first part of the presentation. Now you have the floor.
Thank you, Professor Chow. Ladies and gentlemen, this is Yang Lu and Zihan. We are co-presenting this session. So it's really our great honor to be invited to participating in this forum. We see that under the model law, there is more opportunity for us to work with the ecosystem along the way to innovate in those areas which can facilitate the international trade by leveraging on the data exchange. So this is huge opportunities over there. Let me start with this story first. So in terms of the grocery shopping, we can see this kind of a transformation, especially nowadays, those working class younger generation, they tend to use those online ordering for the grocery food. The reason why is they can have the reasonable price and also have a better user experiences. But the story not end here. What I'm trying to tell you is by leveraging of the data, it can do a lot more things other than just buy the grocery food. First, I can tell you that in this wet market situation, the wastage or the damage rate about those fresh vegetables, it's about 30%. It means if you cannot sell it in time, then 30% of this food or vegetable will be routed. But in the grocery store, chain grocery store scenarios, it can reduce to 10%. By doing those online ordering, it can reduce it even to the 5%. The reason behind it is this online ordering, Ding Dong, take example, they leverage a lot of the data so they can have a better forecast. Even if they cannot meet the forecast, when there is a signal triggered, they can promote through the campaign to sell the rest of the food out. So this is really a good examples for business, how to leverage on the data to improve the efficiency, to save the cost. But story not ends over here. So in terms of the digital economy, we can leverage on the data as an input, which can produce more output. So China is very much emphasized on this. China has already uplifted the data as a production factor since year 2020. And also we are very much focusing on how to build a market allocated mechanism to promote the economy development. So this article actually is from a professor from Stanford Universities. It says China wants to put data to work as economy resources, but how? This picture is very much interesting. You see, data by nature is silo. Now what we are trying to do is break down those silos and either logically or physically consolidate data to let it become an economy means to as an input, so as to increase our productivities and drive more outcomes through this formula. So data can be considered as the fifth production factor after land, labor, capital, and knowledge. So this will help us a lot to develop the new economy in the new world. China is not doing this alone. You see, around the world, there are so many similar practices. Yesterday came from IMDA. Under IMDA, there is SG3X. They are doing this kind of data exchange in the logistic areas. We can see even Japan has the JDEX, and in Korea, we see lots of similar practices. The reason why is the data sharing is become imperative. It's a to be or not to be issue. So we can see this is the cross-border practices to promote this kind of data sharing mechanism. So this is the answer from Shanghai. Under the central government's order, we established the new Shanghai Data Exchange by the year 2021. So this is not only a business. We are a marketplace, but also play a role as a quasi-public institution. So we also help to develop the digital economy sectors. So after we launched this Shanghai Data Exchange, the media has a very high expectation on us. It compares this phenomenon as important as the Amsterdam Stock Exchange establishment. So this is give us full confidence to fully innovate in this kind of new digital economy era. So with or without data exchange, the data market exists. So this is the forecast by a think tank from China. The existing market is already very big. But alongside with this organic growth, we can see with the new data, what we call the 20 data measures launched last year, China will have a huge potential to grow this data factor market. So this is the reason why we established the data exchange to facilitate this kind of data allocation mechanism. So we become a hub in the digital economy era, which will help business to get the data from the third party. And China also is doing this from the top down. This year, we established a new data bureau as a new agency, which will only focusing on the development of the data. You can see lots of other agencies, they are also involving, but now we have this dedicated agency which will help us to guide the development for the digital economy era. So how can we do this? As a data exchange, as I mentioned, we are not only focusing on the platform building, but also we need to work out this kind of rules and standard systems so that to guide the data exchange practice in China. We fully believe that data exchange has a huge potential, but we need to make sure this platform deliver the compliant and high efficiency data exchange practices. So as I was saying, any data products we listed on the platform should be compliant, should have a quality standard. And also any single data product, it will solve a specific business problem. So any data consumers try to buy the data from the data exchange, they need to state what kind of the situation you are using this kind of data. So we need to make sure every data exchange is conducted in the compliant and efficient way. And we also play a role to help to build data infrastructure, not only for Shanghai, but for the whole nation. So Shanghai Data Exchange is considered as a national level data exchange. We are not building only building this platform for the data exchange itself, but we also to make sure after the data exchange, data consumer can get a certificate, which eventually we are promoting a thing called data classified as a asset class. So on this kind of infrastructure, we need to provide lots more functionalities and to make sure that eventually we are building a tiered data factor market, which consists of national level, regional level, and also industrial level. All this will be conducted on the platform of the blockchain so that we can make sure any data products listed here will be recognized everywhere in the data exchange market. And also to make sure that we also play a role as the surveillance and to make sure all those data exchange in the compliant way. So in terms of the business, we conducted this through different kind of market sector. The first and the most important sector is the finance market. So we working with those major banks and also working with those data providers to build a consolidated market, which will help those banks and the financial institutions to get the data effectively. So take examples, especially in the financial market, we are trying to help those financial institutions to go through this kind of a digital transformation process, which means they conduct a business in a different way, especially in those banking scenarios like money lending, credit check, KYC, all those, they are using the new way to conduct the business because they have the alternative data. So this is the areas where we're working heavily with our partners to build this kind of consolidated market. On the other side, we are also working on those transportations, especially in the shipping environment. We can see a lot of our speakers are talking about bill of lading, those type of things. This is a way we help to facilitate the international trade. But on top of this, we can see also there create some other new opportunities, like Costco, one of the biggest shipping lines in the globe. Costco, usually they are providing the data services along the value chain to the cargo owners, to the logistic company, to the forwarders, to the ports. But because of the data, they generate the new services. They can help those global manufacturers to build a single view for the global logistic. So they can help those global manufacturers to have a better decision-making process. If there is a risk over there, how can I reroute the products? So this is the value generated from the data. So data help a lot of business to innovate in those digital transformation scenarios. And on the other side, we are very much focusing on those cross-border data exchange. Currently, we are working with those global data ecosystem partners to build this kind of market. On top of this, I think we can work closely with the UNCITRAL to see how we can build some new innovations for this international trade. So this part, my colleague, our research fellow, Ms. Lin, will help to elaborate a little bit on this later. And also along the data exchange business, we see there's a lot more new business opportunities because data exchange market is not like a traditional mature market. On every of the segment along the value chain, you can see there is opportunities for the digital data ecosystem partners to jump in to provide the services, starting from the data governance to the data product processing, to the data evaluation, et cetera. There's a huge opportunities around the market side. So because of this, we classify our data ecosystem into more than 10 different type of categories, from the data governance all the way down to how to help a business to sell their product, like a new concept called data brokerage. This plays a major role to vitalize or to empower the data exchange market, which let the data consumer easily to find out the data resources along the market. So this is a huge opportunities. Also, if we mapping this into the financial industry, it's about the same. Like a startup going through the IPO process, they need lots of service. So in the data market, it's about the same. So this create new opportunities, and we can see there were many data ecosystem partners will participate in this kind of new practices. So having said that, there is a need to grow this kind of ecosystem. So that's why we established a new Shanghai Data Service Provider Association. So I'm also chairing this association to help the industry to transit from the traditional IT services into the data services side. So there's a huge opportunity alongside. And because of the popularity of this large language model, this AI GC things happening, so Shanghai Data Exchange also play a major role to organize this corpus-based data set. So in order to help those large language model suppliers to train their data, especially in the Mandarin perspective. So most majority of those large model providers, they train their data from the internet, but the Chinese language materials accounts only for 5%. But now with this kind of advantage, we are helping those large language model suppliers to organize different types of Chinese language corpus, so they can build a much better language model in terms of the language use. So this is also the initiatives we are driving here in China, especially in Shanghai. We already have this kind of alliance. We have lots of this kind of corpus materials already being listed in the Shanghai Data Exchange. Also, we are driving a new things called to classify data as a class. So this is not just a practice from the technology point of view. So usually when we talk about a data asset, usually we measure it by how many terabyte, how many megabyte. But now it can be measured from the accounting point of view. So Ministry of Finance in China has already announced this kind of guidance. Starting from January 1st next year, we can have this kind of trial in different type of industries. So Shanghai Data Exchange fully believes through the data exchange, because of you have those kind of data exchange vouchers, certificate. So this can be as a key indicator to measuring the data asset. So this is fully a new initiative. With this kind of things, especially those startups or those major businesses on the data side, in their balance sheet, data can have a way to present it through this, and eventually their market cap can have a lots of ways to present it by this kind of a measurement in terms of the accounting point of view. So alongside this, we can see the organic data market is already growing 30% every year. But with this kind of new way of innovation, we can see we will have a huge opportunity to grow this data market. Eventually, it will help us to develop the digital economy along the way. And so this is the ecosystem. This is a very much important area where we are working on, because data exchange market is not like a mature market. So that's why we need a whole bunch of those data ecosystem partners to help us to grow from every aspect. So this is the major initiatives we are driving in China currently. And now let me give the time to my colleague Lin to talk a little bit about what kind of a legal infrastructure in China and how is our initial thoughts about how we work with UNCITRAL to develop this ETR under the model law.
Thank you. This is Zihan, the researcher from Shanghai Data Exchange. It's my pleasure to stay here to have a speech. I want to introduce some canon legislation about data and data market construction in China, as well as the relation between the ETR and Shanghai Data Exchange. China has issued the top-level documents. It's also a comprehensive document whose name is Opinions on Building a Data Infrastructure System to Better Play the Role of Data Factors. Its abbreviation is called 20 Causes for Data, or the 20 Measures for Strengthening Data Economy. The 20 Causes for Data is divided into 4 parts. First is the data property rights. Second is the data circulation exchange. Third is the revenue distribution. And final is the security governance. In this part, I want to introduce the data property rights mainly, especially the structural division of data property rights. In the 20 causes for data, structural division of data property rights ensure the right to hold data resources, the right to process and use data, and the right to sell data products, which is the separation between the right to hold, use, and trade data. We have the definition in the regulations of promoting data circulation and trading in Pudong New Era of Shanghai. The right to hold data resources is the right to control data resources through management, transition, and so on. If you have the right, you can exclude interference from others. The right to process and use data is the right to perform substantive processing or innovative work on data to form data products and realize value. If you have the right to sell data products, it's the right to operate independently or entrust others to operate them, conduct market circulation of data products, and obtain profits based on the processing and analyzing to form data products by themselves or entrust others. Swan? Okay. And as we know, the global trade is entering the digital era, highlighting 2 significant characteristics. One is the digitalization of trade methods and the digitalization of trade entities. The digitalization of trade methods includes digital connection, digital ordering, digital delivery, and final is the digital settlement. The electronic transferable records, as defined by the MLETR, refer to the electronic equivalent of paper transferable documents or instruments. So obviously, ETR are one of the specific manifestations of the digitalization of trade methods and made more convenience for global trade and accord with the development in the digital trade era. With the formal adoption of the MLETR, the international legal effect of ETR has been further established globally. With the widespread use of the digital technologies and the rapid development of the global digital trade, it is necessary to explore and promote the legal effect of ETR based on the principles of functional equivalence in the MLETR. However, there are still some challenges in the global implementation process, such as the concerns about the technical security. China now is actively promoting legislation and practice of cross-border paperless trade at the national and Shanghai levels. At the national level, China has issued the electronic signature law, the administrative measures for electronic certification service, and the maritime law to explore the legal effect of ETR. Now, the maritime law is revised. The revised maritime law includes provisions of electronic transport records, clarifying that electronic transport records serve as evidence of delivery of goods. At the provincial level, I want to call Shanghai level. Shanghai has issued the Shanghai Data Regulations on promoting data circulation and trading in Pudong New Era of Shanghai, as I mentioned above, and the guidelines for blockchain evidence examination. I mean to promote the international recognition of ETR. And so the final, I will finish quickly. Okay. So after the law system in China, I want to introduce the relationship between Shanghai Data Exchange and the ETR. Shanghai Data Exchange, based on its own positioning and relying on its experience in data trading, contributes wisdom and experience to the trustworthy circulation of ETR. In December 2022, China, as I mentioned above, China has issued the 20 courses for data, proposing the construction of a multi-level data factor market in China, with national level data exchange playing an important role. Shanghai Data Exchange now is a national level data exchange. Shanghai Data Exchange has launched the international board, focusing on building a data import market, aiming to construct an international data trading platform and a global cross-border data flow system. Based on the international board, the Shanghai Data Exchange has improved risk assessed, compliance review, and security protection laws to ensure the safe compliance and trustworthy of the data entry. At the same time, the Shanghai Data Exchange participates in the construction of the Shanghai Data Service Provider Association, promoting the linkage of the various resources in the data factor market and facilitating the circulation and trading of data factor. Currently, as Mr. Lu mentioned above, more than 200 units have joined the Shanghai Data Service Provider Association. Shanghai Data Exchange can promote the mutual recognition of ETR within the national data trading ecosystem and is positioning about the national level data exchange. This is all my speaking, but I have a last word. If you have the time, welcome to China, welcome to Shanghai, especially welcome to our Shanghai Data Exchange. So I want to give the time to Mr. Lu.
Welcome all you to join us at this big event happening this November 25th in Shanghai. So this is one of the biggest tech events, especially in the data world. So we get a lot of professionals, experts to talk about how we leverage on data to create a new value for the digital economies. So again, once again, welcome to join us in November in Shanghai. Thanks.
Thank you so much. For the next speaker is Ms. Bo-kyung Kim. She is the Director of Data Promotion Division under Artificial Intelligence Policy Bureau, Ministry of Science and ICT, Republic of Korea. You have also 15 minutes. Please, you have the floor.
Hello everyone, my name is Bo-kyung Kim. I'm from Ministry of Science and ICT, and I'm in charge of Data Promotion Division in my ministry. Today I will present the trading policy of data in Korea. Korea's data policy environment is changing nowadays significantly, and new policies are being introduced. So today I would like to explain the newly implemented data trading policies in Korea. As you know, data has characteristics fundamentally different from common goods. First, data is easy to transform. Second, its value changes through combination. Third, its usefulness can change subjectively according to players in the market. Last, it can be used simultaneously and repeatedly by multiple users through replication. So because of these characteristics, data trading market is different from other commodity markets. So it is common for data to be customized through negotiation, and each value varies depending on who uses it for what purpose in what way. So this is why it is difficult to have objective pricing for data. Also, in addition, data has a market in which information asymmetry is strong because it is difficult for a buyer to fully understand the quality and usefulness of data before its purchase. So also, it is difficult to completely control unauthorized copying and utilization by others, since the cost of copying data is close to zero, and there is no loss of quality, even after copying. Before representing the status of data market, I'll briefly explain data trading. There is 4 ways of data supply. First, data trading permits the use of trading data with charge. Second, data opening, data disclosures, data to use free of charge, such as public portal. Third, data sharing, in which multiple entities collect, store, process, and analyze data together for a certain goal. Use the result at the same time or distribute the generated review. Today, I will focus on data trading part. I'd like to explain about major status of market in Korea. According to the survey on the status of data industry, the domestic data industry is also expected to grow to Korean won 25.5 trillion by 2022. Direct sales account for 15.8 trillion won in the data industry. Among them, data sales and the brokerage service business can be considered as a data trading market in a narrow context. The data sales and brokerage service industry accounts for 11.2% of total data industry with a size of about Korean won 1.8 trillion as of 2022. The data sales and brokerage market has shown the fast growth rate among data industries. Now I will explain about players. Data trading, in a broad sense, is the market where data seller, trading processing analysis company, trading platform, and purchase mutually interact. Data seller refers to a person who collects data from data entity, enlarges it to a tradable size, enhances its marketability, and sells it as a product in the market. A data trading processing analysis company is a business that processes data according to the requirement to data purchasing company, provide analysis consulting or provide service such as sales agency. This is a concept that corresponds to a brokerage company for trading and a data analysis provider out of a data trading business operator. And trading platform is a platform that searches data product or analysis processing service and supports trading according to a separate contract with data trade sales processing company. Finally, a company or an individual who wants to purchase data to promote its business fall under data purchasers. Depending on whether to have an intermediary, data trading can be divided into direct trading between a seller and a purchaser, and indirect trading through a trading platform or a freight broker. Additionally, I explain major trends and changes regarding data trade channel in Korea. As of 2021, the proportion of indirect direct trading is higher than that of direct free open data, such as public data portals are used the most. However, in the future, the rate of use for free open data will decrease slightly. And data trading based on paid channels such as online platform and private data processing purchase from specialized company appears to expand. From the result of this study, it is expected that the market demand for data brokerage and processing is increasing, and the platforms specialized broker or trading company in data trading market and processing and analysis market will expand. In Korea, data trade market environment has shown a great difference before and after 2019. From early 2010 to 2019, there was only 5 data platforms. In contrast, there have been more than 30 data platforms created after 2020 to 2020 as the demand for data use, such as AI and big data, has increased. So this is Korean trade market is just at an early stage. I will explain more. According to the survey on the status of data industry in 2022, only 28.7% out of companies promoting data business have data trading experience. The reason why the subject of the survey responded that they had no trading experience was that trading is not necessary due to the nature of business. Others are having its self-built data, lack of internal manpower, the absence of useful good quality data, and absence of data trade channel. Also, in addition of 27% of respondents answered that there are legal issues that cannot be considered in the actual trading because of a complicated method of the data trading. Moreover, the response regarding the data quality issue also reached 35% around. In addition, there were responses regarding a company's complaint about the adequacy of data pricing in data trading and difficulty related with current regulation, such as personal information protection. So, Korean government enacted the Data Industry Act in October 2021 to solve such problems of the company and build the foundation for data distribution and trade that can promote data utilization. We are newly planning implementing systems related with data valuation, established of data trading system, data quality management, a standard contract of data trading, a data training company or broker, and dispute resolution systems. This is the first policy. The first policy is to build on one window for convenient search. Before presenting this policy, I first would like to explain big data platform promoted by Ministry of Science and ICT. The ministry has built and operated a big data platform and a big data center that supports the production, distribution, and utilization of high quality data through cooperation between public and private sectors. The big data platform will process and analyze data based on the market demand and provide for the foundation for distribution, while the center will produce data with high utilization value and supply it to the platforms. As of 2023, big data platform in 21 fields and 230 big data center participating in them have been established and are in operation. So in the meantime, while operating the big data platform and promoting the relative policy, we have recognized the need for one window. Public and private sectors have been building and operating various data platforms, but they have been built individually. So their connection and utilization are still insufficient. So this is because it takes a lot of time and money to find, convert, and utilize the data a user needs due to scattered data and separate operation. Accordingly, it is necessary for Korea to establish one window at the national level so that data can flow into each field naturally and create an environment where data can be combined. I will explain the action plan for one window. The main concept is to build one window so that data can be easily and systematically accessed from the perspective of utilization, without distinction between public and private data. This is to standardize metadata so that anyone can easily search and use private and public data and to promote data service linkages through cooperation with related institutions. One window provides catalog-based data location information, status, access condition, and we will also support data exchange and safer use of data. Next, data valuation system. It is the system implemented to support data related to trading and finance by measuring its economic benefit. Based on the economic value of data, data valuation system can contribute to allowing each seller presenting a fair exchange scale and ultimately vitalizing data trade. Moreover, a database company, such as AI company, is experiencing difficulty in financing for commercialization due to the existing corporate valuation practice based on physical collateral such as facility and equipment. Through the data valuation system, it is expected that the company will secure funds such as investment and loan in a timely manner based on the value of their data and make growth. According to the Data Industry Act was imposed in April 2022. In March 2023, for institutions that met the requirement, such as manpower, organization, and valuation model were designated as a data valuation institution for the first time, according to the Data Industry Act. We think if we have valuation method as market, income, and cost approach. Each approach is pros and cons. And current situation, we tried two income approach, and we have two examples. I think data valuation ultimately reinforces the recognition that data is an asset. This will generate investment and utilization of data and be a good mechanism to attract data with good quality to the market. I'll move on to next slide. We have implemented data quality certification system to verify the quality of various data traded in the market and to ensure that the company can trade verified data safely in the market. Data quality will be enhanced by spreading certification into market. We therefore aim to activate data distribution by enhancing confidence among companies that trade data in the data market. Currently, Ministry of Science and ICT is operating a working group with 3 certification institutions to develop common certification regulation and screening system. We have 3 certification companies as designated. Furthermore, the data test standard for certification screening will be prepared based on the international standard to secure reliability or certification result. And also, we have another policy. I'd like to present a standard contract for data trading, which is promoted to establish a reasonable data trading order. Compared to other fields, a contract is still unfamiliar in the data market, so there is a high risk of dispute. Depending on the size of a company, the degree of readiness to enter into a contract differs. Therefore, the predictability of contract and the trading result is strengthened by preparing a standard contract that can be used data trading. This is prepared based on Data Industry Act to promote reasonable and fair trade. The status of implementation for the establishment of standard contract is as following. Currently, we have prepared a draft contract for each type of data trading that reflects the actual situation of data trading in the private sector through research. Based on this information, we plan to collect opinions from experts, various market participants, and stakeholders. We plan to develop and distribute a guideline for a standard contract this year after completing the establishment of standard contract. It is to increase the understanding of data trading and support the use of standard contract. There are 3 types of standard contract depending on the type of data trading: data product trading, processing service trading, and brokerage trading. And also, I'd like to introduce about another policy. It is necessary to supplement information asymmetry between the seller and purchase, who are the main entity in data trading. So we introduced data broker systems. According to the Data Industry Act, data broker provides service such as professional consultation, advisory brokerage between a data seller and a purchaser to alleviate the information asymmetry problem and to play a role in helping a smooth trading. With such measures, one can expect higher efficiency of data trading, market and the improvement of trading environment. Starting with 100 traders this year, the Korean government plans to foster 10,000 data brokers by 2025. And last part, I would like to explain the Data Dispute Resolution Committee. In order to facilitate data trading, it is important to protect the right of trading parties and establish a trading order to create a safe and reliable data trading environment. So to this end, it is necessary to have amicable solution for various disputes arising from the data trading process. So that is why we prepare to establish DDRC in accordance with Data Industry Act for the following reasons. First, you can save time and cost. Second, one does not have to abide by strict regulation. Third, one can have conclusions that satisfy the interest of parties and subject to a dispute. Last, the result of DDRC is highly likely to be implemented since it is based on the agreement of the parties. We are looking forward to launching DDRC within this month. Thank you for your attention. There is still a long way to go to facilitate data trading market in Korea. The ministry will continue to strive to ensure the newly introduced systems are well established. And in the process, we have to actively share policy experience and knowledge with private sector experts and policymakers here. Thank you very much.
Thank you. Thank you so much. And I'm so sorry for our lack of time. And then next speaker is Mr. Atsushi Okada. He is a partner, Mori, Hamada, and Matsumoto, Japan. Are you online?
Can you hear me?
Yes, yes, please. You have the floor.
Okay. Can you see my screen?
Yes.
Great. Thank you very much for inviting me. It's a great honor to make a presentation in this important conference. I think time is already running out, so I will try to make my presentation very short. So today I want to talk about several hot topics, hot policy issues, which presents important issues related to data transfer and data sharing. All of those policy issues are important to facilitate fair and appropriate data transfer mechanism. So first, AI governance. Second, IP protections in terms of AI. And third is data free flow with trust, so-called DFFT. So first topic, AI governance. So as you know, AI has been making tremendous changes to our business and daily lives. And while it is very important for innovation, at the same time, it causes various concerns regarding privacy, security, copyright infringement, data bias, and other various data related issues. And so the good AI regulation, good AI governance is very important for facilitating fair, transparent, and appropriate data transfer. But in this regard, different jurisdictions have taken different approaches so far. So I want to explain about how Japanese government has tried to make an appropriate regulations in this area. So the last year, there was an explosion of ChatGPT and other generative AI revolution. So I think it is useful to make a distinction between the Japanese government's approach between pre-2022 and post-2022. So now pre-2022, Japan has no cross-sectoral regulations that generally constrain use of AI, and potential AI regulations. There are multi-layers approach. The one end at the one end of the broad spectrum of approach, there is a high-level, very broad principle-based approach, and the other end of the other spectrum, there is a specific potential regulation. So in terms of high-level principles, the Japanese government adopted the social principles of human-centric AI in 2019, so which comprises of 3 basic philosophies and 7 principles. So all of them are very high-level principles. And in terms of the actual implementation of good AI governance, the Japan has taken a risk-based and software approach, not hardware-based approach. And Japanese government has adopted several important non-binding guidelines. And here I divided into two types of regulation. The first is regulation on AI, which means regulation to manage risks arising from AI. The second type is regulation for AI, which means reforms to promote the implementation of AI. So the first type, a regulation on AI. So Japan has taken an approach of respecting voluntary AI governance and providing non-binding guidelines, while imposing transparency obligation on some large digital platforms. So there are several guidelines. The first is Ministry of Economic Trade and Industries governance guidelines for implementation of AI principles, which provide specific examples of how to implement social principle, high-level social principle into the real business. And another ministry, which is Ministry of Internal Affairs and Communication, they have similarly created guidelines for AI developers and users. And also in terms of contract for data transfer or AI development, the MIDI established in 2018 contract guidelines on utilization of AI and data, and which includes some standard, although again they are non-binding, but proposed standard samples of data-related contracts. And in terms of regulations for AI, there have been regulatory reforms to promote the use of AI. For example, the relevant law allowed level 3 automated driving. And this year, actually, already the law allows introduce regulation which allows level 4 automated driving. And then evolution of generative AI happened. And in this year, further discussions have been facilitated by the emergence of generative AI. So the Japanese ruling political party, Liberal Democratic Party, issued AI white paper in April, and also the Japanese government established the AI Strategy Council, which is a headquarter of deciding the national policy initiative toward AI-related issues. I'm actually a member of this council. And the AI Strategy Council issued in May a tentative discussion paper on AI and summarized issues related to AI risks, which includes leakage of confidential information, bias issues, and copyright issues, and also cyber attack issues, and so on. And Also, the AI Strategies Council's discussion paper stated that the existing guidelines, as I introduced in the previous slide, should be revised in light of the spread of the generative AI. So current approach, Japan continues to take a soft law-based approach, at least for now, and in accordance with the AI Strategy Council's proposal, the Japanese government is now trying to revise and integrate existing guidelines, but still these are non-binding guidelines, and so still we are taking soft law-based approach. So obviously, there are various issues remaining for future discussion. So how to monitor compliance with, private companies' compliance with the guidelines, and how to secure trust from users and thus general society, and also how to ensure incentives to comply with the non-binding guidelines. And is there any good audit or certification system? And so on. And also, IP roles are very important, and I will explain this topic later. And also, from the international perspective, there is a Hiroshima AI process. So G7 leaders agreed to discuss under the framework of Hiroshima AI process at the G7 Hiroshima Summit held in May 2023. And although all different countries have taken different approaches. So for example, EU is now proposing a hard law-based approach under the Draft AI Act, and the US government have obtained voluntary commitments from major AI developers. So different governments take different approaches, but we are trying to find a common ground. So there are various methods to implement the policy, hard law approach, soft law-based approach. That's fine, but we are all the G7 governments agreed to a joint statement just last week, and agreed with the necessity of developing guiding principles and code of conduct for AI developers and so on. So next topic, AI and IP, especially copyright. So the obviously there are a lot of data, big data required for training AI. So in that context, there is a tension between copyright law and AI innovation. And in this regard, Japanese Copyright Act aims to achieve optimal balance between clarity and flexibility via Article 34. It's an exemption provision as introduced by the 2018 amendment. It's a approach different from the fair use provision in the United States, but but still our exemption provision provides a very flexible grant for AI developers or AI training companies to rely on. So there are two stages. The first stage, AI development and running stage. In this stage, Article 34 becomes relevant. And another stage is generation utilization stage. So generating outputs using AI. So in this regard, in this stage, there is no special provision under Japanese Copyright Act. So if there is a similarity and dependence with the previous existing copyrighted work, then there could be a copyright infringement. But there are various issues how to judge dependence and who bears liability. So again, Article 34 of the copyright. So it provides a broad exemption.
Mr. Okada, please, I'm sorry about that. Please wrap up within 2 minutes, please.
Okay. And so Article 34 provides a very broad exemption, and it's the several characteristics. So the Japanese broad exemption is not limited to scientific and non-commercial purposes. So even commercial purpose is allowed. and also it is permissible to use illegally distributed contents. But there are some limits. Because there's an exemption that if the usage unfairly damages the interest of the copyright holder, then this exemption provision does not apply. So there are voices from the private sector that the scope of this exemption provision should be clarified, especially in the context of generative AI. So the Japanese government's IP strategy headquarters proposed that it is desirable to organize issues such as copyright infringement and also the creative contribution for AI product to be recognized as a copyrighted work and so on. And in accordance with that IP promotion plan, the Japanese relevant governmental agencies governing the copyright law is now discussing with IP law scholars and attorneys of those issues. And finally, data free flow with trust. It is in the context of international data transfer. So what is DFFT? The concept is it aims to promote the free flow of data while ensuring trust in privacy, security, and IP rights. So there are various barriers on the cross-border flow of data, multi-layered nature of regulatory requirements, legal stability, lack of legal stability due to frequent changes in the requirements, and research cost on the part of companies. So Japan is proposing this data free flow with trust, and in this year in G7 Hiroshima, the establishment of institutional arrangement for partnership was endorsed among G7 leaders. So this is last slide. So what is IAP? So basic idea is to facilitate discussion between government and the private sectors. And so both parties work together to implement international projects like enhancing transparency, data mapping, privacy. And so both from regulatory perspective, also technology perspective to facilitate data transfer by removing those barriers. So the basic idea is not, forcing each different government to to purely harmonize the statutory law. It is not feasible to adopt such approach because different government has different statutory laws. So the idea here is to facilitate discussion and to implement more creative technology approaches, including technology approach, and try to remove cross-border data transfer barrier. So that's all from me. Thank you very much for listening.
Thank you so much. And I'm so sorry for the failure of time management. Actually, I also asked a question to the Mr. Jacob Lee, but as you know, we have no time for the Q&A session. And then also we have one open question, but also we cannot answer to the question. But I think you can have some materials from Working Group 4 discussion in website because we already discussed about CISG's application to the new environment based on artificial intelligence and data. So I strongly recommend you visit the UNCITRAL website. And I'm so sorry again. I hope that today's discussion will serve as an important foundation for the developing legal norms on digital trade within UNCITRAL and across the Asia Pacific countries. So now I conclude the session. Thank you so much to the speakers and all attendees. Thank you.
Thank you very much to our moderator and panelists for riveting discussion on trade in data. At this point, we respectfully request that our esteemed speakers approach the stage for a group photo. Mr. Okada, please keep your camera on for a moment longer. One, two, three. One more time. 1, 2, 3. Thank you very much. We will now have a 7-minute break and resume at 11 o'clock with our second panel discussion for the day. During this time, we would like to request the virtual speakers of the upcoming panel to stay online so we could test your connections during the break. Thank you. For participants who have just joined us, welcome to day 2 of the 3rd Incheon Law and Business Forum. Kindly note that we are currently on a short break, and the next session will begin at 11 o'clock Korea Standard Time. Welcome back to our esteemed speakers and guests. Our second panel for today will be addressing the topic of digital trade agreements. It is my pleasure to introduce Mr. Jae-sung Lee, Senior Legal Officer of UNCITRAL in Vienna, to serve as moderator for this panel. Jay is also the Secretary of Working Group 3 on Investor State Dispute Settlement Reform, and he has previously functioned as the Secretary of the Working Groups on Dispute Settlement, Secure Transactions, and Electronic Commerce. Jay, thank you for joining us here today to moderate this panel on digital trade agreements. I will now hand it over to you.
Thank you, and we're looking for one of the speakers. So we're hoping to have a call for Kate to join us in the panel. So here it is. Kate, we're waiting for you. So welcome to Law Track 2 session on the digital trade agreements. As introduced, my name is Jae-sung Lee. I functioned as the secretary of the working group that prepared the first, and I think I was the first, I prepared the first draft of the MLATR some 10 years ago. And I am also involved in the stock taking of recent developments in the digital economy and dispute resolution. I am not a digital economy expert like the other speakers that we have with us, and therefore I'm happy to have 5 DTA experts or digital trade agreement experts today to give us an overview of what's going on with regard to DTAs. In a sense, for me, it's a DTA for dummies session. So hopefully, and all the other participants can get an idea of what is currently being negotiated by the government in the realm of DTAs. Now, while the panel is titled Digital Trade Agreements, if you look at the individual agreements that have been negotiated by states, they have different names. They're referred to as digital partnership agreements, digital economy agreements, digital economic partnership agreements, digital economic framework agreements. So there is no single word that actually covers all these agreements. So, and I think also references made to digital only agreements. So there are different words to call these kind of agreements, but for ease of reference only, we'll refer to them as DTAs or digital trade agreements, noting that such agreements are not necessarily limited to the scope of trade or cross-border trade. We have 5 presenters today. It's an irony because the only Korean speaker is the one who is participating remotely, and all of the foreign speakers are actually here with us. Now, before I give each of them the floor, I would like to actually pose a question to Lara on what is a digital trade agreement, what makes it so digital, or what makes it so trade, and how is it different from the existing FTAs or regional trade agreements that we are so used to being hearing about. So Laura, you have 3 minutes to give us an overview, a crash course on DTAs.
Thank you. Thank you, Jay. I'd like to start by saying that e-commerce have been included as one of the many chapters in FTAs. And in Malaysia's case, since the ASEAN, Australia, New Zealand FTA was signed in 2009. Now, this is largely because e-commerce has often been regarded as the initial touch point on digitalization and digital economy, be it for businesses or consumers, and especially more so in the case of the MSMEs. So more recently, in fact, since 2020, we have observed that some countries have entered into digital-only trade agreements called Digital Economy Agreement, Digital Economy Partnership Agreement, or even DEFA, DEFA, Digital Economy Framework Agreement. So in short, being referred here today in today's panel as DTAs. So these standalone digital-only trade agreements or digital economy agreements seek to address a range of disciplines relating to the digital economy, which includes the more familiar and conventional disciplines in e-commerce chapters of existing FTAs, and newer and emerging issues related to the digital economy, which were not previously addressed in existing FTAs. So generally, our observation is that these standalone agreements and FTA e-commerce chapters tend to vary in terms of specificity, depth, and also breadth. And another distinguishing factor is that FTAs often take a longer time to conclude, as they are dependent on conclusion of other chapters. And concluding a standalone DTA or DE agreement may be faster, as there are no dependency on other chapters. So that's my brief overview based on my understanding what is a DTA.
Thank you, Laura. So as Laura has mentioned, these used to be part of FTAs or separate chapters within FTAs, but now they're becoming kind of a standalone document of its own that deals more specifically with the relevant issues that are covered. Now we'll be delving into what these components of the digital trade agreements are. But before we do that, to give us a little bit of a historical perspective of why DTAs came about and what are the key components, I have Ren UK, who has been with us for some time. He's been on 3 other panels, so I don't think we need to introduce you. But Kay is with the Singapore's Infocom Media Development Authority, supporting Singapore's Ministry of Trade and Industries on discussions on these kind of agreements. He works with governments on projects that involve orchestrating, so it's a business and government relationship kind of a stuff, to undertake digitalizations, and thus showing the way also for other governments on how to conduct these kind of activities. So with that, Kay, we would like to have interactive discussions following this panel presentation. So you have 8 to 10 minutes. Thank you.
Thank you very much, Jay. All right, well, so let's start with the business problem, because ultimately that's who we're doing this for. So we really looked at digitalization, and without intervention, you have all this fragmentation, you have all these unregulated or even without guardrails. And we feel that in the realm of digital, guardrails are important, just so that there is predictability, there is the ability to reliance. So looking at the rise of e-commerce, there were all these issues like, well, what you see in front of you, which really matter to the layman, matter to the business, and therefore matter to government. So from that perspective, we then, and if you cast your mind back, with CPTPP, with that many countries, 3 countries then got together and concluded the Digital Economic Partnership Agreement, right, between New Zealand, Chile, and Singapore. And these are an increasing feature that the world is experiencing. From DEPA, we went to SADEA, or Australia, Singapore, DEA, or the DEA. And then we also went into the UK, Singapore, DEA, and then after that, the Korea, Singapore, DPA. But in addition to these bilateral agreements, we also undertook multilateral at the WTO JSI. And of course, I'm very happy to have Australia, a co-convener at the JSI with me here today. So the momentum is picking up. And we are also, we've got plenty in the pipeline to try to establish these guardrails for the benefit of industry. Now, if you look at why, if you look further, right, it's not just deepening and strengthening the rules for digital trade. It's an opportunity to address and foster cooperation in emerging issues. And this is where the convening power of the governments to orchestrate together with businesses, either to explore emerging technology, but take it to an implementation or a POC stage to prove that this is workable. So areas like digital IDs, e-payments, so on and so forth. And I guess lastly, the DAs create framework, right, for our partners, all to establish and create a trusted, seamless, and a certain environment in the global digital economy. So again, the emphasis is on certainty. Three broad pillars. We look at facilitating seamless end-to-end digital trade. We look to build trust in digital systems, and we look to enable open and secure data flows. Of course, these are evidenced in the paperless trading articles and all the various articles within the DEAs. If we then slice the cake a bit differently, they can be seen at the process level, standards level, regulations and governance, and even infrastructure, which made sense, for example, for the DEA, but probably not for DIPA because, Chile is slightly further away. And if we look at the fact that really DEA is built on top of existing e-commerce chapters, so the green stuff is what's traditionally there, and we take the opportunity to layer in the pink stuff and push that envelope to cooperate with other countries. Okay, that brings me to the end of my 8 minutes, and I'm very happy to make it in time. Thanks, Jay.
Well, thank you, Kay. Now you've kind of seen an overview of what constitutes a DTA, what the main components are. Now we're going to do a world tour, starting from Australia, going to Malaysia, and then coming back to Korea. Starting with Alex, who is new to Seoul, having arrived last month on her mission at the Australian Embassy to Seoul. Before joining the embassy in Korea, she was the director of the digital trade section in the Department of Foreign Affairs and Trade. And in that role, she was responsible for the entry into force of the Australia-Singapore DEA and negotiated digital trade chapters of the Australia-UK FTA. So can you share with us what the Australian experience with DTAs have been?
Happy to, and thank you very much, Jay, for that introduction. As you mentioned, I've just recently arrived in Seoul, where I'm the economic counselor covering a broad range of economic and trade issues, but have previously worked on digital trade agreements, including Singapore and UK. So today I'll just give you a very brief introduction of Australia's approach to digital trade and our current and future priorities. I think Kay's already given a great overview of some of the digital trade areas, so I won't repeat what he's already covered. But I would just say, I guess from a trade negotiator perspective, digital trade is one of the most sort of dynamic and quickly evolving areas of trade and of trade negotiations. It's an area where Australia has really aimed to take a leadership role, both in our sort of bilateral, regional and multilateral negotiations. And so we've done this through a groundbreaking sort of benchmark agreement with Singapore. The digital economy agreement, I think, really showcases where we aim to take our digital trade agreements. And also through our leadership, along with Singapore and Japan, of WTO negotiations. So from a trade negotiator perspective, digital trade can be quite a challenging area. You're trying to balance a lot of things. On the one hand, it's such a fast growing part of trade that it's essential that we negotiate the sort of rules to set the guardrails, I think, as Kay had put it. But on the other hand, it's because it's such a quickly evolving area, it can be difficult to agree on the types of rules that we will need in the future, including where we need to maintain policy space before establishing rules. We're covering critical areas for the future, such as how treatment of AI, how we deal with data flows across borders, or how we treat source code in cross-border transactions. So these are all sort of essential areas to get right. I'd say where we do establish rules, it's important that they can stand the test of time. And it's not always easy, as it requires predicting how digital trade will, policies will evolve in the future. So just quickly on why Australia has put so much effort into these digital trade rules and why it matters to us. I mean, I think if some of the reasons are quite clear. As we all know, the global economy is more connected and integrated than at any point in history. And the use of digital technology is enabling trade enabling trade is growing rapidly. I think the statistic I saw most recently is global exports of digitally delivered services have risen by over 8% per year since 2005, and now worth globally almost $4 trillion US. I think there's this perception sometimes that digital trade rules are mainly only of relevance to e-commerce companies like Amazon or digital platforms like Google, but in reality, digital trade is critical to almost every business in one way or another, as well as to consumers and workers around the world. And digital trade underpins supply, so every supply chain around the world. And for Australia, 1 in 4 Australian jobs are connected to trade. And as this trade is increasingly digital or facilitated by digital means, we see it as really critical to have the right rules in place. And so from the Australian view, what are those right rules? So we want to see robust international digital trade rules. What we're aiming for is to provide certainty, stability, and to build trust in the online environment, so that can enable innovation and growth into the future. The rules are also focused on promoting compatible systems for businesses operating across borders, so to facilitate trade and avoid protectionism. So they cover everything from compatible payment systems to acceptance of e-signatures and paperless trading, so that cross-border trade can be seamless. It's arguably, I think, small businesses and SMEs who stand to gain the most from these digital trade agreements and by having consistent rules across borders, because those small businesses are the ones who are much less likely to have the capacity and resources to navigate complicated and varying rules across different countries. So from the Australian perspective, we're currently, just touching on the current negotiations we have going on from the Australian perspective, starting from the bilaterally, we've got ongoing negotiations with both the EU and India on digital trade as part of a broader sort of FTA negotiations. Multilaterally, as I've mentioned before, we're co-convening the WTO negotiations along with Singapore and Japan, with the aim of developing the first set of global digital trade rules. And those negotiations currently consist of 89 WTO members are participating. And we've got high ambitions of aiming to conclude those negotiations by early 2024, if not sooner. We're also doing regional trade negotiating digital trade rules through the Indo-Pacific Economic Framework in the region. So I guess in terms of what we're aiming to achieve through most of these negotiations, and they do differ a little bit between the multilateral and bilateral, but we sort of have 4 main objectives that we're trying to achieve, especially in the most recent negotiations. Just to go back historically, I think the very first digital trade rules that Australia agreed was back in 2003 with Singapore again. So that was a sort of e-commerce chapter in the Australia-Singapore FTA. So from 2003, and then in 2020, we agreed the Digital Economy Agreement with Singapore. And it's interesting to see the differences between those 2 agreements and how much things have changed over time. I think in the first chapter, there were only 10 articles agreed. And then in the most recent agreement, there were 38 articles. including sort of 8 MOUs that were signed as part of that agreement. So things have certainly evolved very sort of quickly over time. But in terms of our modern and most recent agreements, we sort of aim to have we have 4 main objectives that we're trying to achieve through these trade agreements. So the first is around promoting trust in the online environment, because digital trade just isn't possible without that level of trust from consumers and businesses. So these rules focus on consumer protection, data protection and privacy, which is really critical. And also the treatment of unsolicited messages or spam. The second big sort of group of rules that we focus on is the facilitation of trade by digital means. So these include a whole range of things from acceptance of electronic trade documents, acceptance of e-signatures, and rules on e-invoicing and e-payments as well, to ensure that we're developing compatible systems across borders. The third area of negotiation, it tends to be, and one that's gets a lot of attention, is around the enabling of cross-border flows of data. What we aim to do from an Australian perspective is to enable data flows as seamlessly as possible to enable businesses to work across borders. We want to avoid unjustified data localization requirements, which can often be seen as a sort of form of hidden protectionism sometimes. So these data localization requirements, I think, from our perspective, are problematic because they can impose very high costs for businesses. For example, if businesses have to set up a new sort of local storage requirements in every market that they operate in, it also makes it extremely difficult if they're trying to do centralized, payment systems or the like. But I think it's important to note that we also try to balance that with legitimate public policy priorities. So, for example, Australia carves out health data from those cross-border data flows because we do have legislation that requires health data to remain in Australia. So there's always exceptions to these rules. I think the fourth area, which has been really a feature of agreements like we've had with Singapore and the UK and others, is around cooperation on broader digital economy agreements. We've seen this come into these recent agreements, and that's looking at sort of really working closely with like-minded countries on the future challenges that we see in the digital economy. So I think, as I mentioned, in the Singapore agreement, we had 8 MOUs attached to that agreement on areas ranging from cybersecurity and online practices to digital identities, cooperation on AI, particularly around looking at cooperating on standards around AI, which I think is certainly critical to the future. So I guess so we set out those 4 main objectives, but I guess the principles that we focus on the most through our negotiations is around advocating for rules that are balanced against legitimate public policy objectives, such as privacy or national security, but while trying to maintain flows of data and other rules. So looking ahead, I think I've just mentioned top sort of objectives we have on the horizon. Conclusion of WTO e-commerce joint statement initiative. There's a big focus on that as soon as possible. Concluding negotiations in the IPEF rounds. And lastly, just noting, we're also putting a lot of attention to advocating for an extension of the WTO moratorium against imposing customs duties on cross-border electronic transmissions. So that will be looked at the next ministerial conference at the WTO in early next year. I'll wrap up there, given time, but just noting there is more information about our approach that you can be found on the DFAT website if you look at Australia's digital trade strategy.
Thank you, Alex. I think what Kay and Alex has shown is that these DTAs are actually states coming together. It's an agreement. So they're trying to cooperate on common issues of grounds to facilitate, whatever the word is, facilitate, promote, and enable trade, trust, and trade. I think that's the general outline that we have. The next speaker is Laura Ho, who's a director at the Malaysian Digital Economic Corporation, responsible for the national roadmap and cross-border roles in digital trade. She functions as a channel between businesses and government, and it would be interesting to see how Malaysia, who's a newcomer to DTAs, is approaching these relevant issues and how you're finding common grounds with other states. Thank you, Laura. You have the floor.
Thank you. So first and foremost, I'd like to express my gratitude to UNCITRAL for inviting me to participate at ILBF, to have the opportunity to share with you about Malaysia's journey on digital trade agreement. So I'd like to start with sharing with you about the digital landscape in Malaysia. So Malaysia's total population is about 33.4 million people. Over 99% of the population owns a mobile phone. 97.4% have access to the internet, and 99.2% of the population are active social media users. So in summary, we are a nation with steady digital growth. So then some background about our organization, the Malaysia Digital Economy Corporation. In short, we are known as MDEC. So we were established in 1996 as the one-stop agency to transform and drive the nation towards the knowledge-based economy. So some of you may have heard about this initiative called the Multimedia Super Corridor. So we were set up for that purpose. So currently, we're an agency under the Ministry of Communications and Digital, leading the digital transformation for the country for over 27 years now, through the implementation of various programs under currently what we call the Malaysia Digital Initiative, MD for short. So we envision Malaysia to be the preferred hub for world-class digital businesses and talents, and our mission is to drive the digital economy through various initiatives that includes catalytic high-impact initiatives, strategy and sustainable investments, and inclusive policies. So let me share with you about our journey on e-commerce and towards digital trade. So the initial touch point on digital trade, and for many, in terms of digitalization, is e-commerce. So Malaysia has recognized the importance and critical role of e-commerce and has implemented this particular roadmap called the National E-commerce Strategy Roadmap since 2017. So we are currently at version 2 of this roadmap, is NESR 2.0, that will be implemented from the year 2021 to 2025. So this particular roadmap sets a strategic direction and a whole of nation approach in implementing interventions to ensure a more inclusive outcome by aligning the very diverse stakeholders towards a common vision. So we have found that such a roadmap has been very useful and effective because e-commerce and in fact digital economy involve policies and disciplines that cut across so many ministries and agencies. So NESR 2.0 is guided by 3 principles. It is about intensifying adoption and growth, enhance ecosystem, and about strengthening policy and regulatory environment as well. And it is implemented through 16 programs across 15 ministries and agencies. So one of the key programs under the NESR is the National E-Invoicing Initiative, which is premised on the principles of interoperability and tapping on the power of data for value creation in order to enhance efficiency, accuracy, and reliability of transactions across the industry, and of course also across the border. So COVID has of course brought about unprecedented challenges to many, and the foundation laid by NESR since 2017 and the collaborative effort between public and private sectors have to a large extent helped MSMEs to cushion the shock and in mitigating the effects of the pandemic. So on the other side of this slide, you can see that is the economic impact and some data about e-commerce to our local economy. So e-commerce contribution has more than doubled from 6% in 2016 to 13% in 2021. Individual e-commerce adoption rate has grown from 25% in 2018 to over 70% in 2022. So in terms of income from e-commerce transactions, you can see from the chart that Malaysia has experienced accelerated growth from 2017 to 2021. And there is indication that growth rate has since stabilized. So in essence, e-commerce growth is being exemplified in the form of an S-curve and can be considered to have normalized. With this, I am pleased to take this opportunity to share that this roadmap is currently under review to pivot e-commerce, to drive and to mobilize the entire nation towards digital trade. There is therefore opportunity for this particular review to take into account the work by UNCITRAL, the solutions that are currently being implemented by the various countries, as we have learned yesterday and will be learning today, and the views shared by all the experts here at ILBF. So the growth trend in Malaysia is also consistent with the findings by Google, Temasek, and Baines in their Economy 2022 report. The report highlighted that the growth trajectory of e-commerce among urban digital users in Southeast Asia is expected to be in the form of an S-curve. And to quote from the report, after years of acceleration, digital adoption growth is normalizing. E-commerce is nearing full adoption among digital users in urban Southeast Asia. With this, the question for consideration then is, how and to what extent have cross-border rules evolved, and what next? So according to a joint research by WTO and WEF, e-commerce and digital trade provisions have been increasingly integrated into regional trade agreements since 2010. So recognizing the vast opportunities presented by digital economy, Malaysia has since around the year 2009-2010 entered into a number of FTAs containing e-commerce chapters and provisions. And these include the ASEAN Australia New Zealand FTA, we call it the UNCITRAL. The negotiation for this particular FTA started in 2005. It was signed in 2009 and came into effect for Malaysia in 2010. The CPTPP took about 8 years to conclude. It was signed by 11 participating countries in 2018 and came into force for Malaysia at the end of last year. So the RCEP, for RCEP, negotiations started in 2013 and the agreement was signed in 2020. So over the last few years, recent few years, there was a negotiation for upgrade of the UNCITRAL. The upgrade negotiation was concluded at the end of 2022, and as of last month, the upgraded UNCITRAL has been signed by 6 out of the 12 countries, and that includes Malaysia. So apart from the above, ASEAN member states have also entered into a standalone agreement on e-commerce called the ASEAN Agreement on Electronic Commerce that was signed in 2021. It took about 2 years to finalize the agreements. So in general, the key objectives of e-commerce chapters in these FTAs are to promote wider use of e-commerce, contribute to creating an environment of trust and confidence, enhance cooperation, and of course, it is also to avoid unnecessary barriers. So these agreements, as I've mentioned, were negotiated and signed over a period of about 17 years, 2005 to about the end of 2022. So during this period, and as presented earlier, the technological landscape, in particular the level of digital adoption, innovation, and even business models, have accelerated and evolved very substantially. Accordingly, the provisions covered in these agreements have also evolved over the years, including the disciplines that are being addressed and also the level of commitments. So earlier this month, ASEAN announced the launch of DFA negotiation, Digital Economy Framework Agreement. So I will not go into details because my colleague here from ASEAN Secretariat will be speaking, will be sharing a bit more about what DFA is. So I would like to take this opportunity to share that Malaysia has not entered into any digital-only trade agreements as of now, apart from the ASEAN Agreement on E-commerce. So Malaysia will be joining our fellow ASEAN colleagues to commence negotiation of the ASEAN DFA by the end of this year. So regionally, we are observing that since the year 2020, and as shared by my colleagues here from Singapore and Australia, countries including Australia, Chile, Korea, New Zealand, Singapore, and UK have entered into various digital-only trade agreements or digital economy agreements addressing a wide range of digital trade issues. And of course, still under negotiation, and which I have not put it on this slide, is the WTO Joint Statement Initiative Agreement on E-commerce that involves 89 WTO members, including Malaysia, working together to negotiate new rules on a wide range of disciplines on digital trade and e-commerce. And of course, the target for conclusion is the end of this year. Moving then on to what are differences between the new digital-only trade agreements and versus the conventional FTAs. I've shared a bit just now in the opening session of this particular panel. But let me start by saying that the terms and extent of commitment in any trade agreements are very much dependent on the levels of development of the countries who are in negotiation. So given that countries are at different levels of development and at varying stages of readiness, especially for digital economy and digital trade, it can take time for negotiating parties to find a common landing zone to align their respective ambitions and the level of commitments, and in some instances may not be easily achieved, especially on the newer and emerging disciplines in digital trade that are still very much evolving. So DTAs in general adopt a considerable broader approach than conventional e-commerce chapters in FTAs. DTAs seeks to address a range of disciplines relating to the digital economy that include the more familiar and conventional disciplines in e-commerce chapter of existing FTAs and newer issues to the digital economy that were not previously addressed in existing FTAs. DTA is seen as the next generation agreement with a shift in focus of the agreement from familiar disciplines such as paperless trading, electronic transaction framework, electronic authentication, e-signature, online consumer protection, personal data protection, spam, and cybersecurity, to new and emerging disciplines, for example, fintech, AI, cryptography, digital identities, open government data, digital trade standards, electronic invoicing, and of course, data provisions. So familiar disciplines in existing FTAs include commitments on UNCITRAL Model Law on E-commerce 1996 and the UN Convention on Electronic Communication International Contracts 2005. So in the recent digital-only trade agreements, we have observed that UNCITRAL Model Law on Electronic Transferable Records, MEL-ETR 2017, has also been incorporated. So in essence, DTA and FTAs tend to vary in terms of specificity, depth, and also breadth. Another key difference is that FTAs often take longer to conclude as they're dependent on the conclusion of other chapters. Concluding a standalone DTA may be faster as there's no dependency on other chapters. That's all things being equal. So another observation that I would like to share is that cross-border rulemaking on digital trade has grown more comprehensive and has in fact intensified. Recurring provisions from agreement to agreement possibly reflect the central issues in digital trade negotiations and in cross-border rulemaking. And their changing details may generally indicate how the technical, legal, and regulatory framework might evolve, even as the outcome of negotiations would depend on numerous factors. So, according to OECD,
Laura,
of course, that it comes to...
If you could wrap up,
yeah.
please.
So there's a growing consensus that digital trade encompasses digitally enabled transactions of trade in goods and services that can either be digitally or physically delivered, involving consumers, firms, and government. But underpinning digital trade is the seamless and end-to-end movement of data to improve efficiency, reliability, and accuracy of transactions. So MDAC, we are driving digital transformation for Malaysia, and we are focused on driving initiatives that seek to achieve interoperability, harmonization, and of course, in terms of standards and regulatory approach. And fundamental to this is the interplay of technology, standards, and a coherent, harmonized, and compatible legal and regulatory framework. So we see that international cooperation between jurisdictions and, of course, public and private partnership will play a significant role to foster the growth of this particular ecosystem. So with the continuous advancement in technologies, business models, and of course, economic landscape, and recognizing the cross-border nature of digital trade, there are vast opportunities for greater and closer regional and international cooperation to work towards using the DTA to continually enable and facilitate, to strengthen trust and confidence. It's about reducing barriers. It is also about tapping on the power of data for new value creation. And ultimately, it is about promoting diversity and inclusivity, bridging the digital divide, and driving digital inclusion. So to conclude, DTA can be a useful mechanism to complement the work of UNCITRAL towards forging a coherent and compatible legal and regulatory framework at the international level. So with that, thank you.
Thank you, Laura, for interesting presentations. I do have a question, an urgent question. I'll pose it now, but if you can answer it later. You said that it's easier to conclude DTAs because it's a separate chapter and it might take longer to conclude an FTA. Now, my question there is there such an urgency to conclude the DTAs, and why is it a problem when the FTAs take longer? It's better to have a more broader framework rather than focusing on DTAs. So, I mean, it's just a question that I had looking at your presentations, but we'll go to Chris Jonghyun Park, who's a partner at Lee & Go in Korea and an old friend of mine. I hope he's online. If you can put him on the screen, at least so that we can see his face before he starts his presentations. Our friendship goes over 24 years. That shows how old we are. He has a peculiar career, having worked at 4 different executive branches. He's worked before joining Lee & Co. He used to be in the prosecution service, Ministry of Foreign Affairs, Ministry of Foreign Affairs and Trade, Ministry of Trade and Industry and Energy, and the Ministry of Justice. So today he will be sharing Korea's experience, but as you have seen, we have heard what the objectives are of these DTAs. So if you can maybe focus more on the components of the DTAs, that would be appreciated. Thank you. Chris, you have the floor.
Thank you, Jason. I thank the Korean Ministry of Justice, Incheon Metropolitan City, and UNCITRAL ARCAP for having me speak at this seminar. It's a pity that I can't be with you on site due to other commitments. In this presentation, I would like to share Korea's experience with digital trade agreements from a legal perspective. Please understand that due to time constraints, I will omit the presentation of some of slides I prepared. Digital trade agreements have made various developments in terms of form and content. Initially, provisions on or chapters on digital trade were inserted into trade agreements. Since then, they have recently been concluded as a standalone agreements. Originally about e-commerce, it now covers data flow, protection of personal information, server location, source code, AI, fintech, and the digital economy. While early digital trade norms were mainly cooperation provisions, more recently, binding obligations have been increasing. These are examples of the chapters on e-commerce or digital trade in the FTAs or RTAs. Korea-US FTA Chapter 15, Electronic Commerce, CPTPP Chapter 14, USMCA Chapter 19. As mentioned, there are some standalone agreements on digital trade, such as US-Japan Digital Trade Agreement, Digital Economy Partnership Agreement, Australia-Singapore Digital Economy Agreement, Korea-Singapore Digital Partnership Agreement. Early digital trade provisions focus on e-commerce, as you can see. However, digital trade agreement has expanded to include provisions for digital trade or digital economy, such as cross-border transfer of information by electronic means, location of computing facilities, personal information protection, and so on. Now, let's move to look at Korea's digital trade agreements. Korea's 13 FTAs or RTAs have an individual chapter on e-commerce, starting from Korea-Singapore FTA, leading to RCEP and Korea-Israel FTA recently. Now, key features of e-commerce chapters in Korea FTAs are as follows. There is no custom duties on electronic transmissions, and there are some common elements such as definition of a digital product, electronic authentication and electronic signature, paperless trading, personal information protection, and online consumer protection. And non-discriminatory treatment of digital product is not so common in the chapters of Korea's e-commerce Korea's FTA. And cross-border information flows is provided for only in Korea-US FTA. So in terms of content, Korea-US FTA Chapter 15 may represent other Korean FTA chapters on e-commerce. Korea's digital trade agreements are evolving toward comprehensive agreements for digital economy. Korea takes a multi-layered approach for the negotiation of digital trade agreements. So bilateral, plurilateral, and multilateral digital trade agreement negotiations concluded or are in progress. Korea-Singapore Digital Partnership Agreement, KSDPA, entered into force early this year. Korea's DEPA accession negotiation is recently concluded. IPF Pillar 1 negotiation in progress, and WTO JSI on e-commerce negotiation in progress, as you know. And there's some new elements added, such as cross-border transfer of information by electronic means, location of computing facilities, and so on. So these are the current digital trade agreements of Korea, Korea-US FTA, Korea-Singapore DPA, and DEPA. Let's compare the elements of Korea-US FTA Chapter 15 and KSDPA and DEPA. As you can see, the Korea-US FTA is a fairly early model. So the number of provisions is much smaller than that of KSEPA or DEPA. So the cell in blue is the key provisions of Korea's digital trade agreements from my view. Yeah, it's my brief presentation for Korea's experience on digital trade agreement. Thank you.
Thank you, Chris. I think you actually highlighted the next point that I'm going to ask Sibaram to present on, because you see that the digital trade agreements has a lot of broader scope than the e-commerce chapters in FTAs. That's for sure. Now, there are so many different elements there that getting on the table and agreeing on what the common elements are, what the convergence areas is going to be a difficult thing. Now, we've also seen a number of bilateral agreements. We've seen some of the multilateral or regional agreements, but your experience now is going to be a challenging one as well. Just to give a short introduction, Sibaram is the head of the Digital Economy Division of the ASEAN Secretariat, and his key role is to influence digital policies and implement digital initiatives that would increase the trade and investment across the 10 ASEAN countries. And my question to you is actually in your presentations, can you touch upon the proposed ASEAN DEFA, or the Digital Economy Framework Agreement, launched by the ASEAN Economic Community on 3 September, so it was like 2 weeks ago. And what do you think the elements would be, looking at all the different approaches that you have seen in the region? Thank you. Sibaram, you have the floor.
Thank you, Jay. A very good morning. As been introduced by Jay, my name is Sibaram. I'm from the ASEAN Secretariat. I head the Digital Economy Division. And one of the key areas that I'll look at is the Digital Economy Framework Agreement that I'll be talking to in the next few presentations. Now, before I start, I think it's good for me to do a quick introduction about what is ASEAN or who is ASEAN is all about. So ASEAN is a political and economic union represented by 10 ASEAN member states from the Southeast Asia countries, and soon, just a matter of time, for Timor-Leste to join ASEAN, hopefully in another 1 or 2 years. How big we are? In terms of land size, we are 4.5 million square kilometer. In terms of population, we represent 8.7% of the world total population, which is equivalent to almost 700 million people. ASEAN also is very diversified, multicultural, and we have more than 1,000 languages being spoken. So you can imagine how diversified it is. Now, what is interesting in terms of economic growth, ASEAN contributes more than $3 trillion USD of combined regional GDP, which makes ASEAN the 5th largest economy in the world. Now, as we all know, a bit of digital transformation, the pandemic has actually accelerated digital transformation globally as well as in ASEAN. So if you look at some statistics, right, from a period during the pandemic and after the pandemic, from 2020 to 2022, ASEAN has 100 million new internet users. As of last year, 2022, we have 460 million total internet users, and 80% of these 460 million, they are digital consumers who are involved in some form of digital transaction over the internet. What is more exciting, based on the DEFA study, Digital Economy Framework Agreement, done by the BCG Boston Consulting Group, the value of digital economy as of last year is already surpassed more than 300 million. So that's a huge amount of transaction that we are talking about here. So, to understand, to further accelerate the digital transformation, this is where the leaders in 2021 got together and they actually adopted this document called the Bandar Sri Begawan Roadmap. And this Bandar Sri Begawan Roadmap, they consolidate many of the key ASEAN digital initiatives. But one of the key initiatives that you can see on the red font is for ASEAN to go on a digital-only agreement or a digital-only trade agreement. right? And we call it, there's a different names here, but it's all the same. So we call it a Digital Economy Framework Agreement, in other words, DFA. Now I'm going to skip these next two slides. I think this has been extensively covered by the rest of the speakers. So let me just go straight to what the moderator asked about. What are the key elements that's covered under DFA? Yeah. So before that, DFA, the study commenced sometime earlier of this year, right? And the study was endorsed in August by the economic ministers, and the DFA negotiation was launched on the 3rd of September this year as well, right? So in DFA study, there are a few elements that has been covered, which will be negotiated without prejudice by the ASEAN member states, which is the 10 ASEAN member states. So I'm just going to quickly run through. These are some of the elements that will be brought into the negotiation table, and again, without prejudice, is subject for the negotiation by the ASEAN member states. So number one is one of the key elements or area that we are going to negotiate is digital trade and cross-border e-commerce, right? Now, when you talk about digital trade for ASEAN, it's very much on exchange of electronic documents. So we have ASEAN single window. We have successfully exchanged the custom document, which is the E-Form D, Atika E-Form D, or Certificate of Origin. We are embarking into exchanging agriculture-related documents, which is the E-Phyto and E-Animal Health and so on. And we are also talking to our dialogue partners in terms of exchanging electronic documents. When it comes to cross-border e-commerce, as been presented by Laura earlier, we do have ASEAN Agreement on Electronic Commerce, which was signed in 2019 and entered into force or start implementation in 2021. So moving forward, as we have done a lot in digital trade, what we are really looking at is how does ASEAN single window can evolve in terms of technically to be connect to other dialogue partners, namely Korea, Japan, US, and the China, right? How can we make it more interoperable? I think that's number one. Number two, as we've been very focused on custom document and agriculture document, we also know that the private sector plays an important role, and therefore there's a lot more documents, electronic document that can be exchanged. So I think this is something that will be brought into the table to be further negotiated. Now, for digital trade, one of the key negotiations that will take place, no matter how good big technology or good technology you have, if your legal regime does not allow for you to exchange electronic document, then we have an issue. So this is where the UNCITRAL model law, especially on the MILTA, electronic transferable records, will be negotiated by the 10 member states on the adoption of this UNCITRAL model law. Yeah. Now, number two, the other element, the second element that we've been negotiating is digital payment and e-invoicing. First of all, e-invoicing, we understand from the study that different ASEAN member states are at a different stage of implementing e-invoicing. Some has already started, some are still on the planning stage, doing studies and so on, right? But what will be negotiated, regardless which stage you are now, right? It has to be interoperable so that we can connect among the ASEAN member states and also dialogue partners. Digital payment, we have done pretty well for the last few years. In 2021, we actually implemented a real-time retail payment system where Thailand and Singapore linkage went live. As we speak now, there are a few other bilaterally has been done between Singapore, Thailand, Cambodia, Vietnam, Malaysia, and Indonesia, where the real-time retail payment system, the linkages has been linked. Now, what you see now is one-to-one. So where we are heading towards is a bilateral, where it's many-to-many. And again, whatever we do, it has to follow international standards and it has to be interoperable. And these are the things that will be negotiated in DFA without prejudice. Yes. Number three, I think this has been spoken widely by the other speakers in the previous session and this session as well, digital ID and authentication. Now, under the e-commerce agreement, it has already been agreed by the ASEAN member state that an interoperable electronic authentication and signature will be implemented. So that's fine. But what is new here is the digital ID. When you talk about digital ID, we are talking about two things. One is your personal ID and one is your business ID. At this point of time, we are very much focused on business ID. A study has been done and endorsed by the ASEAN ministers in August. So we are also looking at making sure that when you negotiate, making sure that when business ID is implemented at a national level, it has to be interoperable, and very important, their legal framework acknowledge this business ID, right? And when you do cross-border, it has to be interoperable and to also adopt international standards. Number 4 is online safety and cybersecurity, right? I think ASEAN is also embarking into establishing something called ASEAN Regional Computer Emergency Response Team. This is something that will be negotiated during the DEFA, which we will enforce, saying that this ASEAN CERT need to be established, right, at the regional level as well as at the in-country level, which serve a purpose of 2 things. Number 1, when there is an incident, a cybersecurity incident, this is where all the 10 ASEAN member states will come in and see how do we tackle the incident. Because when an attack happens, it does not recognize borders. Right? As we are all interconnected, it aims to go to one border to another border and even to other countries. So that is why you need to have this group of team to come in and respond immediately to tackle the issue. Number 2, when you talk about cybersecurity, is ever evolving, right? There's a lot of things that need to be learned. So this is where the capacity building, the knowledge sharing, and so forth will come in when it comes to cybersecurity. The other element that will be negotiated, and this is not something new, right, which is cross-border data flows and data protection. ASEAN, we do have our own guidelines, which is the ASEAN Data Management Framework, which Singapore leads it, right? And this is basically a guideline for the industry. How do you really protect your data? And when you talk about cross-border data, we have these model contractual clauses for cross-border data flows. Now, these frameworks or guidelines and whatever we have developed is all voluntary. So we noticed that the adoption has been quite low. So when it comes to DEFA, probably we might negotiate to make this as a compulsory. We do not know. But when it comes to data, also we've been negotiating, and we will negotiate in DEFA on some sensitive issue, things like data localization. How do you treat cross-border? What kind of data that allows to cross-border in terms of commercial, some government data which is sensitive, and so forth. So this is quite sensitive, but this will be negotiated at the DEFA without prejudice. Now the last 2 is number 1, the second last is digital talents and mobility. Digital talent has been quite new. It has been, has been implemented by ASEAN. We work very closely with private sector. They come in, they provide content, and they provide training program for MSMEs to adopt digital technologies. What is new here, and again is a bit sensitive, is digital mobility and temporary movement of people in selected skills areas. I think the devils are in the details, right? So when you talk about who should mobilize, the immigration should recognize this. So devils in the details, so we should really go into the detail, what kind of skills that we recognize that it can be mobilized temporarily among the ASEAN member states. Last but not least is the emerging technologies. I think this has been widely discussed in DEPA, DE, and so on. Over here, we are very much looking into of corporation level, right? So to legally bind among the AMS, those who are more advanced in area like AI, blockchain, to come and train or capacity build those who are less into this. Yeah. So in summary, these are the few elements that will be negotiated, right? Now, again, let me just put my clauses here. This is without prejudice, right? The owners are the ASEAN member states, which we can see here in this hall as well, right? So this will be negotiated, and hopefully the negotiation will start by end of this year, sometime Q4. And according to the economic minister, the direction that we received, that we need to conclude the negotiation by 2025. So we are quite ambitious, and hopefully we can do it soon. Now, in closing, I think what is very exciting, when we started the DEFA study, the first thing we asked, what kind of economic value can we gain, can ASEAN gain by going into digital economic agreement? So earlier I presented, as of now, digital economy is already worth 300 to 400 million. Now, assuming if we don't do anything, we just sit down and naturally, organically grow, digital economy will be a $1 trillion economy by 2030. So this is where, but if you go into a DEFA, a forward-looking DEFA, what you say is future-proof DEFA, right? And this will double the value of digital economy of ASEAN from 1 trillion to 2 trillion, and that's exciting. And that's all why we are here. The ministers are exciting, and hopefully we be able to successfully negotiate our DFA by 2025. Thank you.
Thank you, Sivam. I just wanted to pick up on your point about without prejudice to the ASEAN nations. So the DEFA negotiations does not prevent ASEAN nations from concluding DPAs with other economies, or does that have an impact on their authority to conclude other agreements? And what happens with any bilateral DPAs between the ASEAN nations?
Yeah. So when we did the study, we have actually scanned through all the bilateral agreements. So we have the DEFA, DA, DEPA, and extensive engagement has been done from a bottom up. We engaged with the private sector, the big private sector, mainly MSMEs. More importantly, we spoke with all the ASEAN member states who already had the bilateral agreement. So it sits on top of the DEPA and DEFA. It's not something new that we are creating, right? But the scope can be bigger, right? For example, a lot of a digital-only agreement does not talk about digital payments, right? But we are going to talk about digital payments and so on. Doesn't talk about talent mobility, but these are the areas that we are covering. So it's actually complement with other agreements. Yeah. Now, when I say without prejudice, right? Because the study actually only looks into what kind of areas, elements that need to be negotiated and why. So the what and why is clearly stated. How and to be negotiated, it all depends on the readiness of the ASEAN member state and how are they with the willingness and so on. And that is the process that we go through. Yeah, thank you.
Yes, that's kind of the end of the presentations, and that was a very useful development that we're hearing. I don't see any questions on the Zoom, and I'm aware of the time. We do have 3 minutes left, but that is blocking us from our lunch. But I do have prepared some questions, more of like related questions that I would like to pose to the presenters. But if there's any questions from the floor, please raise your hand and we can take those as we actually ask those questions to our fellow panelists. So my first question goes back in the reverse order as we had started. My first question goes to Sibram. Do you think the number of DTAs will continue to grow? And what would be the main challenge that ASEAN faces in negotiating DFA?
Well, so I would take a position, yes, it will grow simply because technology evolves very fast. There are new issues that you need to deal with, right? There are a lot of problems that when it comes to digital that you need to solve. And therefore, whatever we are going to negotiate in DEFA in the first phase, it depends on the outcome of the negotiation, right? I foresee that as technology grows and new issues comes in, there will be phase 2 and phase 3, an upgrade version. What will be negotiated? It could be an extended scope within the existing element, right? Now, digital trade, you have an additional element to negotiate, or an entirely new element to be negotiated. So in short, I think it will grow. The hurdles is always been, it's different when you go into a multilateral agreement compared to a bilateral, one-to-one compared to many two. So we are talking about 10 ASEAN member states, and the readiness of these 10 ASEAN member states varies, right? From the policy, from their regulation, and so forth. So therefore, the readiness, because of the readiness, I think that would be the biggest challenge on how fast can we move, the depth that we can move, and how ambitious we can be. Right. I think these are some of the challenges that we have to face based on their readiness. Yeah, thank you.
Thank you, Sibram. I think I'm going to go to Chris. I know that you had some slides also referring to UNCITRAL standards being mentioned in the DTAs. Now, we also said that there is the rule-based, that the DTAs need to have some rules embodied in them, and reference to UNCITRAL standards might be necessary, and that's why we have the model laws. My question is to you, Chris. Now, if you do commit to these model laws, that does not mean that the model law itself is implemented. There has to be a domestic implementation of these model laws into domestic legislation. How does that usually take place, since you've been with the Ministry of Justice? If you can share with us your experience on that, and possibly how you see the UNCITRAL text being referred to in the DTAs more in the general perspective. Chris?
I will share my slides with you about the question. From my research, some UNCITRAL instruments meet with digital trade agreements. The first example is CPTPP that's provided for an obligation to maintain a legal framework governing electronic transactions consistent with the principles of UNCITRAL model law on electronic commerce and the UN Convention on the use of electronic communications in international contracts. And it is followed by USMCA, USJDTA, Singapore, Australia DEA, and DIPA, and so on. From my observation, the more recently concluded, the more the UNCITRAL rules refer to. And from Korea's perspective, Korea-Australia FTA Article 15.4 and Korea-Vietnam FTA Article 10.4 also provide alike. And Korea-Singapore DPA Article 14.7, which is for domestic electronic transactions framework, provides that also referring to UNCITRAL instruments and DEPA. These digital trade agreement provisions provide a regulatory power for UNCITRAL instruments, even though they don't have the power itself. Regarding domestic implementation of UNCITRAL instruments, for example, the Ministry of Justice and the Financial Services Commission take charge of the implementation of the UNCITRAL Convention. There may be some other examples, but I will quit my answer. Thank you.
Thank you. I think the question that we have from the Secretariat is, of course, it's good to have reference to the UNCITRAL text, but we'd like to see how they are actually implemented domestically after these commitments by the member states or the states to the DPA. Luca might have a question on this later. I would like to go through the questions. And now, if you look at the digital trade agreements, if you look at the websites that actually promote DTAs, the first thing that they say is it supports businesses. Now, the question to Laura is, without it, does that mean that the business cannot survive? And that actually goes to back to my question about the urgency of the DTAs. Is it really that urgent to have DTAs to support businesses in engaging in digital trade? And a follow-up question is, yes, it helps businesses, but does it also help consumers? Could you possibly respond to that?
So the question is, do you need DTAs to support businesses? So I think how it works in terms of DTAs is there has first to, so DTAs are negotiated between countries. And again, the progress of the DTAs, even though I've mentioned that if you're comparing DTAs to FTAs, FTAs tend to take longer because there are more chapters. But that's all things being equal. So the terms of how the DTAs are to be negotiated and how long it takes very much depends on the level of development and also the readiness of the negotiating parties. So when it comes to the newer disciplines and emerging issues, definitely a consensus may not be as easy, and it will still take time in order to find a common landing zone. So with the commitments in the DTAs, and assume that the DTAs have been finalized and signed, this has to be translated to domestic legislation and domestic laws and regulations. So negotiating DTA is not the only challenging part. So countries need to ensure that the domestic legal framework is able to implement the commitments. So the implementation of DTAs, therefore, depends on the readiness of the specific country as well. So can businesses operate without DTAs? Yes, you can. But I think in this age, especially in the context of digital, it's seamless, it's borderless. We are looking at new and emerging technologies, that there has to be, at least when we interact with each other as between countries, some form of alignment, consistency, and perhaps, and definitely compatibility. It may not necessarily go to the level of harmonize, but definitely there has to be, the cooperation has to be rule-based. So I think that's where the importance of DTA comes in. Then the next question is about DTA is seen as benefiting businesses. What about consumers? So I think the benefit of DTAs can be accessed from two perspectives. One is the specific provisions that are contained in the agreement that directly relate to individuals and consumers. And these provisions often seek to build trust and confidence, such as provisions on personal data protection, consumer protection. And more recently, I think we're beginning to see provisions relating to digital inclusion. And of course, there are also provisions on unsolicited commercial electronic messages, cybersecurity. And I think these benefits both businesses and consumers. And for businesses, definitely cross-border alignment and consistency would need to be there in order to enable and facilitate innovation, especially when it comes to newer and emerging technologies. It's about strengthening trust and confidence for them to be confident enough to engage in cross-border trade, to do transactions that are interoperable, and of course through standards that are consistent. And of course, it's also about cross-border data flows. And what's also important is about avoiding legal fragmentation. So in the bigger context, then what can DTA deliver? I think negotiating parties have to be very conscious about deriving tangible and inclusive outcome through DTAs. I think DTA should seek to accelerate digital transformation, increase adoption. It's also about promoting innovation. And ultimately, the bigger benefits is about economic prosperity for the region and for the countries. It's about job creation, and of course, increasing in income as well. So that's why that concludes my intervention.
Thank you. I think that's a big picture policy questions that they engage in DPAs to actually bring in this economic prosperity. I think that's the general policy objective of negotiating a DTA. Now, you mentioned legal fragmentations, and my next question goes to Alex. Now, in my everyday life, I actually deal with ISDS reform, and one of the biggest challenges that we have is these bilateral investment agreements, which are over 2,500, which are all different, and therefore very difficult to attack or address. Now, we've seen bilateral DPAs being developed. We've seen regional DPAs being developed. Do you foresee the possibility of a multilateral agreement on digital trade? As you had mentioned, we had the reference to convergence. Is that something where we're heading to? Or because of the difference in the readiness of the different economies, are we not going to see a multilateral instrument that actually covers all these aspects to address the fragmentation concerns that I might have? So on that point, and since you've been involved in the WTO negotiations, maybe you can give us a little bit of an insight on that aspect.
Thanks, Jay. I mean, I guess I'd say we certainly hope so on the multilateral, or I guess in the case of the JSI, a plurilateral agreement on digital trade. I think, as I've mentioned already, this is one of our top priorities in terms of our digital trade agenda from an Australian point of view. I think, and the latest update, we're working towards the goal of substantial conclusion of negotiations on the JSI by the end of this year or potentially early next year, but in either case, sort of ahead of the next ministerial conference. I've heard from colleagues that we've got multiple rounds of negotiations scheduled before the end of the year with the aim of that substantial conclusion. To give you an idea of, so in those negotiations, we're aiming for sort of commercially meaningful outcomes on issues like trade facilitation and consumer protection, getting into areas like, you know, e-contracts, e-signatures, paperless trading commitments, and so on. We certainly think it's important, as digital trade continues to grow, that it's really important that we seize opportunities like this to make progress on global rulemaking on digital trade to promote a free and fair model of the digital economy. So those negotiations have been going on since 2019. It's not the longest, certainly not the longest negotiations in WTO history, but we're hoping that we can reach substantial conclusion soon. I guess I'd say what's the benefit of that versus, you know, bilateral or regional agreements. WTO negotiations obviously have the big benefit of bringing in a much broader range of participants. A lot of the agreements we've been talking about today, you know, either sort of in our region or with North America and Europe, but the WTO negotiations will bring in a much broader range of participants. 89 members are taking part in those negotiations, and they cover 90% of global trade. We've certainly made a lot of progress in bilateral and regional agreements, but I think we share concerns about fragmentation of rules, and about wanting to try to establish at least a baseline for digital trade rules. Obviously, you'll have different perspectives in bilateral agreements, especially with like-minded partners. You can get into a much broader range of issues and cooperation, but I think it would be really meaningful to establish a baseline of a lot of, especially around sort of trade facilitation issues with that much bigger number of countries, and that will help, I guess, make global trade sort of more seamless across a much bigger range of countries. So that's where we see the huge benefit, and that's why we've been putting so much effort into those negotiations. And I think I'd also just make the point that we think it's also important for the WTO itself to be involved in this area. This is amongst the most significant rulemaking efforts currently underway in the WTO. And I think reaching an agreement and having this plurilateral agreement will be certainly important to demonstrate the WTO's continued relevance to global rulemaking, especially as the digital economy is growing.
Thank you. We have about 5 minutes left, and before I ask my final question to Kay, I just wanted to see if there are any urgent questions from the room that we should cover. Yes, can you just introduce yourself and then maybe very quickly the question that you have to the speakers?
Thank you very much for the speaker's excellent presentation. My name is Don Lee. I'm working for Korea Trade Network, which is the national paperless trade provider in Korea. I have one question to Mr. Silvaran Supramanian. I'm very sorry for my poor pronunciation. My question is, you mentioned a lot on Asian single window. And KTNet is very interested in this Asian single window linkage between two systems. First, my question is, ASEAN single window is a real hub platform, or it's just a conceptual model to link within the member countries? So under the control of ASEAN Secretariat, do we have a real hub platform or not? That is my first question. And second is regarding what do you say, your remedy to handle the digital divide between member countries. As you see, 10 ASEAN member countries, there are, in reality, there are a lot of digital divide between the member countries. So how to deal with that kind of digital divide to facilitate digital trade? Yeah, thank you.
Thank you. Let me just collect the questions and pose my questions to Kay so that we can actually end in time for our lunchtime. My question to Kay is actually, we have the FTAs and now we have the DTAs. So which ministry actually negotiates these DTAs and upon what kind of an initiative? And I think Laura did touch upon this on the need for different agencies and ministries involved in these DTAs. How do you coordinate that? That's my question to you. But that's also a question to, we have a question to Sibram from one of the guests. And I have a question to Alex and Laura, in the sense that DTAs are also about, it is about market access. It's about enabling market access, but you have not faced any kind of resistance as you have faced with regard to FTAs. I was just wondering whether this is going to be an issue that you think will rise, whether civil society would actually have some hesitations about countries negotiating DTAs. This is just a general question. We're running out of time, so 38 seconds each for each speaker and a very short answer, please. Kay.
Sure. In Singapore's case, it's very easy. It's all Ministry of Trade and Industry. All the other agencies and ministries will support our MTI in that regard. And there's it really takes a village, yeah? It really takes a village. And I just want to add that these DTAs or DEAs are also an opportunity for governments to embark upon more collaborative efforts. So for example, in the Singapore-Australia Digital Economy Agreement, as Alexandra mentioned, we signed 8 MOUs, one of which was an MOU project that I was responsible for. And in that, we orchestrated with businesses, with government orchestration, to really show them the kind of the implementation of certain digital technologies that could help them. So it was really bringing it to the businesses, and that was really quite different. Thanks.
Thank you, Alex. 30 seconds.
I'll be really quick. I guess in my time working on these agreements, I haven't come across a lot of public pushback on some of these rules. Like you say, it's about trade facilitation rather than the market access, because obviously sort of market access agreements around goods and services in FTAs also applies in most cases to e-commerce and digital trade as well. I think where there is potential for some pushback is around issues like privacy, consumer protection, those sort of the trust articles that we talk about, and I think that's why that's why we see it as really critical to include those articles in these agreements.
Right. I would like to add to what Alexandra has said. Again, I have not come across protests in my experience on FTAs, but definitely I think it goes back to my earlier statements about the benefits of DTAs has to be accessed in a very holistic manner. So I think it's about promoting digital inclusion. We have to ensure that all layers of society benefit from the DTAs. So DTAs, of course, it's about creating an environment of trust and confidence to enable and facilitate businesses to achieve commercially meaningful outcome. But definitely it's also about tangible and inclusive benefits for everyone. It's about driving digital transformation, is to ensure that everyone stands to gain from the advancement in digital economy. So how do we then achieve that to take into account all these different interests? It's about engagement, it's about consultation, and it's to be ensure that we, as the government negotiates, interests of different segments, different parties are taken into consideration in order to be able to then balance the various interests.
Thank you, very persuasive. We do have Chris, so I'm going to give Chris the last 30 seconds if he has anything to add. Chris, anything to add?
No.
Thank you.
Okay.
And then Siram, so this digital divide and the ASEAN context, very shortly, if you have any responses to that.
So very quick. First of all, the first question is ASEAN single window. Is it a conceptual or real? I'm not sure the definition between real and conceptual, but it's actually a real system. It's a centralized system. So what happens is every ASEAN member state, they have their national single window, which is owned by the customs, which connects to the other like ministries and also agencies, the traders and financial institutions and so on. And from here, the electronic exchange document happens at the ASEAN single window as a centralized application, which is interoperable among the AMS. Right. Happy to discuss this more. I think to know what is the question is all about and why the question is coming up. The second is digital divide. Now, digital divide, I think there are two angles you can look at. Number one, do you have an access to internet? I think that's very critical. This, I think, under the ASEAN Digital Master Plan 2025, we talk about digital infrastructure at the rural areas. We also encourage private sector to invest in rural areas to make sure that those who are in the rural area have a basic access to internet for them to do some transaction and so on. Number two, you have the access, but you're not using it or you do not know how to use it, right? I think this is two things. This is where a lot of MSMEs training happens. Like I presented earlier, we have the SME Academy, right? And we also have Go Digital ASEAN, where we train these MSMEs for them to participate in digital and also to embrace in digital technologies. Thank you.
Thank you, Siram. Before I close, Kay wanted to take the floor for 20 seconds. Yes?
Sure, thanks. Just wanted to add on to Laura and Alexandra's point. I think given the nature of the DTAs, there's a fair amount of preemptive sort of stance that we're taking as well, in recognition of the fact that the technology does change very fast. But really the aim is to remove barriers or to prevent the formation of barriers, whether visible or invisible. And all because when it comes to digital technology, technical fragmentation is sometimes just as harmful or as it will increase costs, as much as legal fragmentation or other forms of fragmentation. And so I think that's what, and that's why we're trying to get it out there before the industry, goes off in the wrong direction. Hence the word guardrails. Yeah, thanks.
Thank you. Thank you all for joining us on the 30-minute crash course on digital trade agreements. I hope you've had a nice time actually understanding what DTAs are and how the states are negotiating these DTAs. So with that, I'd like to ask you to join me in thanking the speakers for the wonderful presentations that they've been able to give. Thank you.
Thank you to our speakers for a thought-provoking discussion on digital trade agreements. Before we break for lunch, we would like to invite our moderator and panelists to take a group photo. Could our in-person speakers kindly approach the stage? One, two, three. One more time. 1, 2, 3. Yeah, thank you very much. We will now break for lunch and return at 1:30 with a lunch highlight on the environmental impact of paperless trade. Lunch boxes, including vegetarian options, will be served to your table. Please remember to keep your personal belongings with you and feel free to look at the rolling slide deck featuring this event's program, as well as information on our e-learning modules and newly published taxonomy of legal issues related to the digital economy. For participants who have just joined us, welcome to the second day of the third Incheon Line Business Forum. Kindly note that we are currently on a 1-hour break for lunch, and the next session will begin at 1:30 Korea Standard Time. Lastly, we would like to request the virtual speakers of the upcoming panel to return at 1:15, so we could test your connections during the last 15 minutes of the break. Thank you.
Ladies and gentlemen, welcome back. I'm Tracy Choi, legal expert at UNCITRAL RCAP on secondment from the Department of Justice, Hong Kong Special Administrative Region. It is my great pleasure to be the event moderator again for the afternoon session of the forum. Before commencing with our final panel event, I'm pleased to introduce today's lunch highlight event, which is a 30-minute session exploring the environmental impact of paperless trade. We have two speakers with us online in this session. It is my pleasure to introduce you to our first speaker, Dr. Jan Duval. Dr. Duval is the Chief of the Trade Facilitation Unit, Trade and Investment Division of the United Nations Economic and Social Commission for Asia and the Pacific, ESCAP. Since joining ESCAP in 2002, he has designed and delivered capacity building programs and advisory services on trade policy and facilitation throughout the Asia-Pacific region. He currently leads the activities of the United Nations Network of Experts for Paperless Trade in Asia and the Pacific, and has been instrumental in the creation and development of the Asia-Pacific Research and Training Network on Trade. Thank you for joining us today, Dr. Duval. I will now hand over to you. Thank you.
Thank you very much, and I hope you had a good lunch. It's quite early morning here in Geneva. I'm very happy to join you online, although I would have preferred to be there in person and visit Korea. In fact, I'm attending the WTO Public Forum, which is on trade and environment specifically, so I think we are quite on topic. So thank you to UNCITRAL and the government of Korea for inviting me to speak a little bit about paperless trade and the environment. Let me share my presentation. I will try not to bore you during your lunchtime or your after lunchtime. Let me see if I can share my screen. Here we go. All right, I think we are all quite aware about the climate change crisis at this point. I was just reading the news this morning, and again yesterday in Libya there was a major flood killing about 2,000 people at least as of now, and so a lot of those natural disasters can be quite straightforwardly linked to the climate change crisis. The number of those natural disasters is increasing as the climate becomes less predictable. So the overall message on this is really that some things need to be done to reduce CO2 emissions, but that is not going to be free, right? It has a cost. There is a cost to doing this, to reducing CO2 emission, to taking action on climate, but that the cost of taking action is much lower than the cost that globally would be incurred if no action was taken. And so that's why I think we all want to stress the importance of taking action on climate change. And paperless trade, digital trade facilitation is actually trade digitalization is really one way in which action can be taken. So we've done a bit of research on this. I will tell you more about it now. A lot of the work that we've done on this started in 2021 as part of the preparation of this flagship report on accelerating climate smart trade and investment for sustainable development. So you can all find it online. And we've done online courses on the basis of this report. We just did finished the third run, I think, yesterday in collaboration with UNCTAB and UNEP, and it's very successful course and material. So how can trade and investment related policies be more climate smart and help address climate change? This is really what the question that is addressed in that report. So I don't have time to go through the whole report, and I want to focus on paperless trade. But I just thought that it was very important to highlight at least the complexity of the relationship between trade and the environment, right? Because that relationship is just very complex. Right? So I wanted to mention that there are really 5 effects that linking trade and CO2 emissions and the environment more generally that have been identified in the report. And so you can think about direct effects between trade and greenhouse gas emissions. For example, when you transport things, when you do the trade procedures, there is emissions of greenhouse gas emissions, CO2 emissions. So that's a direct negative impact in the sense that you create new CO2 emission, trade creates new CO2 emission. There's a scale effect, which is in a way the largest one, which is simply due to the fact that trade creates economic activity, creates economic growth. And so as a result, as of now at least, right, when you have more economic activity, you have more economic growth, you have more greenhouse gas emissions generated. Then there is also a regulatory effect, which is really the effect on trade of adopting different climate-related policies and environmental policies. And so here you can think of some countries who are actually adopting very strong climate-related policies to reduce CO2 emissions. So in this case, this is going to probably decrease trade. And so potentially decrease trade or make trade more environmentally friendly, less carbon emitting. So because of this, this is a positive effect. But in many other countries, you may also see that countries, to gain a competitive advantage, will actually relax their environmental policies, and as such become pollution heaven. And so this will negatively affect CO2 emission generated. A fourth effect that you can think of is what we call the composition effect. So this is a bit more complex one, but this is really related to the greenhouse gas emission associated with production structure of and the production process. And so when you think about it, there's a lot of people who seem to say that, okay, the best way to reduce CO2 emission is to stop international trade and to produce at home, things at home instead of producing things very, very far away and shipping them to home. But actually, this is in many cases, this is not a valid argument because in many cases, some production, your home, that is not well structured to actually produce a particular good. Maybe it's better to produce that good very, very far away and ship it, and the net CO2 emission that would be generated will be much lower than if you try to produce that good at home. I mean, one typical example of this is agricultural products. If you try to produce, if you produce lamb, for example, in New Zealand, you use very extensive production techniques that actually reduce, don't emit a lot of greenhouse gas emissions. Okay, so it's worth shipping it to other parts of the world rather than trying to produce lamb, for example, for consumption, right? In your home country with a very intensive production process that will emit a lot of greenhouse gas emissions, right? And you can find a lot of examples like this. And so that composition effect is also very important. And then let me end with the fifth effect that we identify between trade and CO2 emissions and greenhouse gas emission is a technique effect or technology effect, right? And this is really about trade ability to spread climate smart products and technology. With international trade, you can gain access to solar panels, for example, that are not produced everywhere in the world. And so because you can use solar panel, you can access solar panels, you can reduce your CO2 emission in your own country thanks to trade. So I think that's something that is very important. So just wanted to do those very introductory remarks before I get into paperless trade. I hope I'm not taking too much time. So now on one of the recommendations, right, of the report, one of 10 or 12 recommendations we have in the report, is to accelerate trade digitalization. Essentially because we find indeed that there is a very positive link between accelerating trade digitalization, accelerating paperless trade, implementing paperless trade, and the environment. So this is based on research we've done at ESCAP and is now published in a peer-reviewed journal. And the context for the research is really that is the climate change crisis, in the sense that if you look at the Sustainable Development Goals, there is progress made across all the Sustainable Development Goals in Asia and the Pacific, but not on the climate goal, right? If anything, there is a reduction in progress towards the climate goal in Asia and the Pacific. And that's a concern, and that's why we need to do more research on that as well. Another element of why we're doing work on this is because of the framework agreement on facilitation of cross-border paperless trade in Asia and the Pacific. And I think you've heard about it already this morning or yesterday, and Republic of Korea is a champion of that framework agreement. And then beyond that, I mean, I think there is a lot of research. It's very well recognized that trade facilitation has important economic impact. Right? It's reduced trade cost. It's good for trade. It has an important. It's very good for inclusiveness as well. It makes it easier for everyone to engage in international trade. So trade facilitation, trade digitalization is something that is very well known in that regard. But the environmental impact of trade producers hasn't really been tracked or quantified. And so what we find in our study is that fully digitalizing a single end-to-end trade transactions, right, going from relatively paper-intensive processes in many parts of the world to a electronic trade transaction process, and is that reduce emissions significantly. And so for every electronic trade transactions, right, that you have, instead of a paper-based trade transactions, you have emission saving equivalent to those that can be captured by 1.5 trees, right? Trying to put a little bit of image in this. So for Asia Pacific, talking about emission savings amounting to about 30 million tons of CO2, which represent about 400 million trees planted for the region. And if you scale this at the global level, you're talking about 1 billion trees. And so another interesting results we find when we try to calculate this is that the results are driven by the efficiency gains from handling the data digitally, rather than directly by the direct savings in CO2 emission from not using paper or not using ink. So I don't have a lot of time to go through the study in detail, but if you're interested, you can take a look. But there are different channels we identified through which implementing paperless trade affects greenhouse emissions. So one is elimination of physical documents. The other one is replacement of physical delivery of those documents for signatures, which is something that is very prevalent still in many countries. And then we have reduction in productive hours, so all the office work that needs to be done because the documents are in paper. And also another channel is reduction of storage time, storage of cargo that needs to wait for the paper documents to come and be prepared before they can move across borders. So I'm not going to skip a little bit of the methodology, because I'm not sure that's of interest and we don't have a lot of time. But let me move to just to highlight that at the end of the day, also we try to be very, very careful in estimating the savings, and we actually probably underestimated the savings. We make strong assumptions throughout the study because of the lack of data. And this is something that needs to be addressed by everyone, right? For example, we use emission factors to link a specific process or a specific item like paper to CO2 emissions. Those emission factors actually will vary a lot depending on the country and the situation, the climate, the situation, or whatever. For example, even the paper used, right, is different from country to country. And so the CO2 emitted in producing that paper is different from different countries. So, and this is true for absolutely every process and everything that is there in the study. So the results are very much exploratory, but I think they really make the point that it's important to move to trade digitalizations because it does have a significant climate change mitigation benefit, at least on a per transaction basis. And this is one thing I want to also highlight. On a per transaction basis, trade digitalization is very beneficial for in terms of mitigating climate change. At the same time, you have to realize that if you facilitate trade, you digitalize trade, you also have the scale effect that I mentioned at the beginning that is kicking, right? Maybe more trade will happen. If you have more trade transactions, potentially you'll also have more CO2 emission emitted, right? So this is something to keep in mind. At the same time, it's also important to put the benefits of paperless trade for climate change in the broader context of other sources of emissions. And in the trade context, there is no question that transport emissions, international transport emissions, is really the big piece of the cake here that needs to be targeted, right? So global emission saving estimates from paperless trade implementation represent only 1.1% of the emissions from fuel used in global supply chain. So there's really a big effort that needs to be done on transport digitalizations and transport decarbonization. We're doing more studies in this area, and there is a need for more, including cases in Bangladesh that extend beyond actually CO2 emissions, but generally they confirm so far the importance and potential to reduce environmental impact, including CO2 emissions through trade digitalization. And so I think, I mean, there is a big focus to law, right, in this in the event you're attending here. And so at the end of the day, how does that relate to law and international rules, right, on trade policy? In fact, there is a lot of agreements that are being negotiated or that have been negotiated that include digital trade and e-commerce provisions in Asia and the Pacific. And so international law on digital trade is likely to continue to evolve quickly. So I guess one of the messages is to ensure that digital trade is also sustainable trade. So I think how do you integrate some of the environmental dimensions, the CO2 emission dimension into the digital trade and e-commerce provision and digital trade agreement that is emerging would be something very important. Let me stop here. Thank you very much.
Good morning. Can you please hear me?
Yes, we can hear you.
Yes, perfect. Yep. Thank you very much for the introduction. I apologize, but I had some audio issues and couldn't listen to the introduction of the moderator. So first of all, I would like to thank UNCITRAL and the government of Korea for hosting the event and for inviting the United Nations Economic Commission for Europe to contribute to your event, to your seminar. So very briefly about myself, because I didn't hear the introduction. I'm Maria Teresa Pisani. I'm officer in charge of the Trade Facilitation Section at the United Nations Economic Commission for Europe, based in Geneva. And at our Trade Facilitation Section in UNEC, we service the United Nations Center for Trade Facilitation and Electronic Business, which within the UN family is the body that develops norms and standards for sustainable and digital trade facilitation. I'm also leading a global multi-stakeholder initiative on green and inclusive value chains in critical sectors for the circular transition, including agri-food, textile and leather, and the critical raw materials. And in this area, particularly, our working party develops recommendations and standards for information exchange to track and trace compliance with environmental, social, and good governance standards along the entire value chain, end to end, from raw material extraction to processing to branding and retailing of products on final markets. Now, let me start by briefly recalling the urgency of climate action. My colleague Jan Duval has been briefly mentioning about that, but in my speaking notes, let me mention that certainly, and as we can see on the news more and more every day, climate change is not a distant threat. It's happening right now, and it's affecting certainly the way we conduct international trade. Rising temperature, the extreme weather events, the shifting ecosystems are actually disrupting supply chains, and this causes economic stability and, of course, jeopardizes livelihoods of millions of people around the world. Now, the rapid surge in CO2 emissions, primarily driven by human activity, is the catalyst of climate change, and addressing the this critical issue demands, of course, immediate and concerted action at the regional and at the global scale. In terms of impacts of the trade, the transport, and logistics, let me give you very few points to put things in context. Almost 70%, 3/4 of global greenhouse gas emissions come from energy consumption. Another 18% from agriculture, forestry, and land use, 5% from industrial processes, and 3% from waste generation. All these areas, of course, are connected to the trade and transport and logistics, which makes this sector, of course, very critical to the urgency of the climate action, since it's a significant contributor of greenhouse gas emissions. Now, the logistic industry responsible for the movement of goods globally heavily relies on transportation, energy-intensive processes involved in warehousing, in packaging, in distribution, also further contributes to carbon emissions. And inefficiencies in supply chains and issues such as excessive packaging, over-reliance on single-use plastics, long-distance shipping causes certainly long-term environmental challenges. Now, what are possible solutions? Of course, there are reports, Economic Trade in Transition 2023 report, which highlights the importance of reducing climate impact of trade and logistics through nearshoring practices, the rerouting of supply chain to nearby countries, often with shared borders, or regionalization, which has increased by 8% points, and the reshoring, which has also increased by 8% points since the two last decades, certainly promises to have important impacts in terms of decrease of CO2 emissions. Another important solution relates to introduction of trade facilitation measures, among which is the transition to paperless trade. Actually, research shows that greenhouse gas emissions can be reduced up to 80% due to efficient trading procedures at the border. Of course, I mean, as Jan was mentioning, by eliminating the need for physical paper documents, we reduce environmental impact of paper production, which consumes a vast amount of energy and water. And additionally, paperless trade streamlines processes, accelerating information exchange between trading partners and cutting down transportation needs. So this lowers emission associated with lengthy and cumbersome documentation processes. Of course, an important aspect to keep in mind is that paperless trade comes with an increasing amount of data storage. And there are increasing body of research from the International Energy Agency, for instance, mentioning about greenhouse gas emissions produced by data storage. Data centers account for almost 2% of global electricity use, which has repercussions in terms of CO2 emissions. Now, how can we enable solutions to promote climate action and support implementation of paperless trade? What are we exactly doing here at the United Nations Economic Commission and its UNCITRAL? Well, we, since the last 60 years, have been developing an important body of norms and standards in support of semantic interoperability on trade and logistics. Hence, different computers and systems can use them to exchange data and therefore enable paperless trade and paperless trade transactions globally and regionally. Another important body of work that we are conducting at UNCITRAL is this initiative for tracking and tracing environmental, social, governance risk and impacts along the value chain, including CO2, the monitoring and the measuring of CO2 emissions of value chain operations. It's an end-to-end value chain approach, starting from raw material production through the processing and then the placing actually of products on markets. In particular,
sorry for interrupting at this moment, but the time of our session is almost up. I shall be grateful if you can wrap up in around 30 seconds.
Yes. Well, just I was about to wrap up. Thank you very much for the reminder. Just wanted to mention about this ongoing piece of work at UNEC and the development of this information exchange standard that enables measuring and computing CO2 emissions along value chain. And implementation of specific use cases that we are doing with major brands and retailers at the global level to enable that measuring on specific products. We have at UNEC a team of specialists that works specifically on these aspects, and experts are invited to join this team of specialists on ESG, traceability and transparency value chain, which regularly meets and supports the implementation of this work. Thank you very much for your attention.
Thank you, Ms. Pisani, for your interesting presentation. Before we conclude this special highlight event, would our speakers please keep your cameras on for a moment longer for a screen capture? Yes. We shall be grateful if the screens of both Mr. Duval and Ms. Pisani can be put up on the screen. Yes. 1, 2, 3. One more. 1, 2, 3. Perfect. Thank you so much, Dr. Duval and Ms. Pisani. So we will now be commencing with our last panel session for today. The Law Track 3 session will take the form of a roundtable discussion on the topic of digital trade law reform and the promotion of UNCITRAL tests in Asia and the Pacific. May I invite our moderator and in-person speakers to take the speaker's seat in front. It is my pleasure to once again welcome Mr. Luca Castellani to facilitate this session. Luca is a legal officer in the Secretariat of UNCITRAL in Vienna. As Secretary of Working Group 4, he oversaw the preparation of the UNCITRAL Model Law on Electronic Transferable Records and of the UNCITRAL Model Law on the use and cross-border recognition of identity management and trust services, and has assisted several countries in the enactment of UNCITRAL tests on electronic commerce. Luca is also actively involved in the field of sales law, where he promotes participation in the UN Convention on Contracts for International Sale of Goods and has coordinated the preparation of the UNCITRAL HCCH UNIDRA legal guide to uniform instruments in the area of international commercial contracts with a focus on sales. Luca, thank you again for joining us. I will now hand over to you. Thank you.
Thank you, Tracy. And I have to add to your kindest introduction. I have next to me my colleague, dear friend, Soo-Yeon Kim. I worked quite a bit also in the region with ASCAP for the framework agreement on the facilitation of cross-border paperless trade in Asia and the Pacific. Maybe one of the things that you got from UNCITRAL is this favor for adopting legislation with very long name, because we also, our treaties have very long names. So the purpose of this roundtable is quite simple, but at the same time, I do not recall easily a similar occasion. We have discussed for 1.5 years from different perspectives the promotion of law reform in digital trade. We focused, the main topic is how to transition from documents to data. Yesterday we were talking about certain documents that now are very popular, if you may say so. We call them electronic transfer records. When on paper we call them transferable documents or instruments, or we call them documents of title. Anyway, we have heard a lot about this. And this morning we heard more about the transition to data, the transactions in data, but we also heard about the bigger picture, that is to say, regional trade agreements, plurilateral and bilateral digital economy agreements. And I have to say, if this forum were a book, we would have written all the chapters. So, you know, but it's not a book, it's a live event, although it's recorded and it's available on demand. And so now we have a roundtable on how to operationalize what we were discussing. This is, of course, a regional forum for Asia and the Pacific. And we have here not less than 7 major players in the field of digital trade law reform. Some of them focus on law reform, some of them have a broader mandate, but they have a legal component. From the UNCITRAL perspective, I would like just to say 2 things. The first one is we are particularly active in the Asia and the Pacific because the UNCITRAL Regional Center for Asia and the Pacific, which is the main organizer of this event, is here precisely to promote the adoption and the uniform use and interpretation of UNCITRAL texts, including texts on electronic commerce and digital trade in the region. And on top of it, UNCITRAL is not only the core legal body in the United Nations system when it comes to matters of commercial law, international business transactions law, if you wish to say so, but also has, in the field of the digital economy, a central and coordinating function which has been acknowledged also by the United Nations General Assembly. And so we see more and more other organizations not only partnering, but also giving confidence to UNCITRAL to carry out certain tasks in the field of law reform, and we are very grateful for that. And we do our best to make sure that we keep the clients happy and they come back to us. So our first speaker, this roundtable is set in a format of exactly of giving the floor to our 7 participants. We have 2 here, 5 online, and basically the 7 participants were asked to answer to 2 questions, which they may, if they wish, they can answer both of them the first time they get the floor, then they don't get the floor again. But if they can get the floor twice, the first question is, introduce yourself and your organization and explain to us why your organization is relevant for this discussion and what kind of tools are offered, because this is exactly, especially for states, to see what is available out there and how they can take advantage of this. And then the second question will be to share a little bit best practices, but also lessons learned in this business. And for each question, they have up to 5 minutes. So I already introduced Soo-yeon Kim from the SCAP Secretariat. Please, Soo-yeon, you have the floor.
Thank you very much. My great appreciation to UNCITRAL, not only because they are one of the organizers, but also like UNCITRAL has been very instrumental in pursuing the digital trade matters in Asia Pacific. So we have been collaborating with UNCITRAL on every stage from the early stage. So throughout my sharing, I think UNCITRAL would come quite often. So I, under the full belief that I would have the second round, so I just focus on the first question. So on cross-border paperless trade, I've been conducting several projects for the past 6 years in mainly LDCs and LLDCs, and through supporting and implementing the framework agreement on facilitation of cross-border paperless trade in Asia and the Pacific, which is a long name, as Lucas said. I'll briefly mention that in my second round of responses, but basically speaking, all the government officials as well as experts from Asia Pacific, under the umbrella of the framework agreement, has developed this readiness assessment for cross-border paperless trade. This has resulted in a collaborative mechanism with SCAP, UNCITRAL, and EIF, creating an online guide, which is an interactive guide to really support any self-assessments from the countries on readiness assessments, both on legal and technical aspects. It also resulted in again, a collaborated output by ESCAP, UNCITRAL, and WTO. It's a toolkit which is based on the assessment and the guide. And it is meaningful because from the Asia-Pacific dialogues, we were able to reach beyond Asia-Pacific, and this one with the global outreach. We really are trying to be a frontier in this regard, together with UNCITRAL and other partners, on what we can really provide some supports for the member states within ESCAP, but beyond. So if I just briefly show you what we have done since 2019 in terms of readiness assessment, there has been 18 national readiness assessment studies completed. As you can see, it's a mixture of sub-regions: Central Asia, Southeast Asia, South Asia, and the Pacific. As I've said, we are reaching beyond Asia. So Mexico has been the first non-Asian countries to conduct the readiness assessment, supported by ECLAC, and they are planning for more. We also, because the readiness assessment has been conducted initially in 2019, we have conducted 3 updates in Bangladesh, Nepal, and Timor-Leste as well. As I have stressed, it is an assessment of both legal and technical aspects of it. And what we are getting out of these assessments is a basis for the countries to really see where they can further work on. So it has recommendations and individual action plans that the countries can pick up. How they utilize it, I will address it in my second round. And then just to briefly share with you additional resources that we are sharing with our member states as well as global. We have a experts network called UNX. They have been instrumental in us pursuing the agenda, supporting the government and intergovernmental discussions, really enriching that discussion. We also have cross-border paperless trade database. Timmy sitting right next to me, we have been collaborating with ICC on establishing this database, as well as we are expanding to different matters, including MLETR adoption. So, and then as Jan, my chief has said, we have been looking into the environmental aspects of the paperless trade as well. We have the model provisions, which is covering the RTAs for trade facilitation in times of crisis. So that goes back to the previous session that we were discussing before lunch. Also, I did receive an email from yesterday's session whether there are any certificates given for participants. So we do have online courses. All of them can be taken self-paced, and then we will be providing the certificates. This has been quite useful in terms of, like, for example, we are a bit of celebrities in Bureau of Customs in the Philippines, because they are actually using this BPA, Business Process Analysis online course for training the new officials from the BOC. So we do not limit our audiences to the government officials, but our primary target is government officials, and we have been using these online courses as well as these support researches to really support the evidence-based policy making in digital trade in the Asia Pacific. So that's a brief introduction of what we do in ESCAP, and I'll share more at the second round. Thank you.
Thank you, Suyeon. Tianmi Silfen, ICC Digital Standards Initiative.
Hi, everybody. Good afternoon. Oh, that was very loud. Wake up. Hi. My name is Tammy Stilfen. I'm from International Chamber of Commerce Digital Standards Initiative, abbreviated as ICC DSI. Can you please? Oh, sorry. Don't worry. Self-help. Yeah, okay. Wow. Once they appear, ICC DSI aims to accelerate the progress of development of a globally harmonized, digitized trade environment, and as a key enabler of a dynamic, sustainable, and inclusive growth. We are what we call a public-private partnership. We are a global initiative based in Singapore, but, oh, here we are. We are a public-private partnership, global initiative based in Singapore, backed by an international governance board comprising of International Chamber of Commerce, the headquarters of based in Paris, and Asian Development Bank, as well as Enterprise Singapore, and World Trade Organization and World Customs Organization. We have senior officials from all these organizations giving us and setting the direction, strategic direction for us to proceed as our agenda. We engage with the public sector to progress regulatory and legislative reforms through one of our vehicles is called Legal Reform Advisory Board, comprising senior officials from key international organizations such as World Bank, IFC, multilateral development banks, including ADB, EBRD, who you will hear from later on the panel, other MDBs covering different regions of the world, including CARICOM, Commonwealth, Inter-American Development Bank, IADB, and also African region. So anywhere that you can think of, we try to engage them through our network and really tap into that market to make sure that this is a global initiative where all countries who are involved or aren't involved in this process yet are a part of this progress moving forward to really embrace this digital future for the world. We engage and mobilize the private sector through our other vehicle is called Industry Advisory Board to make sure that they are realizing the standard setting and operationalize capacity building and other deliverables of the key agenda for ICC-DSI. But I'm here today to talk about legal reform. Our technical assistance is really twofold, where the first facets focus on the legal reform. I like how, she said, we're very thankful for UNCITRAL. We're truly thankful for UNCITRAL because I could say that our dedicated love for Moderator is shining through since this is really the only job that I do. My job is usually either advocating for Moderator or finding people to advocate for Moderator. So if without the Moderator, jobless, so very thankful. We have this very loyal commitment to push only this legislation or this model law everywhere in the world. So the legal reform aspect, we are, excuse me. We offer a comprehensive support through the very inception of the moment that you feel like either through this event or through other avenues that you learn about Malaysia and you feel like your country would benefit from this initiative that we get. You can reach out to us or we reach out to you through whatever channel that we engage you from the moment that you find this likable. And then we provide you with an extensive arsenal of resources from a roadmap, because a lot of the questions that we get is, we like this, but where do we start? What is the first step to do this? We are in the process of developing a roadmap where we are telling people, the first step is always to find the right group of people, either through a working group or through a coalition. But it is something that really reflects the cross-sectoral nature of this whole initiative, not only because of paper documents, but also because the entire nature of trade is very complex. From the second panel of today that we heard, we're involving over 17 agencies. And that's the experience that we've had engaging with different governments, because from Commerce Department to Justice Department, and then to Foreign Affairs and also Internal Revenue Services. Anything that you can think of is probably involved in this somehow. I will dive into it in my second part of the presentation. But from first step to how do you prepare the market as a second step, and where do you go after that? What is your media campaign going to look like? And where do we start involving the industry? And all those questions that we're trying to answer with the roadmap and really giving people a guide to chart the course for this alignment process. And the second product that I'm very proud of is that we have a Moderator toolkit. I realize that you and NASCAP have something very, very similar. That what they have, you probably can find a similar one here. Not to sound competitive, but our goal is to champion the Moderator alignment globally. I know they're trying to be a frontier, but this is something that you can find on our website as a part of the Moderator Toolkit. We have developed a tracker tracking individual nations' adoption or alignment progress. All those things that you see on the screen. Do I have a laser? I don't have a laser. If you see Moderator compatible, there's a square outlining it. That means it's a hyperlink. So anything that you can find a hyperlink, there is the official legislation that they have made it into a domestic legislation. In the second panel, we heard even if with a commitment through an agreement, you still need to have a domestic legislation. So each of those 1 to 8 from Bahrain to United Kingdom, you will find how and also the exact text, legislative text of how they incorporate into their domestic legal system. And then following that will be in progress. All of the countries based on the information that is known to DSI is reflected on this tracker. You'll be able to find it on our website. It is also in the process of being revamped into a more elaborative and also interactive version with UNASCAP to make sure that this is gonna be updated more frequently because this is now a PDF version, although hyperlinkable, but you can't really interact with it. Once it's revamped, it will become a map with a lot of, you will see the region, and once you hover your mouse over it, it will pull up all the information related to the process you're seeing, say like socialization, what does that mean? And also political support, from which agencies have we gotten the support from? All those very detailed information will be available on the revamped version. And also coming up, we have an FAQ session. FAQ not to have a section where people go on the website before emailing us, please read this. That's not what this is for. It is for you to have this in your pocket when you're lobbying your government or any kind of agency. Some of the questions are frequently asked. So something is operating in our country, why do we still need law? What kind of numbers are we looking at to unlock the potential of digital future? So all those questions that we're giving you a answering guide to make sure this process of advocacy is smoother. And same thing with their certificate program. We also have an e-learning course. It is completely free. Moderator 101 crash course module within our certificate in digital trade strategy. And not to steal the spotlight of UNCITRAL too, but this is going to be something easier to digest and comprise something that we have been trying in the last year to do capacity building in person. It is only a few of us. We can't really travel to all places at the same time. We want this to be on demand. We want it to be available to everybody who is interested and to be able to rewatch, because it is pretty course heavy. When it comes to in-person capacity building, you'll have really legally heavy content that sometimes is hard to digest, and I will really benefit from rewatching and rewinding.
Tianmi, the timekeeper has a conflict of interest. I have to ask you to stop, but I want you to continue praising Melita.
The subtle reminder is received. All right. So the roadmap would look like something that's more fancy, but it's in the process of making. And I am actually, second part of our technical assistant focuses on providing an enabling policy environment, because this is it provides the essential structure for legal reform to land. So to make sure it's not only acknowledged in theory, but also it is executed in actual practice. So through that, we actively participate in in-person or remote capacity building programs around the world to make sure that we are engaging with the public sector to make sure that they have an understanding of what MOETR is, and also a realistic expectation what comes when they're starting to get interested in this alignment process. And in this advocacy process or capacity building process, I will proceed into it in my second part of the presentation. Thank you for the time.
Thank you, Tianmi. Now we have Nigel Chen from the Asian Development Bank. Thank you.
Thank you, Luca. I hope everyone can hear me. So thank you, Luca, and thank you also to UNCITRAL for giving me the opportunity to speak with you today on the ADB's work in the area of digital trade law reform and the adoption of UNCITRAL texts, in particular, Melita. My name is, as Luca said, is Nigel Chin, and I'm a principal counsel in ADB's Office of General Counsel. So I think my colleague Stephen Beck gave to you some opening remarks about what ADB is and the work we do. So in addition to our lending and other activities to sovereign and non-sovereign entities, we're also a knowledge institution. And in that regard, we're a thought leader and advocate in a number of areas of importance to the global economy and the world at large, such as climate change, poverty, environmental and social issues, to name but a few. And of course, the reason why we're here today, and that's the digitalization of trade. So why do we think that's important? Well, ADB's recently updated Trade Finance Gap Survey, which I think came out last week, estimates that the unmet demand for trade financing, what we dub the trade finance gap, currently stands at $2.5 trillion. And this is up from our last estimate of $1.7 trillion in 2020. As we believe that trade drives development and growth, this begs the question, what can be done to bridge this enormous gap? Well, ADB sees that the digitalization of trade is a key component to reducing the trade gap by breaking down barriers and making trade more inclusive and greener. And that in turn, UNCITRAL's model law on electronic transaction records is a key instrument to enable the digitalization of trade, because as you've heard over the past day or so, Melita enables a strong legal framework to recognize electronic transaction records both domestically and across borders. It encourages technological neutrality and, of course, interoperability of ETRs across different systems. And because of this, in late 2022, we launched a Melita advocacy program that's available to our DMCs around the Asia Pacific. But before I want to get into that specific program, I want to take a quick step back and just talk about more generally about our work in the digital trade law reform space, which I kind of crudely group into two different categories. First of all, our general advocacy work and our specific work in select DMCs, which is related to the advocacy project I just mentioned. In terms of our general advocacy initiatives, one of the key portions of that is that, together with the ICC and the government of Singapore, ADB was instrumental in helping establish the formation of the ICC Digital Standards Initiative. And you've just heard a bit of the work that the DSI does through from Tianmi's presentations. In addition, as a thought leader, we regularly publish articles and papers on the importance of digital trade law reform. One of our papers that was published in 2021 emphasized the need for legislative reform in Asia to create an enabling environment for trade digitalization. And we'll soon be following up on this through the publication of a paper detailing Melita and the current status of efforts across different countries around the world to adopt or align their legislation with Melita. We also take the opportunity to advocate and educate on the issue of trade digitalization through various international forums that we're invited to participate in. This includes the G20, where we were asked to join the trade and investment group discussions, and we're also invited to join the group drafting the communique to advocate for the digitalization of trade and the alignment of legal systems with Melita. Of course, we have varying degrees of success in those forums for our advocacy of these initiatives. Similarly, we've also been invited to the next APEC meeting to speak to matters of trade facilitation and trade digitalization. So those are our kind of general efforts as a thought leader, but we also take a more targeted approach. And as I mentioned, we launched a Melita advocacy project in late 2022. And through this project, we work with select developing member countries to advocate for their adoption or alignment of their laws with Melita. A key part of this initiative is that we host capacity building events for our developing member countries. For these events, we try to bring together relevant experts from the public sector, international institutions, academia, as well as the private sector to both inform the public and private sectors players in the relevant country on the technicalities and benefits of Melita. We also endeavour to bring to these sessions the experience of other jurisdictions that have already adopted or aligned their legislation with Melita or are in the process of doing so that our developing member countries can learn about the thinking behind why a country decided to adopt Melita, the considerations and the thought processes they went through in the adoption, and how they plan or are implementing the Melita-aligned laws. And of course, we can't do that alone. And so in our capacity building efforts, we are fortunate to have the strong partners such as UNCITRAL, the DSI, ICC, as well as Singapore's Infocom Media Development Authority. Our efforts in these capacity building efforts have so far extended to Georgia and PRC, where for each country we've had a series of capacity building events. And I look forward later on to talking about some of the lessons learned from those experiences. And as well as Georgia and the PRC, we're hoping also to begin discussions with Cambodia on a series of capacity building events. In addition to this capacity building, we're also able to assist developing member countries in their actual law reform efforts through our law and policy reform program, which is run through the ADB's Office of General Counsel. And that comes in should the country decide to go forward and seek to actually adopt or align their legislation with Melita once they find out all about and what the benefits are. And in this regard, we're in the preliminary stages of working with Georgia on their law reform efforts. I'm looking forward to discussing more with you about through what we've learned through our work so far and discussing with the other panelists. So I'll stop there and allow Luca to hand over to the next speaker, and I look forward to speaking to you a bit further later in the session. Thank you.
Thank you, Nigel. Our next speaker actually is coming from, or is at the current time actually, in London, I believe in London. So we would like to give her a special thanks for getting up so early. I think it's 6:30 in the morning now in London. Vashti Maharaj from the Commonwealth Secretariat. You come from Trinidad and Tobago originally, but I believe, but of course now you are in London. Or I hope so, because otherwise it would be like really late night. Vashti, good morning.
Good morning and good afternoon to everyone. Thank you, Luca, for having me. Mindful of the time, so I'm just going to focus this morning on presenting an overview of what we do at the Commonwealth Connectivity Agenda, with focus on legal reforms, specifically Melita alignment within Asia and the Pacific. So what we are about, Commonwealth leaders adopted the Commonwealth Connectivity Agenda at Shogam in 2018. And our objective is to boost trade and investment links across the Commonwealth and raise intra-Commonwealth trade to $2 trillion by 2030. It's a very optimistic goal. So what we do is we focus on 5 key cluster areas by side. And these are the primary areas that we look at in building the digital economy. We do practical assistance through capacity building. We liaise directly with member states. We're responsive to their needs in terms of what needs to be done in building the digital economy. And we also support fact-based decision making. So we also conduct a series of studies, and like many of our colleagues, we also have a repository of digital policies and regulations. In our recently launched report on the quantitative analysis of the move to digital trade that was launched in 2022, we identified that digital trade facilitation across borders could increase trade by approximately 90 billion, and legal reform to support the digitalization of electronic records could unleash as much as 1.1 trillion, bringing the total benefits on paperless trade to nearly 1.2 trillion by 2026. So how do we go and move towards providing support and getting countries to cross that gap and digitize advisory supports in the implementation of national e-commerce strategy directly to member states that reach out and request assistance, such as the Kingdom of Tonga, Samoa. We do provide capacity building training, the legal reform and digitalization working group, and we also work on digital infrastructure and looking at regulatory coherence. And we have very recently, just last week, launched the Commonwealth Connectivity Cross-Regional Connectivity Grants Program. So I'm pleased to see that several of my colleagues that we are working with very well within the region are actually here on this panel and have been participating during the course of this business forum. We do have an upcoming capacity building workshop many of you may or may not be aware of that we're collaborating with the Pacific Island Forum Secretariat, ADB, and we do have other regional partners such as UNCTAD. And we are working on really focusing on what are the key legislative areas, many of which are aligned to what is put forward in Melita. We're looking at electronic transactions, payments and taxation, telecommunications, consumer protection, customs and cross-border management, data protection, cyber, as well as digital identity and authentication, because these are the key areas that member states have identified that they're looking at. And you find that, Luca, when we get into a discussion, we find that many organizations are working on providing support in these key areas to ensure that there's that degree of alignment and common standards across the board. At the recent Commonwealth Trade Ministers, we have a mandate to establish a working group on legal reform and digitalization to individually assist member states in taking that transition to paperless trade. And as a result of which the working group is looking at the identification of legal implications of transitioning to paperless trade, as well as consideration of the most appropriate regulatory frameworks, of which we are looking at alignment with Melita in terms of best practice standards, as well as looking at common standards that are led by DSI and OTME. You're doing a lot of great work in this area. We are also looking at the digital infrastructure in terms of physical infrastructure and how to bridge that digital divide. Later on this year, we will be conducting specific in-country training in Kiribati on the 6th to 8th December, and it will focus on leveraging digital infrastructure and regulatory coherence. But we're really going to take an in-depth look at good regulatory practices and principles and understanding the role of regulatory reform in building the digital economy and trade. And last, before I hand back over to you, Luca, we have recently launched the Commonwealth Connectivity Cross-Regional Connectivity Grant Program. How does that relate to legal reform? It really looks at peer-to-peer learning activities aimed at enhancing knowledge, building capacity, and enhancing expertise to increase and facilitate trade and investment. And what we have found in even launching this program and similar nature in Mauritius is that a lot of the knowledge exchange involves looking at how do we overcome regulatory gaps and hurdles. And we do look at Melita alignments as a best practice standard. As a result of which we're inviting member states within the different regions to look at enabling interventions and engagements, and that is currently open and it's closing on the 27th of October. So we look forward to seeing very good inputs and outcomes coming out of this initiative. On that note, I thank you, Luca, and I hand over to you.
Thank you very much, Vashti, and I would like to also thank you for inviting UNCITRAL. We will provide our contribution to your important event in October in Fiji, thanks to our colleagues in the regional center. We actually stay in London because our next speaker is also based there. Milot Ahma from the European Bank for Reconstruction and Development. And I have to say, while the Commonwealth were references to work in the Pacific in particular, I take it that EBRD will make references to work in Central Asia, which is a region that we have sometimes touched upon during this day and a half, but that deserves, of course, more attention and more resources. A very good early morning, Milot, to you too.
Thank you very much, Luca. Thank you, colleagues. It was a joy listening to the presentations by my colleagues from all the IFIs represented today. My name is Milot Ahma. I'm a counsel at the EBRD's legal transition team. The EBRD legal transition team is a team which is made up of about 20 lawyers, and we work since, I would say, I mean, the team has been around since the early 90s, focusing on legal reform essentially as a tool for improving business environments in the countries where EBRD operated. Now, the geography of EBRD was much smaller back in the day, but currently we operate in about 38 economies, and it's very wide ranging. So we do work in many European countries, but our mandate is also really has expanded in Northern Africa countries, but also as Luca just mentioned in Central Asia as well. So we cover all as the legal transition team, we cover all 38 economies essentially, and we work with our country authorities in improving in various legal reform areas. And in various areas of the economy as well, including financial law, corporate governance, dispute resolution, public procurement, etc. So I would say since the beginning, promotion of international standards was part of our work, where we really try to align the economies where we work, the frameworks there with the best international practice. But we're also a standard setter ourselves for a very long time, and this goes on today, where we've included our own model laws, especially around secure transactions regime. And in doing that, we really cooperated a lot with other standard setting bodies such as UNCITRAL, UNCITRAL, etc. So as part of our work and as part of our legal reform work, we do a lot of standard setting, a lot of actual legal drafting, but also training and capacity building and assessment of legal and regulatory frameworks and benchmarking them then with international best practice. We've in terms of digital trade, and again, let me reiterate that I'm at the legal transition team. I lead our work on access to finance and fintech. So digital trade, we've kind of fell more or less into our work on access to finance, because that's the prism, that's the angle where we of how we essentially look at digital trade, especially the Moderator. We're trying to look at it mostly from the trade facilitation angle, and then in that we cooperate with internal teams, our trade facilitation program and the SME finance and development team, essentially to bridge the policy work that we do together with our transactional work. But again, knowing that the Moderator's benefits are quite vast, we know that the adoption and implementation of Moderator will actually deliver way more benefits than just the trade facilitation area. We, as EBRD, we're part of the ICC Legal Reform Advisory Board. This is, I would say, where our engagement on promoting the Moderator started. And in April 2023, we published our own blueprint paper on digital trade and Moderator, where we wrote the paper in coordination with, in cooperation with CASL, which is an advisory firm based in London, working on mostly legal reform, and which we intend to use really as exactly that. The paper is intended to be used as a blueprint, as a guide for countries to essentially socialize and familiarize themselves with what Moderator is, and to actually use our experience working with countries and working their way in some of these new concepts and some of these new areas. Now, if you go and see, because I would say this blueprint paper is our main sort of resource now in terms of Moderator promotion. It essentially includes some tools for country authorities to have an idea as to how much work they would need to do, how much work they would have in front of them before they start reaping the benefits. We don't intend to go in these countries and say, this is Moderator. Once you adopt it, even if you adopt it as a model law, if you take it as a copy and paste version, your problems are going to be solved. We try to structure it in the form of building blocks, where we essentially show the interconnectedness of the Moderator's, the scope of the Moderator together with other areas, which include authentication but also crucially the actual substantive framework, which covers the ETRs themselves. So the negotiable instruments, if I were to mention one, is also covered by this matrix and this assessment tool that we embedded in our policy work, because we really want to first, before we engage anywhere, to actually get a sense of where they are currently and how much work is essentially in front of them, but also embed the vision of that country, how they see digital trade, what way, how do they intend to go forward in that area. So that's our main bit. I'm happy to append the link maybe in the chat because I don't have a presentation now for you to show, but you can, I would say, just Google it with a blueprint on Moliter and EBRD, and it's going to show. In our policy work, as I said, we work closely with transactional bankers to essentially socialize the concept with bankers, because if you mention Moliter, a lot of people are going to be a bit lost, not entirely sure of what it is. But I think since we started socializing it internally, a lot of people already know, especially the key relevant people who work on transactions, and we're trying to contribute on the transactional side, and we're already identifying some pilots where the legal reform work on Moliter would essentially benefit what we're trying to achieve on the transactional side, and the transactional side of work would actually rely on an environment where Moliter is actually working. We do cooperate with other IFIs, including the IFIs that are here, but I guess I will speak about that area in my second intervention, hopefully, if I get the chance. Thank you.
You sure will have a chance, Milot, and we look forward to finding out more, in particular, what you have in mind about, starting to operationalize. I remember I came to the launch of your initiative in this field, and there was also a nice report that was distributed on that occasion. Now we come back to the region, and actually not only, I believe we go to Fiji, where we have Andrea Iba from the Pacific Island Forum Secretariat. Andrea, good afternoon. How are you?
Good afternoon, Luca.
Please, you have the floor.
Thank you. Thank you very much, Luca. So, hello, everyone. I'm Andrea Iba, and I'm the Pacific E-commerce Coordinator for the Pacific Island Forum Secretariat. So I feel like I'm a little bit the one odd out when I see all the other speakers in the round table, since we do not specifically focus on legal frameworks or regulations or legislations. However, actually, the initiative for which I work for, so the Pacific E-commerce Initiative, is coordinated by the Pacific Island Forum Secretariat, and some part of the coordinator involves coordinating projects and programs by experts in the field, and then some part of the implementation of the Pacific E-commerce regional strategy and roadmap involves also some measures in the area of e-commerce rules and legislations. So as I just mentioned before, we basically act in two ways here: as a coordinator, as an implementation, and an implementer. On the coordinating part, we coordinate the implementation of our strategy, which is a regional strategy, and which follows the UNCTAD methodology for e-commerce. And this methodology proposes 7 priority areas. One of these areas is legal and regulatory frameworks, and deals with digital trade and reform. So through assessments and consultations, we discovered that work in this area is a very key enabler of e-commerce in the Pacific region. And for this reason, for example, all the Forum Island countries were found by the UNCTAD Global Cyber Law Tracker in a nascent stage of e-commerce legislation in the 4 core areas of e-transactions, consumer protection, data protection, and privacy, and as well as cybercrime. Another common challenge that we found and face here in the Pacific is in the absence of e-commerce content in the legal text of the free trade agreements, as well as the regulatory environment, which has limited awareness and use of technical standards that support e-commerce. However, probably the greatest challenges faced by the FICs, so the foreign island countries, in the legal and regulatory frameworks are the lack of enabling regulatory framework for e-commerce and the limited capacity of senior staff that is actively engaged in international e-commerce negotiations. And for this reason, we do coordinate very, very important work from agencies such as UNCITRAL, UNCTAD, and COMSEC in these areas. One example of maybe the importance of this of the intervention of UNCITRAL, for example, in this context, is the harmonization that they do thanks to the adoption of relevant model legislation, and this really facilitates a regional harmonization of legal recognition across borders and regional capacity building for Pacific negotiations. So we do believe that introducing e-commerce legislation is important to generate trust in electronic transactions, and that this trust will be maximized if legislation is harmonized. On the implementation side, we also take the learnings that we got from the assessments, and we did implement in 2022 an e-commerce rules for policymakers. This is basically a self-paced online course through 24 modules that cover topics such as electronic transactions, activities of electronic platform and intermediaries, competition, trade facilitation, business trust, data disciplines, consumer trust, and cybersecurity. It is a service, a product that we do offer to policymakers in the region in order to build capacity. And it's covered both at a very simple and superficial level, and as well at a deeper level, thanks to the participation of some experts in the areas. And here I need to thank again UNCITRAL, UNCTAD, COMSEC, and other colleagues who participated in these important lectures. So the first time we ran this activity was last year, but we will be a rolling activity. And for now, we do have 74 policymakers in the Pacific who received the certificates of completion after participating to the course. And this course is currently available on the Pacific e-commerce portal as a self-paced version, as I said, and it includes also other, like it's both as a visual in a visual form, so through YouTube videos, as well as PDF versions that mimic university lecture styles. So I think this concludes our two streams on e-commerce rules and legislations. Thank you.
Thank you, Andrea. And I would like to say, you started by saying we mostly do our things, although we coordinate, but yes, indeed, in the e-commerce work plan and the e-commerce strategy of the PIFS, the legal and regulatory is very much based on the adoption of UNCITRAL texts. So we are very happy to work closely with you and to deliver in different countries, but with our partners. We worked in Tuvalu closely with ESCAP, and now we go to an old friend of mine. I'm very happy that he could join us. He's actually working for UNCTAD. UNCTAD, of course, is a big player in business space with the e-trade ready initiative, with the e-trade readiness assessments. But Dominique, I think I saw him last time in Geneva. I believe now you are in Honiara, in the Solomon Islands. So it's not the same place where I saw you last, but I'm very happy to see you again, and you have the floor. Please tell us a little bit what UNCTAD is doing in general, but in particular what you're doing in Honiara.
Thank you so much, Luca. It's very nice to see you again, and nice to see former ESCAP colleague at the table as well. I'm actually joining from Fiji. I've been here about 2 years, and I'm leading UNCTAD's activities in this area under the Pacific Digital Economy Program. Yeah, I think my first reflection, just hearing the different speakers from ESCAP, the cross-border paperless trade readiness assessments, the work being done by the PIFs in the region, as well as the other speakers, it just strikes me how complementary all of our work is. We know digital trade is a big area. It's a cross-cutting issue that touches so many areas. So it's just really great to see that all of our work complements each other. So I think what I'll do is I'll just share a few highlights of UNCTAD's technical assistance in this area. And then I would encourage the member states joining in the room or online to reach out to the organizers if any support from UNCTAD could potentially be useful. So in terms of our technical assistance in the digital trade area, we generally provide it through these work streams. Luca had mentioned it, the e-trade readiness assessment. These are really diagnostic assessments that provide a starting point for countries to put in place regulatory reforms to better engage in and benefit from e-commerce and digital trade. These are one of our core products. And what we found is they really serve as an important policy tool. They provide a starting point to identify gaps in a country in many areas. And one of those areas is in the area of legal reforms, of course. What we oftentimes see is after a e-trade readiness assessment is carried out in a country, the countries then often request UNCTAD to provide assistance to develop fully fledged national e-commerce strategies. And these are a roadmap, a vision for countries to strengthen their enabling business, policy, legal, and regulatory frameworks to engage in e-commerce and digital trade. And we have a few other technical assistance work streams as there, e-commerce and law reform, which I'll get into the details in a moment. We also provide technical assistance to countries to strengthen their capacities to measure e-commerce and the digital economy. We know there's a dearth of data and statistics related to digital trade and e-commerce. And so we usually provide this assistance to NSOs, National Statistical Offices, to produce better, more reliable, and internationally comparable statistics on e-commerce and digital economy. The final work stream, we provide technical assistance to strengthen the capacity of women digital entrepreneurs. We do this through our E-Trade for Women initiative. We organize master classes. The most recent one was in Kuala Lumpur, where we did a week-long workshop for 30 women digital entrepreneurs to really provide them with the tools and knowledge to scale up their digital businesses. And just want to make a special note that all of the work that UNCTAD carries out, we do it in close collaboration with our E-Trade for All partners, including UNCITRAL, the Commonwealth Secretariat, the PIFs, the SCAP. E-Trade for All is a platform to better connect countries with development partners, providing assistance in this area of digital trade. We found it has been quite useful to maximize the impact of development partner support and to improve synergies. And just to give you a concrete example, I looked at the e-trade readiness assessments that we've carried out before this session, and almost, in fact, all of them recommended the adoption of the UNCITRAL model laws in various areas. So that's just an example of the great partnership and collaboration through E-Trade for All. I'll move through these quite quickly, but just to show you the geographic coverage of our, what we call the E-Trade readiness assessments. We have completed 35 of them at this stage, 10 in Asia and 5 in the Pacific. And I should add that the Pacific Island Forum Secretariat has also conducted E-Trade readiness assessment for countries, additional countries in the Pacific region following the UNCTAD methodology. E-commerce strategies, also wide geographic coverage, 5 in Asia, 1 in the Pacific, and we're currently supporting Fiji and Timor-Leste with the development of their strategies. As far as technical assistance specific to e-commerce and law reform, we provide this work through 4 main activities. We provide regional and national capacity building workshops. We know in some countries the capacity is still a little bit low. So for example, in Kazakhstan last year, we provided a capacity building workshop for the country to better understand the implications of the WTO JSI. And we also provide technical assistance in preparing and revising e-commerce related laws. We carry out regional cyber law reviews as well as thematic studies. The one we're conducting this year is related to the indirect taxation of e-commerce in developing countries. And finally, one of our long-standing products is our UNCTAD Global Cyber Law Tracker. And this is where across 194 countries, we track and note the progress along 4 e-commerce related legislations. I will skip a few slides. These are just examples of courses we provide, but I wanted to make sure that we show a couple of photos of our capacity building training workshops. You'll note our moderator there, attending our workshop on digital identity for trade and development back in 2019. So again, just highlighting the great partnership between UNCTAD, UNCITRAL, and our partners. Maybe just a sneak preview. One of the products that we're working on is a cyber law review for the Pacific region. It'll be quite an in-depth report on the status of e-commerce related legislation in the Pacific. And you can see here on the screen across a number of areas from consumer protection, intellectual property, online content regulation, et cetera, we can see where the gaps are. And this is, again, a great gap analysis where partners in the room, partners in the E-Trade for All initiative can use this as a gap analysis to already identify countries and specific thematic areas where potential technical assistance could be provided. This is my final slide for this round. Just wanted to highlight that our work is expanding in a certain way to be more regionally focused. We are part of a 5-year regional program called the Pacific Digital Economy Program, covering 11 Pacific countries, where we provide the technical assistance that I covered, but in a more focused aspect to countries in the Pacific, including the e-trade readiness assessments, the work related to e-commerce law reform, as well as national e-commerce strategies. We're grateful for the contributions or the support provided by the European Union, Australia, and most recently the government of New Zealand. And we do all of this work in partnership with UNCDF, UNDP, as well as my colleague Andrea, the Pacific Island Forum Secretariat. And this falls under the broader Pacific e-commerce initiative. So really my takeaway is that supporting countries with law reform in the area of digital trade is cross-cutting, and I'm heartened to see the complementary aspects of each of our projects and programs. And I'll leave it there for the moment, and happy to have an open discussion or a roundtable or move on to the next round. But Luca, again, thank you for the opportunity to share some information about UNCTAD's technical assistance. Thank you.
Thank you very much, Dominic. And now we have the second round. We'll have about 3 minutes for each speaker. But I believe that a lot has already been done, and I believe that not only the audience here is learning, but one of the major goals of this roundtable was to inform each other, the 7 of us. So I'm sure that there's bits and pieces that we were unaware of. So, Suyeon.
Thank you very much. If you can upload my presentation once again. I am proud to say we are partnering with most of the partners in this session, but yes, of course, I'm seeing the comprehensive picture. So thank you for the presentation from everyone. So as we are short of time, I try to be as quick as possible, focusing on challenges and lessons learned, referring to the good practices as necessary. So first of all, when we did the readiness assessments on the legal side, very commonly reappearing problems were obsolete and outdated laws. And it was actually ironical that some countries who were pursuing the digital trade on earlier periods were having this dilemma of they worked on it, but it has been obsolete. So the international national experts team, as well as other experts involved, have been really stressing the importance of drafting or updating based on the general principles. The general principles referred in the UNCITRAL model laws, and that has been referred, that was the basis for the framework agreement drafting as well. So whenever we refer to these law making or updating the laws, this has become a very common problems. And then our solution is really going back to the interoperability and neutrality of the technical neutrality and other general principles. The second challenges we had was lack of coordination. I mean, unfortunately, despite numerous attempts, it is very tricky to have this digital trade agenda forward at the national and regional and global level. One of the problems would be, many of you would know, if we would like to organize any intergovernmental or any working group meetings, the countries often would ask, like, who would be the leading agency? And there are numerous, and because it's cross-cutting, it's quite natural that several multi-agencies and stakeholders would be involved. But because of that, in practicality, it's really hard to pursue anything. So we have been seeing some countries who would like to pursue, but they are stuck at the public consultation, not even public. They are stuck at the consultation with the agencies stage because the other agencies are not responding, unfortunately, or whatsoever. So where we have the success at country level was almost always we had a champion or we had a leading agency. And that was the case in Tuvalu when we, ESCAP and UNCITRAL, were pursuing, and we successfully made it happen, acceding to the ECC as well as the framework agreement, CPTA. But that was only because the counterpart ministry, Ministry of Fisheries and Industries, were quite proactive on it. It is also true, like one good practice that we saw was in Philippines through the National Single Window Working Group. All of the discussions and any of the decisions to be made related to digital trade and cross-border paperless trade, it was more streamlined because they had that they still have very active National Single Window Working Groups. Thirdly and lastly, partnership. I mean, it sounds very generic and very non-brainer, but in reality, partnership is the key. And we are really glad to see this happening in several countries. For example, Bangladesh, we did the update of assessment in partnership with ADB, as ADB was initiating the SASEC Integrated Trade Facilitation Sector Development Program, which had a policy-based component. One of them was to have a roadmap in implementation of the framework agreement. Therefore, the legal and technical assessments as well as the action plan was really picked up and is being used for pushing the agenda forward. Timor-Leste, it's actually another good example. So we have been pushing for e-commerce law drafting with the support of ESCAP. World Bank has been leading, ESCAP and UNCITRAL has been supporting. And now with Dominic and like the project coming in, they are able to pick up of the work that we have been pursuing. So it is very interesting and very encouraging for me to see our sister agencies and partner agencies are picking up the readiness assessments and related activities that we have been pursuing and vice versa. So with that, just a 30-second introduction. So because we realize the importance of the partnership as well as the coordinating mechanisms. So as I have several times briefly mentioned, framework agreement on the facilitation of cross-border paperless trade in Asia and the Pacific. It's a UN treaty, and we have currently 11 parties, and Russian Federation actually submitted their, they just deposited about 2 weeks ago. So after 2.5 months, they would become a full party. So with 12 parties and dedicated to the cross-border paperless trade data exchange on legal and technical issues. So this is how ESCAP is pursuing and how we are trying to address these challenges in partnership with partners. Thank you.
Thank you, Suyo. Tianmi.
Thank you. A lot of the challenges I was going to address is already addressed by her. Synergy is actually very important, and also don't undermine the existing interest that is already going on in the country. So just because a lot of the parties may not have heard of Moderator doesn't mean that digitalization hasn't planted a seed in either the industry or government. Digitalization has been going on for like over 20 years. It's so long that you wonder why we're still here talking about this. But knowing that there's no perfect approach, a lot of people come to ask us, do you have a template for approach? Usually they're, to top to bottom, bottom to up, where you start with a grassroots and then lobby your interests up to your government. That is possible, but no matter which one you choose, top to bottom, you have ministerial declaration or DFA, a DTA or FTA, and then you can't avoid the cross-sectoral nature of this whole issue. Case in point, warehouse receipts, bills of lading, promissory notes, they're all oversaw by different government agencies. So it's not going to be something that you adopt this all these key trade documents with one agency. So one of the recommended approach sometimes is to set representative from each of the agency to have a comprehensive legislation to make sure that you don't have that fragmentation in your legislative domestic legislation. And also don't forget that no matter where you are in the process, we're here, ICC-DSI is here. We have a wealth of networks in the national committees of ICC. So wherever you are, I know that, Malaysia, Cambodia, all those countries that you're thinking, different chambers have their way of supporting. So not every chamber does the same thing, but definitely will provide you the resource that you may be missing. Also, getting everybody on board is important to know that this is not only a law or banking issue, even though we have the transport documents, we have the trade finance documents, you have shipping for forwarders, customs, everybody on board to make sure that this is going to be smooth. Otherwise, you're going to run into roadblocks everywhere you go. So we're here to smoothen the process, but don't undermine the synergy. And we will do everything that we can to identify all the legal barriers that is in your alignment process and remove them, and to achieve a Moderator compatible future.
Thank you. Nigel.
Thank you. I guess what I have to say just builds on what you've just heard from Soo-hyun and Tian-mi. I think that in terms of bringing the law reform to fruition, different countries will be starting at different points and at different levels of sophistication. So in terms of designing the capacity building to lead up to the actual law reform process, Tian-mi's right, no one size fits all. But I think to build on what Soo-hyun was saying, that there does need to be an internal champion, at least to bring everyone, to help bring everyone together in all the necessary stakeholders together from a country, whether they be, excuse me, from the public sector as well as the private sector, into the same room to learn, to be educated about Moderator and its benefits, or to educate others about Moderator and its benefits, if that's what we're talking about. Because as Tian-mi mentioned, at least Moderator, a lot of this digital economy, digital trade laws, they touch on a whole lot of different aspects, transport, customs, digital economy, foreign affairs even. It touched on a whole lot of different aspects. So you need a strong champion within the country to be able to bring all of these people together, because we as ADB or other institutions can only do it to a certain point. So I completely agree with the champion approach, the need for a strong domestic stakeholder, at least at the beginning, to bring all the domestic stakeholders together. And then, of course, in the legal reform process itself, there also needs to be a strong champion that could be different from the one that leads the capacity building events, because you could be using the capacity building events that we help coordinate to find that law reform champion, as opposed to the capacity building champion, if I can divide it like that. I think from from an organizer of these events, it's very important for us to make sure that we know our audience and the level of sophistication within that audience, so we know how to pitch the events at the right level and to bring the right people along to speak and present at these events. I guess that's really what I wanted to build on from our experience thus far, and it really just emphasizes what's already gone, what the two previous presenters have already said. Back over to you, Luca.
Thank you, Nigel. Vashti.
I would like to thank my fellow panelists for very eloquently outlining a lot of the key challenges. So I'm just going to present 3 of the key lessons learned. I'm mindful of the time. As you have highlighted, every country and region is at a different stage of its development. There's no one size fits all. And when we do look at promoting assistance and providing, capacity to promote legal reform, we want to do it based on each country's individual needs and each region's different needs. So from ComSec's perspective, and looking at building the digital economy, working with the Caribbean, they have different priorities. And then working with the Pacific, they have different priorities. Working with Africa and Asian regions, they have different priorities. But digital trade is a global phenomenon, and it therefore involves a lot of in-depth and focused attention to what are the actual needs of each country. Second area that we've looked at is that, when we use the term harmonization, it's a very idealistic approach. And in reality, what we're really looking at, more importantly, is greater legal alignment to allow for actual interoperability, because that is the key to global trade and really the essential building block in building the digital economy. And last, but certainly not least from our perspective, is that the right players are definitely in this room and on this panel. We do have a shared vision, as Dominic has very rightly pointed out, and Luca, you've underscored. We share common goals, and you'd find that in our presentations, we are doing a lot of work that is both complementary, but a lot of work that, address the same issues. And it's very important to work together in bringing the pieces together, because we're really looking at, assisting the same countries. So on that note, I'd hand over back to you, Luca, and thank you very much.
Thank you very much, Vashti. Milot.
Yes, thank you very much. I echo almost everything that was just said, and I think this also shows the coordination level among some of the players in this area, the IFIs, because I think we all have similar messages. I would say we most of us, and certainly I can speak of EBRD, we use donor funds to essentially implement these technical cooperation projects to assist countries in aligning their frameworks with best practices. But recently, these funds are becoming scarcer and scarcer. So we really need to think about ways how to make really scoring efficiencies where we can. And we can certainly, it's impossible for us both on the internal resource side, but again, on donor financing side to do a lot of projects at once. So we really have to, I think, step up even on the IFIs front, the coordination level, and essentially share the work that we do. But I think the country authorities also have a role to play in this, and that's to essentially prevent the overlaps of work between the various IFIs, because they're like our reporting to donors are really like our donors are very sensitive in these overlaps, where essentially the same or largely same pots of funding really used by two different organizations are used for the same thing. So we ideally like to keep our work separate, complement where possible, but ideally not overlap, especially in the same country. So I think country authorities, and we've had occasions where we really find out later in the day that similar, same IFIs have been working on the same project. And again, country authorities really have a key role to play, because they can use those funding in a more efficient ways. And again, I think speaking about efficiency as EBRD, really looking at the how much Molita really can benefit the economies, but also like the regions in terms of the trade and cross-border trade. There is a sense of urgency for sure, and that's why we don't really have, I think, the luxury of going and working on just separate countries, where possible. So we are really trying to see which regional, economic forums can be good or appropriate forums to pitch Molira. I think every organization here, including ICC and UNCITRAL, is doing the same to kind of pitch it at that higher level, so that then it trickles down to the country authorities and the work can be picked up a bit later, so that socializing effort is done at that level. On our side, the pipeline, especially on Molira, is still just at the beginning. We hope that we're going to have our first project this year, but again, we will continue to cooperate with all the IFIs to essentially make sure that we don't overlap on that, but we also count on the authorities and country authorities to point us and indicate wherever they have already established something with a certain IFI. Thank you.
Thank you very much. And now we go to our colleagues in Fiji. Andrea first.
Thank you, Luca. Well, thank you everyone for the very insightful discussion so far. I think probably where I would like to contribute just a little bit is to share our experience here in the Pacific in terms of coordination mechanisms. So as I was mentioning before, we are now focusing on implementation of a Pacific e-commerce regional strategy, and this involves a lot of players, over 20 implementing agencies that are implementing different measures across different dimensions. We found that in a place like the Pacific, that despite being relatively small in terms of population or also landmass, is actually incredibly vast in terms of geography. And we found that having a centralized governance body, such as a Pacific e-commerce committee, overseeing the implementation of this strategy and maintaining always a political will alive from the member countries, really helps supporting and delivering results. So what then we did, we then added 2 subcommittees to this committee, one for the private sector to keep the private sector perspective always present, and then one for the developing countries in order for implementing agencies as well as donor partners to have a dialogue and discussion on what should come next, what is their vision, and what plans do they have for the future, and then these will be then presented to the member countries. This has been working pretty well so far. However, we did think, observing from the experience, more of a global experience, what has been done, we thought to actually establish a Pacific e-commerce alliance. And this resembles very closely what UNCTAD has done with the E-Trade for All Alliance. With the difference that the focus will be at the moment on the implementation of this e-commerce regional strategy. And so the idea is to promote the strategy, but not only is to facilitate resource allocation towards its measures, and as well to avoid duplication and incentivize partnerships. So the members of this alliance are only implementing agencies. We're now reaching out to some of the main implementers of our regional strategy, and we're receiving a very good feedback so far. But the idea would be then to have very fruitful projects going ahead and put together work plans in order to know what is happening in the region, not only ex post, so not only when we actually do and develop our M&E framework, but even before, so ex ante. And with respect to this, I just will conclude with an example. Actually, as we started this conversation with the Commonwealth Secretariat, then we decided the Commonwealth Secretariat had an idea to have a workshop here in the Pacific for Pacific policymakers on the legal framework for the digital economy. And since we did have similar streams, and then UNCTAD had similar streams, and then ADB as well, we managed to put together our efforts. And now we will have in October a workshop of 3 days co-organized by these 4 implementing agencies under the same initiative. So this is a bit what we are looking for in terms of coordination, and all in order to mitigate challenges, of course. And going forward, we will really look forward to have more of these kind of collaborations. So back to you, Luca. Thank you.
Thank you, Andrea, and we're very happy to be one of the founding members of the Pacific E-Commerce Alliance. We look forward to cooperation. Dominique, I have to confess to you, I'm very happy to give the last word to UNCTAD. At the same time, by now, my scheme has become evident to everyone. They put as a timekeeper the one who was the least qualified for it, and we are the only panel that is way over time. But it was very interesting, at least for me. So my own goal was completely reached. But please, mindful of my difficult position. Thank you, Dominique.
Thank you so much, Luca. No, I think my fellow panelists have covered the emerging good practices quite well, so I won't repeat some of the important points. I think just the common theme, I mean, I think we heard it from all the panelists. It really comes down to coordination, 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 whether it's at the national level through national e-commerce committees, whether it's at the regional level with the works that the PIFS does, and whether it's at the international level through E-Trade for All and other initiatives. It's really just finding those synergies between each of our respective development programs. And I think my former colleague Sue from SCAP illustrated that quite well in the context of Timor-Leste. The great work that SCAP has carried out in Timor-Leste, UNCTAD is now picking up that baton, and we hope a year's time from now, when the country has a national e-commerce strategy with a clear roadmap, development partners and donors will step up and pick up the baton to support Timor-Leste with its e-commerce journey. And so that's the case with all the countries. I think we can all work together, find ways to coordinate better and maximize our impact. So I'll leave it at that as a concluding note, but just to thank UNCITRAL again for the opportunity to share these important points, and a special thanks to the organizers of the event. I think the logistics and connection details, communication was top-notch and excellent support received by the team. So just wanted to extend special thanks to them. Thank you very much, Luca, for the opportunity.
Thank you. Thank to you and to all of our speakers. I really appreciate this opportunity. We do not have many chances to discuss. We said coordination and avoiding duplication of efforts is one of the key ingredients for the success of this exercise. We try to do a little bit of that. I would close it here in order not to run too late. Thank you so much, and to be continued. Thank you.
Thank you, everyone. Thanks, Luca.
Thank you.
Thank you.
Thank you.
Thank you very much to our moderator and speakers for this fascinating roundtable discussion. At this point in time, we would like to invite our speakers to take a group photo together, actually. And with our virtual speakers, please turn on your cameras, and our in-person speakers approach the stage. Andrea, are you still with us? It's great, we can see you now. Okay. 1, 2, 3. One more. 1, 2, 3. Thank you. As the third Incheon Law and Business Forum draws to a close, I would like to firstly thank each of our esteemed speakers for sharing your knowledge and contributing to this event. Before I invite Ms. Athita Kominder to give a concluding remark, I understand that our secretary from the UNCITRAL, Ms. Anna Jobin-Brett, would like to take the floor for a few minutes. Anna, please.
Thank you very much, and sorry for intruding into the closing session and taking time away from my dear colleague Akita. But I just wanted to give you a bit of immediate feedback to this ILBF with one very concrete request to all of you and to all those who have participated online and those who have contributed to the quality of these exchanges during the 2 days. And this request is as follows. You all understand that UNCITRAL's role is to develop legislation to advance the agenda that you all have in the area of digital trade. This we do with the participation of states and state experts in our working groups. So our primary interest as UNCITRAL, as the UNCITRAL Secretariat, is to put together good legislation, good model text, good guidance texts, good conventions that you can then easily use. So currently we're working on, or we're going to begin work on, harmonized text on warehouse receipts. I've heard about warehouse receipts a couple of times during these 2 days. What we need is, in this working group for warehouse receipts, all of you who participate or who use or who build capacity or who are going to lobby the government agencies to make sure that we have good warehouse receipt texts as a model law that you can then use to have the latest technologically neutral but still electronic warehouse receipts to continue to develop international trade in your countries and trade finance. We're also working, as you've heard, on negotiable cargo, electronic cargo documents. So the same thing, we need in our working groups those that have a particular interest or that have a particular expertise from a region to contribute to this work. And so it's really, and also in data transactions, which is the topic that we're working on currently in our working group 4, we're working on developing default clauses on data contracting. Data is the fuel of artificial intelligence. If you want to develop your economy towards more AI friendliness and AI impact, you will need to have this ability to import and export data. Similarly, we're looking now into a sort of a restatement of all of UNCITRAL's texts on automated contracting, and we're going now into the machine contracting. So it's no longer electronic, but we also have to cater now for the machines that are being trained to be able to enter into contracts. So all of this requires, and this is, I would say, my plea beyond the technical assistance, the capacity building, the awareness building, and the promotion that my colleagues here in RCAP do so very efficiently, to also come back to our working groups with your expertise. Let us know when you find that there is a need, a particular need in a region. Chances are that the same need will be similarly there in other regions, and bring that to the UNCITRAL Commission with new proposals for legislative developments, and also to the UNCITRAL working groups. So that's really trying to make an event like this today a complete win-win, including for our legislative work, which is the core of UNCITRAL's mandate. So thank you very much. Over to you, Atita.
Thank you very much, Anna. So distinguished speakers and participants, 5 years ago in September 2019, the Incheon Law and Business Forum was inaugurated by the Ministry of Justice of the Republic of Korea, Incheon Metropolitan City, and the UNCITRAL Regional Center for Asia and the Pacific, right in the same conference room. Themed Challenges of Doing Business in the Digital Economy in Asia and the Pacific, the law and business regional experts participating in that dialogue focused on foundational initial questions like what could be done or what are we starting to do? And as Anna mentioned during her opening, how could we address legal fragmentation? As for the technology at the conference level, even transmitting a recorded presentation was really quite difficult, let alone remotely convening in real time. Fast forward to this year's ILBF and look at how the technology has changed. We have expert speakers and participants joining virtually from across the world with seamless interaction. We have simultaneous AI-generated subtitle translation streamed on secondary platforms. And in addition to our on-site participants, we have over 4,500 virtual viewers, the largest synchronous viewership of any ILBF iteration. Like the ILBF audience, the dialogue on the digital economy has advanced by leaps and bounds. A suite of legal and commercial solutions is now available for stakeholders to adopt and implement. As the Korean Deputy Justice Minister for Legal Affairs, Koo Sung-yup, communicated, there is a paradigm shift in digital trade, including digitization of trade-related documents that is legally enabled in the cross-border context by the work of UNCITRAL and in particular via the MLETR. Harmonization of digital trade regulations across borders remains key, as noted by ASEAN Deputy Secretary General Satvinder Singh, who urged stakeholders to consider swiftly raising awareness of and adopting the MLETR. The UNCITRAL Secretariat, including my office, the UNCITRAL Regional Center for Asia and the Pacific, located here in Incheon, stand ready to provide technical assistance and capacity building in this regard, partnering with other United Nations entities and international organizations in the region, including but not limited to the United Nations Economic and Social Commission for Asia and the Pacific, Asian Development Bank, the ICC Digital Standards Initiative, and others. Public and private sector stakeholders, please reach out to UNCITRAL RCAP anytime with questions or requests for potential collaborations. Could I have my 2 slides, please? These are the last 2 slides of the conference, I promise. So UNCITRAL RCAP also partners with universities and institutions of higher learning in the region every year to raise awareness on the benefits of legal harmonization and the work of UNCITRAL to law students, the next generation of legal thinkers and policymakers. This year's theme, fittingly, is exploring the digital frontiers of cross-border trade. UNCITRAL RCAP warmly welcomes expressions of interest from institutions interested in co-organizing an activity under the flagship UNCITRAL Asia Pacific Days 2023. So please scan the QR code if you are interested. Next slide, please. In addition, you are invited to take UNCITRAL's e-learning modules, details of which are available in the event chat box, with e-commerce modules forthcoming, and to participate in other UNCITRAL flagship events in the region as shown on your screen. Please do subscribe to the UNCITRAL RCAP mailing list for updates. Last but not least, on behalf of UNCITRAL RCAP, the Ministry of Justice of the Republic of Korea, and Incheon Metropolitan City, a final note of thanks to our wonderful supporting organizations, Incheon Tourism Organization, POSCO International, HKIAC, KTNet, PKU Law, and ICC DSI for making the 3rd Incheon Law and Business Forum possible. To our expert speakers and all forum participants, thank you for your invaluable contributions, questions, and comments. It's really been our honor to facilitate the sharing of experiences and insights from the Asia Pacific and beyond during these sessions. A final note of thanks to my colleagues, Anna, Jay, and of course the ILBF architect, Luca, for joining us in person from UNCITRAL headquarters in Vienna, and the top-notch staff and interns at RCAP, Hangil, Tracy, Taeyeon, Ginny, Senia, CNG, Simon, Sekwang, Dina, and Yao Yu, for your relentless efforts and around-the-clock support. So I hope everyone can sleep well now. So this concludes the ILBF public conference sessions, and invite those here to stay on for refreshments. Thank you again for joining the ILBF these 2 days, and for government officials participating in the regional workshop that starts in about 15 minutes, thank you for your patience. Please switch platforms using the link already provided to you. And for those participating government officials already here, we will convene in this room after the coffee break in about 15 minutes. Thank you.
So again, good afternoon. Thank you for joining us. This is actually the, I would say, the add-on to our public event. This is the private closed door segment. We wanted to give an opportunity to selected stakeholders to have a moment to share some considerations and to discuss a little bit more. We just had this roundtable on technical assistance. There were very clear messages on the need to have a champion, the need to find partners, to coordinate, avoid the duplication of efforts. I think there was consensus on all of these things, and now we want to start implementing that. And we could not have, of course, all the people we had online, but we are very grateful here to have, on the one hand, a few IGOs and one NGO, our closest partners. And on the other hand, I very much thank you, our colleagues who came from afar, took time off from a very busy schedule to come from Thailand, from Malaysia, from the Philippines, from Laos, from Cambodia, and to discuss. All countries here from Southeast Asia, we have also, and I thank them also, colleagues from Japan online who will share some important information. It's an extremely informal meeting. We just want to have an opportunity to share ideas in a manner that is completely free, to better understand how we can help each other and to leverage. I liked yesterday in particular, there was one speaker, Chemi Kim, who said, we have in trade facilitation, we have a tragedy of the commons. So individually, it's very difficult, but jointly, we have a snowball effect on the benefits. And so we have to move jointly. But our program now sees a few words of welcome from the three co-organizers of this informal workshop, that is to say, first the Secretary of UNCITRAL, Anna Juben-Barrett, and then, of course, UNSCAP, Soo-Yeon Kim, and Asian Development Bank, Nigel Chin. Anna, please.
Thank you very much, Luca, and I'm not going to spend too much time talking and introducing, because what we really want very much at this stage is to hear back from you. We are, as I mentioned, very interested in hearing what you are facing on the ground where there are needs at your end, and not only of awareness or capacity building, but also of legislative support that you may need. And this is really what we want to exchange very informally with you and with our colleagues here in RCAP, to make sure that we continue to fulfill the needs and the expectations that are put on the UNCITRAL Secretariat, namely to harmonize, but also to modernize international trade law. So we are really reaching now the stage where the harmonization work on the more traditional areas of international trade have been achieved or are being achieved, but we also have to be forward-looking and to look at what needs to be modernized, what needs to change, what needs to be updated, what needs to cater for the new forms of doing business. So we're looking forward to very much to hearing back from you and to exchanging with you and with our dear friends, colleagues, and partners, be it at the UNSCAP, with which we're working very closely, be it at the ADB, at the ICC, at the ASEAN Secretariat, with which we're beginning a journey, hopefully. And so over to you and to a rich discussion. It's really about you giving us feedback. Thank you.
Thank you very much. I think Anna said it all, but let me just briefly add the ESCA perspective. So as you would know, we are the regional commission, regional arm of the UN Secretariat in Asia Pacific countries. So we've got 53 member states and associate members. And we have been really collaborating closely with sub-regional and regional bodies. Quite recently, we have been solidifying our collaborations with ASEAN Secretariat and ASEAN countries in general. So in the trade facilitation arena, we have been utilizing the collaborative mechanisms for the UN Global Survey on Digital and Sustainable Trade Facilitation. We actually have the ASEAN report, the first one published even before the global and regional one, because we wanted to utilize that report as the basis for the discussions at the ASEAN Economic Ministers meeting. So we, as the regional arm of the UN Secretariat, cannot do it by ourselves. We really, as Anna said and stressed, we are looking forward to hearing from all the member states, as well as our dear partners. So thank you very much.
Nigel?
Sure. Thank you, Luca. I really don't have much to add from what Anna and Suhyun have just said. I'm very interested to hear the feedback and the needs of the participants in the room with you today. I would, from the earliest, but I'd just like to say, from the earlier session, as you mentioned, Luke, I think it was as interesting for me as it was for the participants, learning about all of the other work that, I of course knew of some of the work that fellow institutions are doing in this space, but not all of it. So that was very interesting for me. And so I wonder, they would have heard that the participants would have heard of the things that we need from them, the champions partnership. But I'm wondering if there could be more collaboration and cooperation amongst the international institutions and others in order to deliver the assistance that our countries need. So I'd be very interested, perhaps, in continuing a discussion later on that aspect, so that we can tailor solutions for the issues that we may be presented with. Because as I think Milot from EBRD was saying, in general, we fund these initiatives through TA resources, which are becoming more scarce as we go along, and they're either funded internally or through the donor funds, and there is increasing demand on those funds. So we need to learn amongst ourselves as enabling institutions to better coordinate the use of those resources to best serve our member countries. So thank you.
Thank you very much, Nigel. Now, if I'm not mistaken, I think that we have a colleague from Japan. If we can connect him, who will also share some information and a presentation.
We're not kicking you out, Nigel. Huh? Stay put. Stay put.
Until the end. Nigel, are you in Manila?
I'm in New Zealand at the moment,
Are you
Luca.
in New Zealand?
Yes.
Yeah. So we are mindful of time zone as well.
No, it's okay.
Yes, hello? We see you.
Hi. Can you hear me?
Yes, we hear you. Thank you. Welcome. Thank you for joining us.
Thank you for inviting us to this event.
Please go ahead.
I'm sorry, I'm not familiar with this kind of
Take your time.
thing.
Take all the time you need. It's a very relaxed, informal meeting. Don't worry.
Thank you. And can I start my presentation here or later? I don't know the logistics well.
As you prefer, or we can show your presentation from here, I believe, if you prefer.
or later?
Or later, as you like.
I prefer later.
Okay, very good. So if you want, we get back the floor and we give it back to you a bit later. Yes?
Thank you.
Perfect. Thank you so much. So now I really open to the informal discussion. First of all, I would like to stress two things. The golden rule of cooperation is everything takes place at the request of the recipient. That's just anything I may say might be misunderstood. No, it has to be read in both in that light. And also, we want to have a very informal discussion, but we don't want anyone to feel obliged to share information or, you know, to speak because there is a pressure to speak. There is no pressure to speak. The main topic of these 2 days was support to trade digitization. Now we call digital transformation in trade. First of all, I have to say, why Southeast Asia? First of all, we have the ASEAN Secretariat. Thank you. And there is the Digital Economy Framework Agreement coming up. Now, our colleagues said many times, without prejudice on further discussions, you know, but it's happening. And in order to negotiate this kind of document, one has to have the capacity. In order to, some countries have a lot of capacity, some countries have some capacity, some countries have little capacity. So maybe this is also a way to build a bit of that capacity. And then we already had some, of course, bilateral interactions. And I think it would be very useful to start, I'm calling upon someone, but it would be very useful to start by sharing the experience of Thailand. Why Thailand? Because we at UNCITRAL have been working on digital trade with Thailand for at least 10 years, from the times when I was here in this regional center. And Suyon is working closely with Thailand because it's the host country of UNESCAP, so knows a lot of Thai stakeholders. And to get back to what the Secretary of UNCITRAL said before, Thailand is a country that comes regularly to the working group meetings. It's not the only country that does so. And there is this interaction, and therefore I would say there is useful exchange of know-how in between the delegates to the working group and the law reform process. So Thailand, like all the states that are here from Southeast Asia, Thailand has adopted the model law on electronic commerce. It went a little bit beyond because it has revised an Electronic Transactions Act and incorporated the substantive provisions of the Electronic Communications Convention. But it's not the only one. Vietnam did the same, for instance. Australia did the same, to mention one. It's not here now. And then now there is something in the works. So if I can ask, we have microphones in the front, and maybe you can pass, but Choi, can I give you the floor? So, you know, we just want to know what you are doing and why, and what's going on with the convention, with the Electronic Communications Convention, with the MLETR, with the identity management, and so on and so forth.
Hello, hi everyone. My name is Choi. I'm from EDA, or Electronic Development Agency in Thailand, under the Ministry of the Digital Economy in Thailand. As Luca mentioned, now Thailand has the Electronic Transaction Act that based on the concept from the model law, electronic commerce, electronic signature, and the principle from the ECC convention that now we are on the process to think about how to ratify or succession to the ECC. We now on the process of public hearing about the ETA and the ECC that is comply to each other to confirm that. So we make the next step to the cabinet and the parliament to adopt the ECC with the UNCITRAL. This is the part that we already have. For now, we are currently the process of revise the Electronic Transaction Act. The main revise is based on to adopt adopt the new model law from UNCITRAL. One is the ETR, and second is the digital ID and trust service. And this draft is on the process of the Council State to review the draft, and I think the final draft may be see in the April in next year. Maybe we will see the final draft from the Council of State that have the ETR, digital ID, and trust service. But in the legal part, I think UNCITRAL already set the principle that we, I think, must comply for the harmonize between the country. But I think it's something that important, that is we have to set some standard or the guideline for provide the detail on the example of technique to adopt the UNCITRAL principle in the implementation in the when the user need to development the system or to the use of system. So Thailand is now on the process to develop the standard standard for adopt the principle from UNCITRAL, and we are looking forward for the cooperation from UNCITRAL, ASEAN country, and ABC or other partner to join with us to set this standard or the guideline together. Thank you, Luca.
Thank you. So I just want to reformulate to make sure that we understand correctly. We have two things going on. On the one hand, progress on the adoption of a treaty, the United Nations Convention on the use of electronic communications in international contracts called ECC, which has 18 state parties, the majority of them in Asia and the Pacific. And two of them are actually in ASEAN, Singapore and the Philippines. And so we may get to 3 if Thailand completes the process. There was a public consultation on that, which was positive, but a treaty has to go through Parliament. So that's the parliamentary process there. And congratulations. I know Vietnam, for instance, had a comprehensive study to do the same some time ago. And this Electronic Communications Convention is referenced in RCEP, among other. It's referenced in CPTPP, it's referenced in RCEP, so it can be also one building block for the Digital Economy Framework Agreement. Now, why a treaty? Because a treaty is more binding than a model law as a legislative text. So the treaty creates more certainty in the law applicable to the electronic transaction. But this is a treaty that applies only business to business, so it's limited in scope, but it's useful from the other perspective, from, for instance, commercial arbitration perspective, sale of goods perspective. because there are some form requirements that cannot easily be solved in light of the provisions of both treaties. So I don't want to now open a discussion on why that treaty is useful, but I would like to say it is useful to set a core of common rules for B2B exchanges across borders. And that's one thing. And that's where UNCITRAL has provided some support, limited support, but we tried to do what we could. And we are happy to continue doing that, of course. Like we did work with the Philippines, and we are now continuing to do that work with the Philippines on implementation. And one thing which is in that treaty, which is very, very much discussed, is cross-border recognition of electronic signatures. You have cross-border recognition of electronic signatures in that treaty. So B2B, but very flexible, very flexible. And the other issue is the consideration of the adoption of our model law on electronic transfer records, or MLETR. Now we had, if you remember yesterday, we opened it actually with the Thai Bank Association telling us what was the business case behind their demand for adopting the MLETR. And ETDA, which is, now it means two things in our space. ETDA means the Electronic Transactions Development Agency in Thailand. But ETDA means also the Electronic Trade Documents Act in the UK. So we have to say ETDA 1 and ETDA 2. I already hear ETDA confusion going on here. So ETDA, Asian ETDA, Thai ETDA, is the agency that is actually in charge of administering the Electronic Transactions Act. And because this Electronic Transactions Act already incorporates the UNCITRAL model law on electronic commerce and the substantive provisions of the Electronic Communications Convention, ETDA here is the champion that took upon itself to say, let's have MLETR in Thailand, because we had a business request. And there was a draft, and now the question is to go through the public consultation, to get support for the public consultation. But also, and this is a very big question, to get guidance on the technical standards that need to be used to have reliable systems, if I understand correctly. And here, this issue of the reliability, because UNCITRAL always talks about reliable methods. And maybe you caught it, maybe not, but the only person, in my opinion, who really went into this was Marina, the one who spoke from ICE-Trade, who had a slide and said, you know what, these requirements are such that you cannot be in this business and not meet these requirements. She said like that. She said, if you've been in this business for a bit, you are already meeting these requirements. But then, of course, and we have here Kay, the white paper is also trying to address that. So if you read that white paper, you will find some elements to go forward. What is not there is a set, there is actually, Tianmi, ICC-DSI put together the list of the standards relevant for the implementation of the MLETR, which is a long list. So I cannot say that we don't know which standards apply, because we know. Hannah drafted the list. Anna is the colleague of Tianmi at ICC-DSI. But there is no certification. There is not yet someone who comes and says, if you do this, then I give you accreditation, something like that. There is not. And according to some people, there should not be, because it's difficult then to have it cross borders. So that's the question. Now, this is where we are, and I think it's interesting. So we have elements. We have business interest. We have a champion, which is the ETDA 1. We have a bill, because the bill has been drafted. The bill will come back from the Council of State, or wherever it is, in April. And it will go for public consultation. And we need to have support on implementation and capacity building on implementation. This is an open call. I don't know. We have to ask those who can help. Tell me the list of standards. What can we do to help with that? Grab a mic if you want to say something. We have a self-help system. What can we do?
Digital standards, I think we're still in the, I wouldn't say that there's a one standard that is going to be recommend, well, like right now, at least there's not one single standard that we're going to set, we're going to do this. Because just because the availability of standards that are out there, there's only going to narrow down to a few. And then what happens after that is still to be determined. That is still in the work process. As I said just now, we have two vehicles. One is the Legal Reform Advisory Board, and the other one is the Industry Advisory Board. And that is engaging private sector to mobilize them to actually do the standard adoption and harmonization. But I'm happy to connect you guys with that arm of DSI. But right now, we're still in the process, as I hear, to determine whether we should work with ISO.
Which is an important thing.
But it's also a major decision. Just because we're pushing it doesn't mean the industry is accepting it. And as you know, we don't want to create a new standard. We want to choose from the already existing one. That we shouldn't reinvent the wheel, right? But how many of the private sector, or how much of it would actually support the one that we do? You need a majority consent to make this like a guiding standard.
So this is an interesting answer. The answer is, let's talk about standards, because maybe it's not a very good thing to have ISO stepping in and giving very rigid guidelines. We want to keep some flexibility. But at the same time, we need to help countries in finding out which are the relevant standards.
Before we go into what you said, I think what is confirmed right now, what has been published on the DSI website, is a list of key trade documents. And we have identified common data that is existing in all these documents. There are 7 of them, and you can find them in a very extensive report to, these are the replication or duplicated data that's been communicated between documents, but maybe in different format. So to save time and energy and really resource, you find the commonality and really, I guess, execute what Lucas, this forum's topic, from document to data. You stop thinking about these documents as paper or with, constrained with edges, but rather a pile of data to be transmitted. And those have been identified. And I can drop a link to the group in the paper. It's called the KTDDE abbreviation. And then you will see how the 7 key trade documents, and it's actually an analysis of identifying all of those that are common. It's a good visual to show that as well. But I think now that we just need to determine, we have identified the common denominators, but which ones should be the required ones in the future?
Nigel, if our friend Chloe wants to get support from ADB, should she write an email to gofundme@adb.org, or do you have other ways of discussing that? I say Ploy or any other one in the room.
Sure. I mean, I think if they're interested in accessing ADB resources for these kind of initiatives, that they should in the first instance reach out to the relevant country office. Reach out to the ADB representative that they're in contact with in country, who will then be the contact point for them, and then they would contact us. That would be the protocol, and then we would be looking together to see what funding sources would be available in order to provide assistance.
I honestly, I don't remember, and I don't know actually if there is like a limit or something, but I think that currently ADB under this program is onboarding a couple of countries a year.
I guess we're constrained by both capacity of the team members for the project as well as funding. So we've managed to onboard 2 thus far, with a 3rd in the pipeline that I mentioned in the previous session, that being Cambodia. So we've allocated both the time commitment and the funding for that, and that's why it's very difficult for us. We would have to analyze very carefully any further applications for funding to find that and to be able to commit the resources that is necessary to do this properly.
By all means, I thought for a split second I saw a slide from you with the countries and dates where ADB started being active. But when it turned out that my colleagues said no, but I think I saw it before, not now during the roundtable.
It was my slide. It was the last slide that I didn't want to show because Nigel's there. It was only there if Nigel didn't talk about it, but of course he would talk about it.
Now I don't know if that slide is correct.
No longer.
Factually.
No, it's Nigel. It's the one that ADB did for the capacity building, where the projected launch date for the 4 countries, I think Q4 2022 for China, and then Cambodia and Vietnam. They're both in 2023, which means like it's probably going to push back for at least 2 or 3 quarters.
They have been pushed back. Obviously, we have been engaging with Georgia and the PRC most recently in the event that you participated a few weeks ago. Vietnam is not progressing at this point of time, but so that slide is now out of date. But there's no, I guess, in answer to your question, Luca, at this point there's no, we don't. Because of our capacity constraints, it's not that we allocate 2 countries every year for the next 3 years. That's not the plan at this point in time. So we just have to be very careful with the allocation of the time and at the financial resources that are available.
Well, we all have to.
Yeah.
We all have to. But let's say there are programs going on, one in Georgia, one in China. And I want to say this because it's important also to understand how these things may happen. Because these things may happen in different ways. So in the case of Thailand, this is something that came from the fact that the Thai government, I mean selected agencies in the Thai government, had a certain familiarity with UNCITRAL, and the private sector had an interest for a certain type of law reform. We have said several times, we have mentioned Cambodia. In Cambodia, the things are not exactly like that. And we have here a colleague from Cambodia, from the Ministry of Commerce, actually, a fellow lawyer, which makes it easier for lawyers to talk to lawyers, but it doesn't make it easier for non-lawyers. But nevertheless, and I don't know, Nigel, what you can or cannot say on the way Cambodia came to your radar screen, but not so much to focus on Cambodia, but also to share how this can happen in a different way. You know what I mean?
Yeah, I mean, I think there's a limit to what I can say in this forum about that. I think that that engagement with Cambodia was also conducted through our country office and the offices that are responsible for Cambodia, to include in some of their country programming, as well as a commitment to look at Melita adoption. So that has been something that has been in the works, I think, even before I joined this program, actually. So that has had quite a reasonably long gestation period. And there were times that I think that perhaps we didn't feel the interest, but I think that there's now some momentum there, so that we're picking that up again. So like I say, I applaud Thailand's efforts thus far with their program, and with the draft bill. It's something that we could look at. I guess there's no, as we were saying earlier in the previous session, there's no one way to implement these programs, and I guess there's in part of that, there's no one way that these projects within the different DMCs come about. So you know, in the case of Thailand, where they've done a lot of the work already, and they're at a very sophisticated, very advanced stage, at least compared to the other countries that we're dealing with. You know, this is something that we can look at, but you know, I can't, whether it's ADB funding by itself or ADB co-partnering with someone, another institution to fund. All I can say is something we can look at.
Of course. But that goes without saying. We all have processes and procedures in place, especially when it comes to approving disbursement of money. Now, the aspect that actually I wanted to highlight, which I believe is true for Cambodia, and it will be true in many other cases. The focal point in the Cambodian government for ADB is in the Ministry of Finance, I believe.
Yes, that's right. And
therefore, if, you know, our colleague goes back to Phnom Penh and says, listen, we have this opportunity, it's a very good opportunity. But, and there's already been a lot of talk, and here ADB and our government have made progress, but we need to find out, not only from, in this case, I would say not primarily from the ADB country focal point, but from the Cambodian government ADB focal point, because that would be the one who is coordinating the activities. And so one would have to go to the Minister of Finance and say, hey, we heard about this. And actually, because I know for a fact, because we worked a lot with ESCAP in Cambodia, and actually we supported the adoption of the electronic transactions. It's called the Electronic Commerce Law. Yeah. The Minister of Commerce, I think it was the Vice Minister who was coming to our meeting. The Secretary, the Permanent Secretary was coming, the Permanent Secretary of the Ministry was coming to our meetings. So we had an ongoing relationship for several years, and we had this law successfully adopted, and I would say very much in compliance with UNCITRAL text as far as we are concerned. And so also, this is a practical example of how things work in reality. So from our side, we know that if we want to add MLETR to the e-commerce law, we have to go through the Ministry of Commerce. And so now here we have an opportunity, because there was a decision between ADB and the government of Cambodia that MLETR is a point of common interest. But then the relevant line ministry is not the focal point. So we have to ask to our Cambodian colleagues to go back and sort out between themselves so that they can come back to us and say, good, we are good to start. Let's see what kind of activities can be done. So there is that element of coordination in this case, because the activity comes from a different institutional perspective. In the case of Thailand, we don't have that element of coordination because the initiator of the request is already the line agency. So it works a little bit different. And this is just, to share some information for common consideration on how these things need to be a bit streamlined. And I actually don't remember, and I don't know if it is useful, maybe not, to mention the discussions you had with Vietnam, but if there is nothing there to be said at the current time, we don't have to do that. We have a colleague from Vietnam here, actually.
Yeah, not at this point in time. Okay.
Yeah, that's fine. Yeah. And we have been working actually with, this is actually, she's from the line agency, IDEA is called, under the Ministry of Trade, and we did work together before. So this is yeah, please.
I think that was a good important point that you made about that practicalities of the liaison with focal points with various stakeholders. And I think in the Cambodia example, as our contact is with the Ministry of Finance, but of course now you've introduced us. Sorry, I can't remember. We at least know you can introduce us to the representative from Cambodia that's in attendance today, and then we can also introduce him to the relevant focal points, so we can try and short circuit some of that protocol, or at least kind of preempt some of the interaction that's going to need to happen.
Yeah, and of course, and these are purely administrative issues that can end up in wasting months, if not years, while trying to find coordination. So it's better to make things clear at the onset, so that one says, yes, it's all there, but one has to coordinate from the other side. Now, I don't know if now we can get back to our colleague in Japan, maybe? Is she ready? We see you again.
Sorry for the confusion I made previously.
Not at all, not at all. I have a lot of challenges. We always change platform, and it's Zoom, and it's Teams, and it's WebEx, and it's for something else. And especially I don't want to say anything about Teams. Please go ahead.
Sorry. I'd like to introduce ourselves.
Please.
We are from Ministry of Justice, Japan, and we are 3 of us here. I think this delay or
go ahead, say everything you want to say and go ahead.
Okay. And we prepared our presentation to give for this workshop. And is this the right time to give you my presentation?
We see the slide. Please go ahead.
Okay, then I start here. Sorry. Again, and I like to introduce our project, and we are now trying to achieve digitalization of some specific kinds of transferable documents, and mainly bills of lading, through amending commercial code in Japan. And sorry, in the next few minutes, I like to talk about our project in here. Thank you. First, I'd like to give you some basic background information about our projects. The provisions for bills of lading in Japan's commercial code are based on the assumption that they are in paper form. But since MLETR was adopted in 2017, with regard to trade-related documents, the trend toward digitalization has become more pronounced, and Japanese government recognizes that the digitalization of bills of lading is a pressing issue. In February 2022, the Minister of Justice consulted the Legislative Council, which is the advisory body to the minister, to deliberate on reviewing the provisions of bills of lading in the commercial code. And in response, the subcommittee of Legislative Council has started deliberations on digitalization of bills of lading. The interim proposal was published by the subcommittee in March 2023, and public consultation procedure was conducted until May. We've received many positive comments through the procedure, which shows that there is a high level of interest in this topic. Currently, further deliberations are underway based on the comments received through the procedure. Please go on to the next slide. Thank you. And now I'm going to talk about what the subcommittee is discussing now. And please keep in mind that we are still in the middle of discussion. So what I'm talking today here is not final. And after the discussion by the subcommittee, there will be several procedures for the bill to be official. In this project, our basic policy is to follow fundamental principles of MLETR, such as functional equivalence, technology neutrality, and non-discrimination against the use of electronic means. As I mentioned, as I mentioned earlier, what we are trying to do is not to legislate new law for all kinds of transferable documents, but to amend the commercial code to digitalize specific kinds of transferable documents, such as bills of lading. Please go to the next slide, please. A major challenge is how to incorporate the MLETR concepts while retaining consistency with Japanese legislative system. For example, singularity, control, or transfer of control are unprecedented concepts in Japanese legislation. So how to define those concepts in Japanese are the most challenging. Please go to the next slide. Thank you. And regarding singularity, it's necessary to identify which electronic record is the record that should be legally treated as an EBL. Please go to the next slide. Unlike paper, electronic record can be copied easily and identical copies can exist. So following MLETR, we are thinking to require EBL system to use a reliable method to identify that electronic record as the EBL. Please, yes, thank you. In addition, electronic record can be easily altered, and it may be difficult to detect if the record has been changed. To improve the security of EBL, we could require electronic signature of carrier on EBL and EBL system to record any changes. Please go to the next slide. Thank you. As for the next concept of control, since the legal term possession in Japanese can only be used for tangible things, we cannot use possession for electronic records. So we need to introduce an alternative Japanese term that can appropriately describe the concept of control in MLETR. It's also pointed out that the use of the word control without a description would be too ambiguous to apply it to actual cases. Therefore, we are now looking for a way to give the word a clear legal description while retaining the core concept of control in MLETR. Please go to the next slide. Thank you. At the same time, we are discussing how to define transfer of control. We need to legally define transfer in a way that a person who receives the transfer of control keeps exclusive control of EBL. Also, we are discussing to introduce the concept of electronic endorsement following MLETR. Please go to the next slide. Aside from those issues, we are also discussing how to achieve functional equivalence between EBL and paper BL. We assume that the information to be included in the EBL is largely the same as in the paper BL, but under the current commercial code, issuing multiple bills of lading is allowed, and in such a case, that information must be included in bills of lading. On the other hand, regarding EBL, we are now considering not allowing multiple original EBLs to be issued. This is because allowing multiple issuance would raise some complicated legal issues, particularly regarding the singularity requirement. As for the legal effects of EBL, we will recognize the same legal effects as paper bills of lading in order to achieve functional equivalence. However, it has been discussed that provision stating only that an electronic bill of lading has the same effect as a paper bill of lading would be too broad and open to interpretation. So to avoid ambiguity in interpretation, we think it will be necessary to clarify in explicit terms how the legal provisions for paper BL would apply to EBL. Thank you. Lastly, we'd like to introduce 3 other issues under discussion. First, we think that the new commercial code needs provisions about conversion between paper bills of lading and EBL. We are now discussing if we grant shipper the right to convert EBL to paper BL, and this is the most controversial issue. Some argue that once EBL has been issued by agreement of both parties, conversion to paper BL should be allowed only when both parties agree to the conversion. Others say that allowing shippers to convert would promote the use of EBL, given the fact that some countries do not yet allow the use of EBL at customs. The second issue is how enforcement systems should be established in situations where EBL are used. While enforcement systems are in place for tangible things, they may not be applicable for EBL, especially when blockchain technology is used. Third, we also consider digitalizing warehouse receipts and negotiable multimodal transport documents, which are also transferable documents on the commercial code. Please go to the next slide. Thank you. To sum up, our goal in this project is to follow MLETR as much as possible. While achieving functional equivalence and technology neutrality, we are trying to amend the code in a way that is consistent not only with MLETR, but also with the domestic legal system. This is a new and challenging attempt in our legal system. And I'd like to conclude my presentation here. Thank you for your kind attention.
Thank you very much. It was very well heard and received. I actually had a question, but I think someone else has a question before me. So if you don't mind, Tianmi has a question.
Hello, thank you for the presentation. I have a very simple question. When you said you guys changed a term to replace control, what did you guys use?
We like to use control in Japanese, but it's a unprecedented concept. So there's a discussion about which Japanese words to be used. So it's we haven't decided yet, but we'd like to introduce the concept of control.
Would that be? It will be something that's existing in the Japanese legal system already, right? It wouldn't be a made-up word just to fit the digital age.
We don't know. We don't have exact word for control in Japanese yet in our legal system, and we are now thinking which Japanese word is the most suitable word to explain the concept of control. Does that make sense?
Okay, thank you.
But we have another question. Tianmi, can you pass the microphone to the back, please? Thank you very much.
Okay, thank you. Thank you very much for your presentation. This is Satoru Someya from Trade Worlds Inc. Thank you very much for your support to make the registration in Japan. And the terminology of Japanese is a little bit difficult to define the EBL's image in the government's role, the 管理する or 拘束する or something it is mentioned as a control in Japanese language cannot figure out what the non-fungible asset or something's control. 拘束する means a very holding physical image is having. So the government laws image should be create some new words or the combination word will be needed to handle the EBL's image together. But I will go back to Japan tonight to Tokyo. So we would like to have the conversation to find the best word to describe those kinds of the control or the singularity or those kinds of the cyber areas controlling image in the Japanese language together. That is a supportive comment from Japan. Yeah.
Thank you.
I do have a question for both of you. Now, Japan, I'm very, very happy that Japan is considering adoption of MLETR for one or some documents. It's actually the first time Japan is adopting an UNCITRAL text in this field. It has adopted in arbitration, in sale of goods. But because bills of lading are necessarily used cross-border, and one thing that we learned from our Korean colleagues during this event, they said several times, we have had legislation for some 20 years on electronic bills of lading, but our legislation doesn't work because it's under Korean law, it's a Korean registry, it forces companies to change their business practices, and you know, most of bills of lading are not issued under Korean law or under Japanese law. Most bills of lading are issued under English law or US law. So this makes a difference. So there is a cross-border element. And the Ministry of Justice of Japan is one of the few ministries of justice that has a specific office for international cooperation. I know this office used to be in Osaka. I don't know if it's still in Osaka or it went to Tokyo. But there is a specific office in the Ministry of Justice for international cooperation and technical assistance. So once this is maybe has made even further progress, would it be possible to envisage a direct or indirect, when I say direct from the Ministry of Justice or indirect support, indirect would be from JICA or someone like that, but I would prefer direct because there is legal expertise, to help countries that are commercial partners of Japan to get on board on MLETR. Is this something possible? Is this something that can also support, mutually support trade wars maybe, in a way? You know, is this possible in theory? Or am I just making a proposal that maybe you can think about it and come back to us? Not now.
Yeah, I like to say yes, but I'm not in charge of saying that.
But we can look into it.
Yeah, I understand.
Because to me, you know, this is very, very rare. But this piece of legislation is successful only if it is open to cross-border exchanges. Most of legislation is for domestic consumption, but this one, no. So to me, if we want to get that critical mass that allows us to really achieve our goals, we have to think about it. Like, and I say this because in UNCITRAL, most of our work is legislative drafting. But me, because I like technical assistance, I say, when we draft a text, we have already to think how to implement it, how to promote it, how to implement it. Because otherwise, it takes us 3 years or 5 years to draft something, and then we look at each other and we say, and now what do we do for its promotion? And it's not efficient. So, you know, I'm offering this to you, and please think about it. And maybe we can continue the discussion another day. But maybe this is something that can be useful because Japanese MOJ has this facility. But thank you. Thank you for listening to my suggestion.
Thank you so much. I'll think about it.
Can I add one last comment?
Please.
Hi, it's me again from International Chamber of Commerce, Digital Standards Initiative. We've been working with ICC Japan as well, trying to promote this. And also we've talked with METI, Ministry of Economic Trade and Industry. Both of them have expressed the business interest of it. And I know that when it comes to implementation after the law has been revised or added, the amendment has been in place. Japan usually is pretty quick in landing those legislations in corporations. So we would like to be considered partner or corridors if you're considering pilot programs, whoever that you feel like when it comes to that stage. We would like to provide assistance too during the whatever it is going on now, like, consultation or discussion, but as I understand, it's a quite internal process that it is not going to open to a party external to MOJ. So we have networks in Japan that we would really like to work with, especially when you say that your goal is to follow the MOETR as close as possible. Other Asian countries may also have that wish, which means that on the legal front, that is aligned. So let us know what we can do, and I will shoot you an email. Yeah, thank you.
Thank you.
Yep. Discussion continues, please.
Thank you. Just add the comment, the ICC DSI's former managing director, Oswald-san, is also asked us to support, to introduce the MLETR's created persons in a New York office of the UNCITRAL, and there are so many supportive comment is coming. So we, Japan, will making the conversation with the Ministry of Justice in Japan to make some open door to the international society to support the drafting up and solving the problem in the making the sentences or the changing the sentences of the commercial law in Japan. And adding to that kind of the supportive, we need to consider about the language point, because in English area, maybe we can get so many insight from the other countries, but when we need to write down the sentences in the Japanese government law, we need to care about the Japanese language. So that point, we need to figure out together from the corporate or the private side, and also the public sector's Ministry of Justice. But to collaboration, the support from the international society, and also the discussion in domestic, the Japanese language people, we can solve generally to the goal to change our government's role in a very smart style, I think. Yeah, thank you very much.
Thank you. I would like to say I have three takeaways from this discussion for everyone. The first one is the need to consider dissemination of awareness and capacity building already during the consideration of the law, which applies to everyone. We need to inform the private sector that a law is being discussed and is being adopted. The second is, thanks to ICC DSI, and not only, private sector is always there. In some countries we have more engagement of private sector. We were discussing before in Thailand, the process started from the private sector. In other countries we have less. The private sector is always there. And at the end of the day, these laws are passed for the private sector. So it's better to have them. The third, which is a huge issue, which we never discuss in UNCITRAL because it's not immediately inside, it's next to us, is the language issue. And we have to make sure that we have enough resources. Like in Thailand, the bill was drafted in Thai by the line ministry. In Japan, this is being done in Japanese by the Ministry of Justice. But in some countries, we have to be careful, and we need to have some resources also for translation and keep consistency with existing terminology if there is already an Electronic Transactions Act. And in some languages it is difficult. I personally took care of the Electronic Transactions Act of the Maldives, and the local language is not a language where it's very easy to describe the different nuances of electronic and digital signatures, because the language, Diwali, is, it's a language that deals with other things. There's a famous story about so many words in the Inuit language of the Eskimos to describe the snow, because they see a lot of snow, but each language is specialized in a certain way and not in another way. Now, I am mindful that after today's, yes, Kay, I would really want to hear from you. Please.
Testing. Oh, sorry, just a question from me, actually. I'd like to find out whether Article 19, non-discrimination of foreign electronic transferable records, is going to be adopted in Japan as well?
Isn't it a bit too early to ask? I don't know, we can ask, but I mean, I find it too early. Do you have already, I mean, I saw there is a draft available online in English, and I didn't see Article 19, but please, I pass on.
I don't think so. We like to follow MLETR as much as possible. So we'll have the we want to have the article following Article 19, but we haven't decided yet.
Oh, okay, great. Thank you for clarifying. Actually, the reason why I asked this, actually two reasons. Number one, coming from an industry practitioner's perspective. And actually, number two was what Luca said, that this really is for cross-border usage. And therefore, yeah, from that perspective, Article 19, non-discrimination of foreign electronic transferable records, takes on some importance. But thank you. Yeah, thanks for answering the question.
So what I was saying is, as we are winding down, I wanted just to mention one thing. The regional center, UNCITRAL Regional Center for Asia and the Pacific, sometimes is officially a development partner of the United Nations in certain countries. So you can approach us also through that. This is the case in particular in Laos. So when things happen in Laos, we should be able to see them if they come, because every country has a UN coordination, and all the UN bodies are sitting there. Because we are very small, we sit only in a handful of those, and we can be resident, non-resident. In that case, we are non-resident, but we sit there. So that being said, I would really like to ask if there is anything left to be covered, a last call before we close this meeting. Nigel, are you still there with us? Do you have anything to say?
Nothing further from me, Luca, but thank you for inviting me along. It's been really interesting.
Thank you. Any question? We are ahead of our schedule, but we don't have to use all the time we have. I think we discussed this already. If there's any question here, or or immediately after, please raise your hand. If not, I think that we can close it possibly. Suyeon, any last words? Who's coming next to the framework agreement? Which is the next country joining?
With Russian Federation joining very soon, we are a bit.
No, that already happened. The next one.
We have several pursuing the domestic processes, but it's always hard to tell. Sometimes we get nice surprises, sometimes we get the bad surprises. So okay. I just keep that here.
But of the countries here today, the Philippines are a party to that agreement.
Yes.
And the others are not yet. So, yeah. Atita, final words?
Nothing much, just to say thank you. Thank you to our online participants, especially from Ministry of Justice of Japan. I know you might feel some disconnect because you're not in the room, so we tried to put in the chat who was speaking when. Thank you. So I think that's basically it. I don't know if any of our other delegates who haven't spoken yet would like to say anything. Malaysia, Cambodia, Laos, no? Okay.
Perfect. So
Alright.
that's it for now. To be continued another day, another time, another venue. But thank you so much for staying with us another hour and a half. We always take a picture. So please, also you two online, please stay online, and all those who are here, we go and take the picture because everything will be documented. Thank you.
Japanese colleagues and Nigel, so we're going to pull you up on the big screen and we'll stand in front of you. Okay, thank you for bearing with us. Thank you, online colleagues. You can get in touch with us via the email that we had sent prior to the workshop. So thank you so much. We'll say goodbye to you now. Thank you, Japanese colleagues and Nigel. Thank you.
Thank you.
Okay.
Bye.
Bye. Have a nice evening. Bye.